Hi guys, in this video I am going to help you boost your preparation for CA Interlaw. Sir, what are we going to do, sir? Totally in CA Interlaw, we have only 15 chapters for the whole syllabus. I am going to help you prepare 5 chapters together with me in just 5 hours where we will discuss 125 plus questions from 2018 to 2024. Even if you are skipping this chapter, just watch these questions. The source of these questions are ICA past exam, RTP, MTP from this time range. And I can guarantee you that from these 125 questions in these 5 hours in these 5 chapters, we can easily expect 25 plus marks in exam. What are those chapters, guys? Foreign Company, Meetings, Deposit, LLP Act and General Clause Act. It's going to be in rapid speed. Already it's going to be in full speed in these 5 hours where we'll quickly be discussing. You can also increase that speed by making it 1.25, 1.5. Watch it together at 5 hours or watch in parts. Timestamp also is available. This is nothing but we had a batch called workout batch where we discuss only questions on popular demand. I'm releasing for these 5 chapters so that you can quickly revise these 5 chapters in the next 1.5 day or 1 day, how much ever time is left. All the best, guys. Keep watching. Discuss whatever you want in the comments and I will definitely reply to it. Enjoy in the next 5 hours. Hi guys, welcome back to workout batch. Now we are going to do last chapter, at least in our order, foreign company new edition. Very important until it is trending. So for the next few attempts in 2025 exams, it is important until they finish asking all the questions and exhaust. When it comes to foreign company alone, we don't have a lot of source of questions because foreign company is newly added in CA Inter. So for workout, what I have done for foreign company, right from 2018 to 2024, I have picked up questions from CA final. Why? Because in CA final, foreign company, whatever syllabus is there, same thing is brought into CA Inter. So we have picked those questions, accumulated about 25 of those questions. For foreign company, we have our material, just the 5-side material from section 379 to 393. I would have told in the class also, only 5 concepts will come repetitively in exam. That is because in final it used to come like that. I will first showcase what those concepts are and then we will get into questions. So you will understand. If I am skipping foreign company, at least these 5 concepts I can learn and be smart. One is 379, applicability of this chapter to foreign companies. I would have told in our class for whom foreign company chapter is applicable. Then I would have also told electronic mode. Now what is it? One new notification came listing down what is electronic mode. This is one. Second set of question I would have told is 380. 380, whom we have to give once a foreign company enters India, within 30 days you have to register yourself and give FC1. This is one concept. Next I would have told accounts, I would have told this annual return and financial statements filing, that is number 3. Then all this is not that important. I would have told this prospectus is that 4th concept in foreign company which is important. In final only this they tested. For Inter I would have told additionally new areas not tested is 392 where penalty is 50,000 rupees per day. I don't think we have questions in this, but Inter they may test. And last section 393. What happens if the foreign company is not registered in Indian Companies Act? Consequence of non-registration, foreign company cannot sue third party, but third party can sue the foreign company. In the 5 concept da sutti keka porom. Let's get into the questions. Of course, in this list of 25 odd questions, some questions we may not be able to answer or we may not be able to find the answer in our book because I have taken this from final. So final syllabus is always a little higher. So on my question, if it comes, we will just strike it off. I have not read these questions before. I am reading it first time with you guys only, guys. Okay. Now question number 1, sir, why you didn't read before? Na time illa. So we are reading together, nothing else. As per provisions of Companies Act, What is the status of XYZ Limited, a company incorporated in London and has a share transfer office in Mumbai? I told you, most of the questions will be in that first page of foreign company chapter. Is a foreign company? Not a foreign company. That means the definition, foreign company means a company which is incorporated outside India and has a place of business in India. For that I have to see share transfer agent. Is that a place of business? In this electronic mode, when I search fully, can you find anywhere share transfer agent, guys? This electronic mode is only an illustrative list. Quickly I am seeing, I am not able to see any share transfer agent. But you tell me, share transfer office, is it a place of business in Mumbai? They are doing some business. Let's go check the answer. If a company has a place of business in India by itself or through an agent or through electronic mode, then it is called a foreign company, and place of business includes share transfer or registration office. Therefore, it is a foreign company. Are you following, guys? Sir, what happens if it's a foreign company? I would have already discussed in class. There are two types of foreign company. Let me call it as A and B. In Companies Act, totally we have 27 chapters. Auditor is one chapter, dividend is one chapter, books of accounts is one chapter. If you are a foreign company, you just have to follow this one chapter, which is chapter number 22, relating to foreign company. That's it. This one alone you have to follow. If you are a foreign company of type B, then you have to follow all 27 chapters. You will be deemed as if you are an Indian company. What is this type B? Very important. This only came in September 24 exam also. A foreign company, but 50% or more of the paid up share capital is held by people in India. Classic example, Range Rover car is a company. Jaguar and Range Rover is a European company owned by Tata Motors. So Jaguar is European company, but Tata Motors has more than 50%. So even though it's a company incorporated outside India, it is deemed as if it's a company incorporated as if in India, and all chapters are applicable. These are the two types of applicability. What is third type? Foreign company. C, that's C in vechikalam. So type A is only this chapter I have to follow. Type B, follow all Companies Act fully. What is type C? It is not, it is a foreign company, does not have place of business in India. Appo Companies Act onnume follow panna venum. For example, take a company which is operating in US. It is operating only in US. India they don't have business. Walmart. Or in US there is a gym called Anytime Fitness. It's a popular gym in US. 24 hours gym will be open for people like me. I'm waiting when it will come to India. Okay. And you can go to gym anytime. They are there only in US. It is not there in India. So these type of companies are foreign companies, don't have place of business in India. Number Companies Act kitte varadu. Other type C. Okay. Next. ABC, a foreign company having its principal place of business at Kolkata. That's it. They have to follow. West Bengal is required to deliver various documents to registrar. You are required to say what documents they have to register. This also we have in our notes. Section 380, documents to be delivered to registrar by foreign company in form FC1. They have to deliver within 30 days. What are the key documents? Basic documents. Which country you are from, name of the company, what business you are going to do, your MOA. In that country, MOA is called charter, the charter document, the charter. Okay. Then when you are opening and closing business, if you came on earlier days, declaration from authorized agents. If they are debarred, they should give a declaration, we are not debarred from doing business in India. Then name and address of the people who are authorized in India, full address. These 7-8 points actually. Okay. So that's about it. We will just go quickly read the points again here. Within 30 days. Okay, here they are not even listing down what are the documents. They are just saying it is required to be delivered to New Delhi. That also we have in the book. New Delhi la kurta podum. Question la ketirukana what to give. You are required to state where the said company. Okay, you should read the question properly. I should read it properly, guys. Where to deliver? Delhi. I should have answered that what to deliver in keta, then I will list down all these things. Okay, next question number 2. Determine the legal positions in the given situation. Abroad Limited, a foreign company, without establishing a place of business in India, issued prospectus for subscription of securities in India. So company is not having place of business in India, but prospectus mattum kuduthirukkan. Being a consultant of company, examine the validity of prospectus issued by this company. We will go to our notes, go to provisions. Can a foreign company issue prospectus, guys? If they are issuing prospectus, they have to follow provisions of this chapter. What is this? Registration of prospectus, and prospectus should be attached with the following documents. Let's read the answer, then connect with our book. Is the prospectus valid? Yes, it will be valid if it is done in compliance with the provisions of section 379. Let's read what answer they have given. They are referring to 389. So what is 389 here? Exactly what we saw here. Registration of prospectus. So according to Companies Act, inga paragraph irukku, I am just giving in points. The following documents should be annexed to prospectus: expert, appointment of MD, any material contracts in the last 2 years, copy of underwriting, power of attorney. This prospectus, it has to be certified by the chairperson of the company and other 2 directors. What will they certify? They will certify it has been delivered to registrar for registration. The prospectus will also state that on the face of the copy that it has been delivered. Are you following, guys? Read this point. It should be the same. Let's read it. What they are saying. Whether the company has been established a place of business, circulation or distribution, it should be signed by the chairperson of the company and other 2 directors. Same 2 points we have here. Chairperson, other 2 directors, and having been approved by resolution, delivered to the registrar for registration, and get the appropriate consent that is there. All those points. 389. Are you following, guys? Okay, understanding? I told you the 5 areas of the question is going to come mostly. Of course, we only have 1 hour to complete. Oh, starting solla marante. 1 hour we will try and complete foreign company, guys. Because it's 1 hour, I am just reading through the keywords and connecting with our notes. The whole idea is workout is for students. Wherever you studied, you can connect with those notes, but our notes we are connecting because for most of our students it will be easier. Okay, next, Radix is a company registered in Thailand. Iniki dhaan pesnuma. Today is 31st December, guys. For those who are watching this later, we are recording on 31st December 2024 at 6 p.m. we are recording this. Look at the motivation you should get. There are some 15 students sitting here. I am sitting here. All of us don't have New Year plans. Our New Year plan is to study. Okay. Thailand on this trip. Okay. 2 of my school friends are now in Thailand actually. Avanglu 1 week of story potne irukanga. One guy went with his family, other guy went with his wife. Both of them are putting stories from Thailand. Naanu story part like dhaan pannit irukken. Okay. My wife also asked me what plans in Jan, any trip on. I said no trip. First nama vela pannalam. We will go for trip in 2026 and convince panta. It's a company registered in Thailand. Although it has no place of business established in India, yet it is engaged in online business through remote delivery of healthcare service in India. Thailand linding enna healthcare service. State the legal position and nature of Radix. Is it a foreign company in light of the Companies Act? Is it foreign company? Yes. Remote delivery, online delivery of healthcare service. Go to our notes. In electronic mode, there is one point. Can you see? Telemedicine. Electronic mode, not telemedicine is included. Correct? So I will come here. Look at this. According to section 242, what is foreign company definition? Guys. In the chapter, one question now. Foreign company means a company incorporated outside India, has a place of business in India by itself or through an agent, physically or electronic mode. Okay. Then come here. They are writing the full electronic mode, all the points, not required, because main core point here is telemedicine, and the point mattu eldana podum. But if it's a 6-mark question, maybe this is final. This answer is from CA final. So ellame eldirupanga. Okay. Next, question number 4. Yes. If you all forgot Sanjeev online students, he is still here only, guys. Proof kaga Sanjeev padikka poran. Yes, Sanjeev.
Delegate Limited Incorporated in Singapore decides to establish a place of business at Mumbai. You, being a practicing chartered accountant, have been appointed by a company as a liaison officer for compliance of legal formalities on behalf of the company. Examine the provisions of the Companies Act. State the documents you are required to furnish on behalf of the company on establishment of a place of business at Mumbai.
Repeater. What they're asking, section 380. What all I should deliver? You should deliver in form FC 1 within 30 days of what to say in coming into India to what place? New Delhi. இங்க கரெக்டாக படிக்கலாம், இங்கே கிளியராக கேட்டிருக்கான். State the documents you are required to furnish. I will not repeat again, guys. Sometime back only இந்த டாக்குமெண்ட்ஸ்லாம் படிச்சேனா ரஃபா. Those documents will be listed here. Basically, if you don't remember also, you think, guys, foreign company na normal name of person, date of birth, father's name, அதெல்லாம் வந்துடும். அதை நான் ஒன்றும் எழுதிடலாம். nationality அதெல்லாம் வந்துடும். Additionally, எந்த country, passport number, income tax, PAN number, occupation, இதுவே வந்துடும். And then you will keep going, guys. Name and address. I told full address of where company is there, particulars of opening and closing if they earlier came to India and left, declaration that none of them are convicted or debarred, any other information that you will submit. Question number 5, similar to question number 5 only, came in September 24 exams. Yes, Sanjeev, read it.
Z Limited, a foreign company incorporated in Japan, has a branch office in Hyderabad in India. Mr. B, the Indian citizen, holds preference shares of Z Limited, which comprises 10% of paid up share capital of the company. DC Limited, a company incorporated in India, holds equity shares of Z Limited, which comprises of 45% of paid up share capital of the company. During the financial year 2019-20, there has been alteration in the particulars of the document mentioned under section 380 of the Act, and the company has failed to submit the alteration to the register within 30 days. Unless in the light of the applicable laws, the consequence of failures on the validity of any contracts entered in by foreign company.
Okay, this chapter, in the chapter the workout is important because ICA source of questions is this list only. So they will keep asking from this. So what they are saying here, look at this. It's a foreign company in Japan, branch office in Hyderabad. அவனே சொல்லிட்டான், it is a foreign company. Bharatiya, Indian citizen, holds preference shares in Z, which is how much? 10% of paid up share capital. And Desi Limited holds Indian company, which holds 45%. அப்போனா இந்த ஜப்பான் கம்பெனியில் அந்த Bharatiya fellow is having 10%, other Indian company is having 45%, collectively they have 55%, more than 50% of paid up share capital, and it is included, see, not less than 50% of paid up share capital including equity and preference if it is held by Indian citizens or one or more companies incorporated in India. It is deemed that company is as if incorporated in India. அப்போ பேருக்கு தான் ஜப்பான் கம்பெனி. You are an Indian company, you are only in India, you have to follow full Companies Act. Okay, during the year 1920 there has been alteration in the particulars of the documents mentioned in section 380 talks about filing to ROC. When you come to India you will file. Whenever there is a change also you have to file. They have failed to file within 30 days. Examine the validity. So two things will come here. First, you should tell it's a foreign company deemed that is incorporated as if in India. So they have to follow full Companies Act. Look at the answer, guys. Where not less than 50% on the provision. It is deemed as if it's a company incorporated in India. That point. Then as per amendment, our book is as per amendment only. What is the conclusion they are giving? Let's go to conclusion. Okay. Yeah. In the above question, provisions of Companies Act are applicable to Z because an aggregate of 55% is held by Indian citizen and Indian company. So they have to follow full Companies Act. So this is the provision. This is the analysis. Okay. Leave this amendment point. We have anyway amendment. Just for answer they are giving like that. They have to follow full Companies Act is the first para. Second paragraph. However, there has been non-compliance of section 380 because they have not sorry, if they have to follow full Companies Act, they have to follow 1 to 470, which includes 380. That means they have to file to ROC if there is a change in information. Look at this, I have given here. Where I am giving it. I would have given it somewhere here again. Here. Any alteration of the same shall also be filed in 30 days in form FC 2. Okay. So, shall apply. However, there has been a violation of 380. So, as per 393, immediately 393 will come. As if you are not registered, the validity of contract entered by foreign company shall not be affected. Company may be sued in respect of contract, but company cannot sue the other parties. Beautifully they are writing. First they brought 379. Full act is applicable for you. Then they went to 380 and told, because of non-compliance in 380, you go to 393. In the non-compliance, because amendments are not filed, I will go to the last section which I told you they will ask. That non-registration, company cannot sue third party can sue the company. Should I scroll like this and show you guys? You will get some connect. Okay. I told you in the 5 questions da kepan sonnana. And the 5 3 concepts they connected. Are you following guys? Clear? Understanding? Next question 6. 6 mark question. They are giving 6 cases. Either foreign company. Quickly let me read this. We will discuss for all 6. Let's see collectively how much mark we will get guys. Incorporated Malaysia, registered. Now definition is what? Foreign company means a company which is incorporated outside India. So I need to focus only on incorporated column. Here everything is given same, correct? Column. Okay, maybe if it's different also, it's just to confuse you. I will focus only on where it is incorporated. All these are foreign companies. Which is as per Indian Companies Act, 3 cases I told you. A, B, C. If you fall in A now, only this chapter. If you fall in B now, full Companies Act. If you fall in C now, you do follow panavano. Developed patients database for a hospital in India. Server is in Malaysia. Is a foreign company. Is it a foreign company? Is having a place of business in India through a database. In electronic mode, we would have seen data interchange, digital supply, data interchange. Let me go check. The answer could be wrong also guys. I am only guessing. Has a place of business in India by its, okay, first they are writing the full definition of Mutchirna, then each of the 6, and look how they are writing this answer. They are writing definition, then electronic mode, fully they are explaining, and then they are also writing that more than 50%, full provision they wrote, and then answer. Server is in Malaysia, okay. Though incorporated outside it as transaction, it is a foreign company because of that database point. That's what we saw. Data interchange. Like this, let's discuss for everything, then we'll go check all the answers. Only first I wanted to check. No place of business in India, but employs agents in India. Is this a foreign company? Yes or no? What is definition? Incorporated outside India, but has a place of business in India. Avane place of business illan solrani. Is it a foreign company? I will say no, but let's go check. We will check the reason. I may be wrong also guys. We will check. It's okay if we are wrong. We are only trying. The idea is we will try make mistakes during class so that exam la vandichna. Even if you don't understand concept, mark vanda podum. Okay. Next, board meeting held in India. Are they doing business in India? Meeting da vekranga. Okay. So I will take it as no, but let's check if the answer is opposite. I don't know if it's correct. 59% of shareholding held by is a type B or company. A type B only for class case exam leda type ABC. Type B na you have to follow full Companies Act. Offers and invites deposits from citizens of India but has no place of business. In our list, in electronic mode, go read point number C. Offer to accept deposits or inviting deposits or accepting deposits from India. That means that is deemed to having place of business. Therefore, it's a foreign company. Yes. 49% of the shareholding held by an not a foreign company. Correct? Because we need how much? More than or equal to more than or equal to, not less than 50%. So this also will come under category C. Let's go check the answers. Everything correct or some mistakes also is fine. Next to Dubai. Correct or since company though employed agent in India, it's not having any place. See, the condition is place of business in India and employing agent. through an agent. Place of business in India through an agent only I will take. Only agent, therefore not a foreign company. Correctly we got 2 marks for us. First, second. Merely holding meetings in India cannot be termed as conducting business. It is not a foreign company. Look other way. Imagine you are an Indian company. Okay. One day I am saying, okay guys, class inge irthu board adikudhu. Come on, let's go to Sri Lanka for one day class. Or one day we'll go there for meeting and come back. Summa poitu varum. That is not conducting business. Place of business na or continuity irukanu. Or at least one time an income generation irukanu. Okay. Meeting kaga simply they came to India and went. It is not a foreign company. We got it. Correct. 3 out of 3. This will definitely be correct. It is not a foreign company. 15% is held by an Indian company. Not less than 50% is held by Indian citizens. It is treated as an category C sonalla. It is not a foreign company. It is deemed as if it's a company incorporated in India. That we will write. Next, it is cannot be called as a foreign company. This is one of the ways of transacting business through electronic. This one we got it wrong. However, this company doesn't have a place of business in India. Hence, it cannot be called as a foreign company. So let me conclude this. Got the clarity now. Follow. It triple condition to call as a foreign company, guys. It should be incorporated outside India plus place of business plus it should be either by physical or agent, again by itself or electronic mode. And the circular what they gave for electronic mode that circular. What is electronic mode? Data interchange, telemedicine, giving deposits, etc. That means by interpretation I will take, you should satisfy all the 3. In this case, they satisfied first, they satisfied third, but place of business say illa. So since there is no place of business, the provision says it is not a foreign company. Are you getting it? We got this wrong. So we got so far 1 wrong. 5th one we got 1 wrong. Last one, this we know 49% now. It is not a foreign company because you need at least 50%. Hence this is a place of business. No? It is treated as an hence is held by hence is a, see that how can I conclude it's a foreign company? 49% of salary, yeah, therefore it is a, but foreign company in the chapter follow pannuma. They have not given about place of business, correct? So we have A, B and C. இவன் என்ன கன்க்ளூட் பண்றான்? This is not C ன்னு சொல்றான். So sorry, this is not. He is saying this is not B. But how do I know it's A? It is a foreign company in this chapter only if they have place of business. That they have not given. So they are just ending by saying it is a foreign company. Whether they have to follow this chapter or not, it is a foreign company. A also foreign company. C also foreign company. But whether they have to follow this chapter depends on place of business. Our question is silent. Are you following, guys? So we got 5 out of 6 correct. We got this deposits one alone wrong. I hope you got clarity now. Why the clarity is no place of business and don't count it. Even in second point we didn't count, 5th point also we didn't count. Clear understood, guys? Honestly got clarity. Only if you get clarity I will feel like okay you have understood. Sure, 100% all of you. Yes, Harish. Ama. So his doubt is, sir, in 4th case or in this case where it is held by more than 50% by people in India, do I call that as an Indian company? So look at this, what they are saying. Few foreign companies as if it is a company incorporated in India. So if more than 50% is held by people held in India, I will call it an Indian company itself. That's why they will follow all the 27 chapters. Therefore in 4th case it will be called as an Indian company only and not a foreign company. Understood? In fact all these questions we have in our book also. Not okay, other book. Okay, leave that. Next question 7. Yes, Sanjeev, fast.
A company incorporated in France with limited liability established an office in Baroda and started conducting business activity from its place of business. In compliance of Section 382 of Companies Act, it conspicuously exhibited a name board outside its office with the name of the company in English in big black letters. In 3 days, the company received a notice from the registrar stating that it had not properly complied with the requirements of Section 382 of Companies Act. Mention the areas of lapses the foreign company which should be mentioned in the notice.
Sir, you told us only 5 concepts will come. Pudu concept came. Exam la varla MTP. It's only MTP question. We have this also in our book. Small concept 382 says name of the inga irukku paranga. Name of the display of name of foreign company. What they are saying, the name should have two things. It should have name of the foreign company, should have the country from where it is originating. That details I should have in every place where business is carried on, and the same shall be legible in English. Name outside additional of it shall be in vernacular. So English plus Tamil, English plus Hindi. Okay, English mandatory. Details of liability also should be there. First point only they have asked. Let's go down. That only should be the answer. So exhibit outside every office the name of the company legible in English, and the local office vernacular language can be used generally. So here what they are saying, then liability of member, you solrang, they're talking about liability also, because this 382 talks about liability of members in every place or wherever there is prospectus, advertisement. You should talk about all the letterheads should talk about liability of the company also, the members liability. So on the details also should be here. 382 is writing, considering all of this, this company did not have details of what company is one where liability is member. The fact that the members liability is limited has not been exhibited. Neenga question la pathina 382 they displayed only name, they have not displayed liability of the members, and they have also not displayed in local language. It has not displayed in local language, that also is missing. So 3 things should be there in 382. Name of the company in English, vernacular language, and liability of the members. Out of 3 things in this question, they gave only name. Vernacular language general use kudukala and liability of members is not given. So they are saying that's why they received notice from the registrar. Are you following, guys? Clear? Question number 8. Yes.
Elegant Education Limited is a UK-based company engaged in the business of providing online education. It has introduced some certificate courses having duration of 4 to 6 months, and any person can enroll in the courses. The education is provided through online classes, webinars, and study materials are supplied through emails registered candidates. The company is not having any place of business in India. It is mentioned that all the candidates who have enrolled in the course of the Indian citizens residing in India. Based on the above facts, procuring 100% business from India, whether the company will be treated as a foreign company or Indian company. What will be your answer if the above question, more than 55% of the foreign company paid up share capital is held by Indian companies or Indian citizens?
You know the answer. When you're reading, you're getting the answer. That's the confidence you should get in exam. For all 6 subjects or 3 subjects, or at least majority of 100 marks. Now here, first case, is it foreign company? Yes, because they are providing education through online. Our list la neenga pathina there will be education inga paranga, telemedicine or education. I'll zoom in a little more. Can you see this education, guys? Ipo therida? Okay. Oh, online I think I'm covering little bit, or ivlo zoom panna it's little not visible. Yeah, you can see education. Come down. So education, yes. Second, what if more than 55% is held by, then what you will call it, guys? More than 50% is held, therefore it is deemed as an Indian company. Are you following? Just on kuti distraction within workout batch, because we spoke about education and online courses. You guys being students for the next 3 to 4 years, you will already be getting lot of ads. Do this diploma course, do this AI course, do this course, and nariya ads will keep coming. Your friend also would have done, na pantanda, data analytics, I finished one course, I got one certificate, I paid 40,000. you will keep getting lot of these ads because there are so many companies like Upgrad, Udemy. I'm not naming against the company. I'm saying you will get lots. Scaler, நிறைய ads will come. அவங்களுக்கு business now. I'm not saying don't do them. If you want to do a course, just check. Price is secondary, guys. Price doesn't matter. Let it be 1 lakh, let it be 10,000. Most important thing is your time. You are going to invest hundreds of hours in that. After investing, see what you are going to learn, and after learning that, are you going to apply that in your life? I will tell my real life example. I finished CA. Then while doing CA, my faculty told do just CS, and why my faculty told do CS was inter முடிச்சிட்டு ஃபைனல் எழுதுறதுக்கு 3.5 years கேப் இருக்கும். ஸோ அந்த கேப்பில் ரைட்டிங் ப்ராக்டிஸ்க்காக CS பண்ண சொன்னார். I blindly trusted and did, okay, it added value. Then one day I myself decided, after finishing CS, CA over, CS over, CMA பண்ணலாமே. Then I went to CMA Institute and paid fees. Then I registered for CMA. Inter exams also I paid fees. Then my friend asked me once, எதுக்கு பண்ற நீ? சும்மா to show off you want to do CMA வா? Are you having any value? உட்கார்ந்து பேசணும். You are doing it raw, okay fine. What is the value of doing CMA? Are you going to practice as CMA tomorrow? He asked me. I said no. Just for having these 3 qualifications, do you want to do it? Then I thought, okay, again why to do it? I registered, I never wrote any exam. I don't know what I'm registration, it should be void by now. I should again pay. I'm not interested anymore also. I'm not saying it's not a good course. If I'm interested in costing, I will go do it later. So I stopped doing that course. That's it. So CS also, it was mainly for writing practice, and so I mean, that was a purpose for me. After that, membership fees katla actually 1-2 years I will go pay that. Okay, by the time somebody takes this recording and sends to CS Institute. So any course that you are going to do, global course in the future, check is it going to add value for you. Don't do it because your friend forwarded that reel to you, or don't do it because somebody is earning money. Do anything if you are going to find value in that. That's it. Okay. Question number, this is correct only, no, our answer is correct, right? More than 50% now. Indian company. And previous one, electronic mode includes education, so it is a foreign company. Yes. But in the previous question where there is explicitly given that it has no place of business, but yet it is considered. No. In the previous, his doubt I will just repeat. Janeshwar's doubt is, sir, previous question you told there is no place of business but includes deposits. We did not count as foreign company. In this question, the company is not having any place of business in India. Let me go check the answer. Is it a foreign company? 1 second. Case 1 dana. Okay, definition of foreign company. Thus, from above provisions, company still is a foreign company irrespective of the fact 100% of business comes in India. What is the conclusion they have given? From rules means carrying out electronically based, whether main server is installed in India or not, but not limited to online such as education. So what have they concluded? They are saying it is a foreign company which has to follow this chapter, correct? Adana solran. So his doubt is a valid doubt. He is asking, in this case, enga poichu? Okay, it's not loading. Yeah, he's saying some PDF started playing. Okay. Yeah, அவன் கேட்குறான், இங்கே வந்து you told no sir, no place of business, but that list is covered. So no place of business, just because this is there, I will not take it as foreign company. Same thing is there in this question, no? Correct? Yeah, in this question also, it's the same thing. Education one. But they have concluded by saying it is a foreign company. இங்கே எந்த மாதிரி foreign company சொல்கிறான் அவன்? Based on above facts, 100% business from India, whether the company is foreign company or an Indian company. Of course, it's a foreign company which has to follow whether the main server is in India or not, including but not limited to service telemarketing. Thus, from above provision, it is treated as a foreign company irrespective of the fact 100% business comes from India. புரியல. In that it is so in that what he concluded yeah, that this is it is cannot be called as a anga, it is not a foreign company because there is no place of business in India and potrukkan, but this question they are saying it is a foreign company, correct? Correct. Online service telemarketing, okay. So you are saying answer la whether main service is installed in India or not, but not limited to online service such as telemarketing, telecommunication. Oh, for telemarketing, telecommuting and telemedicine and education, this server can be anywhere. India la irukko illiyo, it doesn't matter. So then we'll go based on this point. Even if server is not in India, we will consider it as place of business is in India. But just going by plain reading of question, just because they are saying, okay, so the point is this, what Hari told is what we have to conclude. Even though they don't have place of business, for these cases, telemarketing, telecommuting, telemedicine and education and information research, server India lo irukko illiyo, we will still consider if this service is done as if place of business is in India, and logically they are doing business in India, they are getting revenue. Are you following? I hope you understood the doubt. Little bit confusion is still there for me also. Let's see some more questions to see if you are getting clarity in that. Okay, next question 9.
Search and Find Private Limited incorporated in Singapore. The company sells its goods through electronic mode on the e-commerce platform in India. However, it does not have any branch or office in India. Is the company required to submit the document as required under Section 380 of the Companies Act?
It sells goods through electronic mode. That means it is having place of business. It does not have branch office in India. Is it required to submit documents? Yes, because foreign company means a company incorporated outside India, place of business in India by itself or through agent through electronic mode. Okay, adha kuduthirukam parunga, through electronic mode also is included. Therefore, this company is conducting business in electronic mode. Therefore, it is required to submit the documents. Next question.
Arika
10.
is a company limited incorporated in Singapore, decides to establish a branch office at Mumbai. You, being practicing chartered accountant, have been appointed by the company as a liaison officer for compliance of legal formalities on behalf of the company. Examine whether branch office will be considered as a company incorporated outside India. If yes, state the documents you are required to furnish on behalf of the company or the establishment of a branch office at Mumbai.
Fairly simple. Will branch office be considered as a company incorporated outside India? Is a company in Singapore desiring to establish a branch office in so branch office in Mumbai. Now physically they are having place of business. Is it foreign company? Yes, it's a foreign company. Therefore, what documents they have to give? Section 380 la all those documents, name, passport number, all of that. It has a place. So branch office are generally considered as reflection of the parent office. Therefore, branch offices incorporated outside India are considered as a place of business which is done physically. Therefore, you have to, it is called as a foreign company. 380 next point, case 2. What all documents you will submit? Are you following, guys? So just be aware of this document list because it's coming multiple times. Next question.
T Motors Limited was incorporated in Japan. Its share capital is held by the following persons: citizens of India 10%, Indian company 40%. The company has opened its representative office in Mumbai 15th January 2021 in order to receive orders from the Indian market and make available the delivery of Japanese luxury cars to Indian purchasers. The company was not aware of Indian company law, hence could not file the required documents to the register. The company could file all the required documents only on 28th Feb 2021. Based on the above facts, answer the following: whether the provisions of chapter of the Companies Act 2013 are applicable to T Motors Limited, what documents are required to be filed by T Motors Limited to the Register of Companies, by what time all the requisite documents shall be filed.
Okay, Toyota company Tokishin Matino. Okay, Tokushio, whatever. Okay, fine. First, it's a company again, Japan. It's Japan company, illa. This is treated as an Indian company because 10 plus 40, how much? 50% of paid up share capital is held by people in India. So example Japan vanda illa India. Okay, சும்மா சொல்கிறாங்க guys, percentage count பண்ணிக்கோங்க. The company has opened representative office in Mumbai on 15th. That means within 30 days you have to file form FC1 to ROC. So 30 days will be somewhere around in 15th Feb. In order to receive luxury orders from Indian purchasers. Okay. The company was not aware of Indian company law. Mistake of law is no excuse. Foundation purchasing, correct? Hence could not file the required documents register. Company could file all the documents on 28th Feb. That means there is almost half a month delay. For every day of delay, penalty is 50,000. Can I give discount for the company? Illa, nee luxury cars nee vippe. I will also put luxury tax 50k per day. Based on the above, are provisions of chapter 22 applicable to Tokishi? Yes. Yes then. This chapter also is applicable. Fully it's applicable. It is deemed as if it is an Indian company. What documents are required to be filed by Tokushi? 380. By what all time it should be filed? 30 days. Penalty kekrana? Illa. Let me go cross check. Not less than 50%. Therefore, all provisions are applicable to it. Are you following? That means this full act itself is applicable, including foreign company chapter. Second, what documents? This we already saw. Within how many days? 30 days. Again case 3 bhi adhe solran parunga. So date he has given. So 15th Jan before 14th Feb, Valentine's Day vanich. Okay. Correctly, this you will correctly count. Are you following? Yes, actually count the 30 days. If at all they ask additionally, na irundha penalty um ketirpen. If I am the examiner, penalty, if you see 392, by not complying provisions of this chapter, 50,000 per day of default. Are you following, guys? Okay. Next question number 12. I think this question is not in syllabus, but let's check. Or it's in syllabus, I'm not sure, but let's check. No, it's in syllabus only, I think. Okay. Yeah, it's in syllabus. I'll quickly read. Blue Star is a company incorporated in USA 4 years back and has no established place of business in India. No place of business. Company entered into the following contracts. Last 4 years, ordinary course of business, some number, material contracts out of subset. Out of 4, 2 are material. Out of 6, 1 is material. Out of 3, okay, here 4 is material. It's not like that then. Different contracts. Apart from above, one contract has been entered in with its manager. The company intended to offer its securities in India. For that purpose, the secretary of the company, Christian, prepared the prospectus along with annexing the required documents and got it registered. Expert's consent was issued in a separate statement, the reference to which was given in the prospectus. Few application forms for securities of Blue Star were issued to prospective investors. Without the prospectus, one such form in connection was inviting persons into underwriting agreement. In the aforesaid, answer the following questions. Final question nala he has put all the provisions. Is it part of syllabus? Yes. But how soon they will ask us, it will take some time, because in this question they have discussed the concept of prospectus along with underwriting. We have both of that in our book, prospectus point and underwriting exception underwriting. Look at this, I would have given a point also. No person shall issue a prospectus for a foreign company to anyone in India unless it is issued as a prospectus with this chapter. Apuna, if you're issuing securities, now you have to give prospectus, but exception underwriting. This question talks about that exception, and it also talks about material contracts, which we just read. Look at this. The prospectus, just now we read some time back. The prospectus should contain details of material contract in the last 2 years. Here they gave details of last 4 years. Let's go read the answer. Whether expert statement can be considered to be included in prospectus, what copy would be annexed, whether for issuing forms without prospectus. Okay. Case 1, small cases. We will read the answer itself to get more clarity. According to section 388, a statement shall be deemed to be included in a prospectus if any report it contains expert, therefore expert statement shall be deemed to be included in prospectus. Sir, நம்ம bookல எங்க சார் இருக்குது? If I go to our prospectus in our book is just 2 pages, 388 and 389. So 388 I am yet to read in today's class. Provision as to experts consent and allotment. The expert approval should be included in the prospectus if it is available. If the prospectus includes statement from expert, expert must agree it is part of document. Are you following, guys? Therefore the document can't be shared without expert consent. This is first. Second, a copy of contract for appointment of MD and manager in case of a contract not in writing, memorandum of particulars, okay. Copy of material contracts not entered in ordinary course of business but within last 2 years. We saw that just now some time back. These points, guys. Registration of prospectus, what all should be annexed? Look at the question. What all should be annexed with prospectus? Second question, what all should be annexed? What all is annexed here? Expert consent, appointment copy of MD and oral, if then material contract, underwriting, copy of power of attorney. These 5 points as it is will come over here. Case 2, material contracts in last 2 years, appointment of managing director or manager. Are you following, guys? All of these points. They have not given some more points. You can write what underwriting, copy of POA also. Therefore here last to 2 years of material contracts, which is 3 and 4, that also I can give 3 and 4, but 7 illa 3 and 4. Apart from it, whatever total 8 copies of contract would be annexed. 8 copies, I believe 8. 3 plus 4 only, no? Financial year 1920 2021, the material contracts entered with Blue Star is 3 plus 4, and apart from it, one contract entered with the manager. Adum ketirukanga question la. So 3 plus 4 plus 1, 8 contracts will be annexed. Then last question, no person in India will issue underwriting exception, correct? No need to give prospectus if it's given through an underwriting. Just now I read some time back, guys. Therefore here it can be considered as valid because it's covered under the exception of the subsection. Which exception? Prospectus is needed for everybody except for underwriting. So all these 3 things have come from within expert and prospectus. Little in-depth question, but final questions we are discussing, guys. So don't get scared, it's part of syllabus anyway. Okay, this question we will come to it in last question 13 because there is, okay, pay panidla. It's computational question. Question 13, yes, read it quickly.
Zell Power LLC is a foreign company as per definition provided in the Companies Act, carrying business in India also. It is strictly observing the provisions stated for foreign companies in Companies Act, while Register ROC Delhi is of opinion that ZPL Limited, apart from observing the provisions prescribed for foreign companies, section 380 to 386, ZPL also needed to observe other provisions of the Companies Act with regard to business carried on by it in India as if it were a company incorporated in India. ZPL is not agreed to the opinion register and continue to observe only those provisions which are applicable to foreign companies. ZPL also furnished the following details to ROC. ZPL capital includes ordinary shares of 6 million, face value of 5 euro with 2 euro paid up, 12 million preference shares stock, 1.2 million into euro 10 fully paid up, debt fund of 21.25 million, out of which Mr. Trishi, who is an Indian citizen and residing in India, being part of promoter group, own 2,93,000 ordinary shares of ZPL. Mr. Nirav, who is an Indian citizen but residing in UAE, owns preference stock of ZPL Limited. Modern Engineering Limited, that an Indian company, owns 67,220 ordinary shares and 1,42,320 preference stock of ZPL Large Investment Limited, which is an Indian company, holds 3,93,475 preference stock of ZPL. You are required to evaluate the facts and determine whose opinion hold legal validity in the light of the relevant provisions of the Companies Act.
Okay, now question பார்க்கிறதுக்கு பயங்கரமா இருக்கு, guys. It's a little scary question, which is a big one, but finally it came only in RTP. Let me simplify for you. At least have you understood what they're asking in this question? He's asking you whether 50% of paid up share capital, including equity plus preference, is held by Indian persons or Indian company. That's all I have to check. So, denominator அவன் கொடுத்துட்டான். Denominator is the total capital base of that company. Equity plus preference. I can solve the whole question, but I will run through solution. This is the total capital base, which is 12 million preference stock and ordinary shares 12 million. So, total it will be 12 plus 12, which is 24 million. Correct? 12 million preference, 12 million equity. In other countries, they don't call equity share, they call it as stock. Okay. In this 24 million, how much we are having? Trisha is having this much. Then Nirav is having this 1,09,000. Modern Engineering has 67,220. In that, and they also have preference shares. Again, Raj Investment, Indian company, has 3,93,000. In the numbers, ellame numerator la add pannum. And then I will check if I am getting 50% or not. Just to save time, let me go to the table away podliya. Okay. So denominator is 24 million. You have to count, guys. Roughly, can you count the total of Trisha? 29,32,780 plus 1,09,205 plus 67,220 plus 1,42,320 plus 3,93,475. எவ்வளோ வருது? There is one catch over here also, but one very good catch is there. How much is coming? Now, you have to be very careful here. You cannot divide. It's a very, very, what to say. Exam la ningla gali da. Ungala gali pandratha the question veppam. Okay. What most of them will do is denominator la 24 million vechirunga. 12 million plus 12 million vechittu. Numerator la you will add everything. You will get some value. Okay. It will not come correct answer because I don't know if you noted. Equity share is face value 5, paid up is 2. Preference share is face value is 10 euros. So you cannot count based on number of shares. You have to count based on value. Sir, enna sir solringa? What I am trying to say, if I have to count based on value means, when I say I have to count based on value, denominator should be equity plus preference in value. Numerator also should be equity plus preference in value. What all of you did now, we just added 29 lakh plus 1 lakh 9. No. You have to multiply each of the share with its corresponding paid up value. Correct? So, Trisha is having what? Ordinary shares. So, Trisha is having each share worth 2 paid up. So, Trisha ku vandu 29,32 into 2 podno. Are you getting it, guys? So, for each person I have to multiply and find value, divide by value if I am getting 50%. Are you getting it? So, the most common mistake students would have committed, including me, if I am doing for the first time. In fact, when I was doing this question for the first time, that was a mistake I also did. Okay. So, you should take 2 into whatever preference. Preference again will be 10. Where all equity 2, preference 10. And then if you divide like that, you will get. So that's why they are looking at this. They are counting preference separately. They are also counting equity separately. Are you following, guys? Purila. Adha 67,220. Trisha and that company. Therefore, this paid up value is 6 million. Then preference on the paid up value is 6.45. Therefore, total is 12.45, which is more than 50%. Therefore, this company will be deemed as if it is an company incorporated in India. Are you following, guys? Which has more than half. If you do the other way, just by doing number of shares, 50 kammiya vandirukum. It would have been less than 50. That would have been the mistake. Are you following, guys? Do you want me to do this computation and show you? or at least for one we will do. Idan normal 29 lakh 32,780. I'm doing in lakhs but actually millions, plus 67 220 into எவ்வளோ வருது இது நம்ம ஆட் பண்ணோம் 30 lakhs வருதா கரெக்டா 29 த்ரிஷாவும் அந்த கம்பெனியும் ஆட் பண்ணா 30 lakhs வருதா 30 lakhs into 2 per share which is going to be 60 lakhs. 10 lakhs is 1 million. Remember this. 10 lakhs is 1 million. So 60 lakhs na 6 million. Understood for equity? Preference is going to be straightforward. Irukra 3 preference eduthu multiply with 10. You will actually get 64 lakh 50,000. Are you getting 100? So 10 illa 100 on face value. 10 na okay. You will get 64 lakh 50,000. So 10 lakhs is 1 million. So 6.45. Are you following, guys? So total will be 24.5 million. Sorry, 12.45 million out of 24 million. Are you following, guys? Everybody understood? Will this come in exam? Part of syllabus. First mandatory question 5 marks keklam. Now is it scary, guys? And the one catch is what? You would have not multiplied. Nee number mattu eduthirpa. Number mattu eduthinga gali, because it is in value. Okay. Fine. One day it will come, guys. Internet definitely it will come. The day it comes, I will repost this video that we predicted on 31st December 2024. We predicted this, guys. Okay. Next. Question 14.
Examine whether the following company considers foreign company. Miss Redstone Limited is a company registered in Singapore. The board of directors meets and executes business decision at their board meetings held in India.
Answer. Yes, foreign company. No, we already saw board meeting na illa. Next.
Miss Blowstar Public Company Limited, registered in Thailand, has authorized Mr. Y in India to find customers and to enter contracts with them on behalf of the company.
Foreign company has authorized Y in India to find. That means you appointed agent to enter into and do business. So Blue Star registered in Thailand has authorized Y in India. I am entering into business in India through an agent to find customers and enter into contract with them on behalf of the company. Is it foreign company? Yes or no? Yes is what I will take. Let's check the answer. Okay, in the page what is the answer? Just check for that. Yes da kuduthirukano. Yes, why it is yes. Answer has come now. Blue Star, it is authorized Y in India to find customers. That means you are entering into place of business in India through an agent. Therefore, it is a foreign company. Next, X Limited, registered in Dubai, installed its main server in Dubai for maintaining office automation software by cloud computing for a client in India. What is this? Nowhere they have spoken about. See, they have not told anywhere. Server pati engume they are not bothered. Because of electronic mode now, don't expect server to be in India. Enga irukku? Oh, example cloud server. Location of server is not important for determining. Let's check the answer. But for its client in India, that means I am doing electronically place of business in India. I will say it's a foreign company, but I am doubtful, guys. Let's check. Okay. Why I am saying doubtful? Exam you have to write one answer. You have to take one side. In the given case, registered in Dubai, installed server in Dubai, automation, client in India. That means place of business is in India. Thus it can be said that as a place of business in India through electronic mode, therefore it is a foreign company. This question is to communicate server enge irukku matter illa. Incorporate outside India, yes. Place of business in India, yes. Physical electronically, yes. Electronic mattum clarification. Are you following, guys? Clear? Harish, yes, doubt. Correct. So in question number அதே அந்த பாக்ஸ் கொஸ்டின் தான் ட்ரபிள் கிரியேட் பண்ணுது. கரெக்டா? ஜானேஸ்வருக்கும் கொஸ்டின் 6 வந்துச்சா? this question, which one is this? 6th, which case? Second case. Dubai case, no place of business in India but employs agents in India, since the company is employing through agents in India but does not have a place of business. Now I'll clarify this, guys. What they're trying to say is, in both previous Dhyaneshwar question and this, both of you bought the same question. Sir, on the table question la mattum, what to say? That agents point to and that education question. Correct? Education, you brought up this question. Which one? Deposits. Okay. We will go with the assumption, or we will go with the interpretation. In the Dabba question, they have clearly given there is no place of business, and question is focusing only on this keyword. That's why we are saying it is not a foreign company. In the other two questions where we had conflict, now just exactly this question, you are having agents and you are getting customers from India. Regarding place of business, edume kudukla. So my assumption is there is place of business. And in the other education question also, since even though they have given there is no place of business, that exception point is there, that for telemarketing server doesn't matter. But even in the education question, avan solran there is no place of business, but question la factually place of business is happening in India. 100% of clients are from India. Now how can I tell there is no place of business? So going by that, yes, it is a foreign company. So in the Dabba question, because there is no other facts given, I'm going with the word no place of business. But if some other facts are given in the question, give that more importance and don't just go by the word. Company is saying no place of business, therefore there is no place of business. Got some clarity here? Now we are in which question? Okay. 15 start pannuma. Sure, have you understood this one? 14. Answer is, third one, yes sir. Yeah, server in Dubai. Agent, to find customers. Nothing about place of business is given over here. So that means to find customers in India is for place of business in India. Okay. I think I'll just reopen the PDF so this issue will not come. That's it. Which page number? 3. That's it. Sometimes reopen panna, it will be fine. Question 50 now. Idana close pannu. Thank you. Leave. Okay. Question 15. Totally 25 are there. 23. I think now repetition only is coming. We can get done with it soon. Okay. Now, analyze whether the following is foreign company or not. Quickly. Company incorporated outside India. First point met. Registered in Moscow. Okay. Russia has installed main server in Moscow. Office automation server for client in India. Is it a foreign company? Yes. Similar question we just now saw. Okay. Server inge irukko matter kadiyad. Earlier there used to be a law. Server location matters, but not today. Following Dhyaneshwar, clear. Company incorporated outside India. Employs agents in India, but has no place of business in India. Now since avane kurturka, there is no other facts. This will again be like that Dabba question. Just employing agents in India, I can again interpret employing agents in India for what? In the previous question, you are employing agents in India to find customers. That means for place of business you are employing customer. In this question you are employing agents in India, but for what? Idume kudukla. So with based on the facts I will say this is not a foreign company. Check the answer. Adan kuduthirukana. Idukku foreign company kudutana, then I say adha adikanum. Okay. Fine. Not a foreign company. Nalla tappichitom. Okay. Understood? So you got clarity. இந்த மாதிரி ஒரு 40 question பண்ணா we will know. Questionல hint இருக்கும். இந்த மாதிரி no place of business. Agents எதுக்கு எம்ப்ளாய் பண்ணிருக்காங்க கொடுக்கல, not a foreign company. Agents to find business, foreign company. That's it. Okay. Company incorporated outside India, registered in Australia, authorized text to source customers and subsequently enter into contact. Now this becomes a All your confusion is solved in this question. Question 15. Understood? Second question and third question. Harish, clear now? That's it. Okay, Jan 21, CA final students. A company incorporated outside India and registered in Mauritius. Thailand, Mauritius. Okay. All the business models, financial strategy, and important decisions are carried and taken out at board meeting held only in India. Is it a foreign company? No. But look at this. Only board meeting is happening in India. No business. Board meeting, na, of course they will take decisions. அப்போ என்ன பண்ணுவாங்க போர்ட் மீட்டிங்கில்? வாட் எல்ஸ் தே வில் டூ கைஸ்? டிசிஷன் தான் எடுக்க போகிறோம். ஓகே, மொரேஷியஸ்லேருந்து இந்தியாவுக்கு வரான் பாருங்க கைஸ். தட் மீன்ஸ் அவனுக்கு மூட் இல்லை மொரேஷியஸில் ஒர்க் பண்ணுறதுக்கு. ஸோ ஃபார் போர்ட் மீட்டிங் இஸ் கமிங் டு இந்தியா, ஒர்க்கிங் அண்ட் கோயிங் பேக். வாட் இஸ் தி ஆன்சர் ஃபார் ஃபோர்த் ஒன்? குவிக்லி செக். இஸ் இட் அ ஃபாரின் கம்பெனி? நாட் அ ஃபாரின் கம்பெனி. ஃபாலோயிங்கா? இப்போ இந்த பிடிஎஃப் ஓப்பன் பண்ணாலே I think in the PDF itself is angry. On 31st we are doing workout page varamatingde. I'll open a different version of the PDF. I think I understood why. வந்துச்சா? இல்லை வால்யூம்லாம் கிடையாது, ஜஸ்ட் 31st நம்ம கிளாஸ் வைக்கிறோன்னு சிஸ்டம் தெரிஞ்சிச்சு. கிளம்புங்களான்னு சொல்லுது. பேஜ் நம்பர் 3 இதில் வராது. 15 தானே முடித்தோம் இப்போ, கரெக்டா? இன் திஸ் இட் வில் நாட் கம், டோன்ட் வரி. ஓகே, that PDF I made some changes by converting to Word and reconverting. Okay, fine. Phil Health System Incorporated, a foreign company registered in Australia and established place of business in India. The FS pertaining to Indian company for the year 31st March were prepared by the company. Answer the following question. Foreign company navane soltan. Okay. Whether accounts of company pertaining to Indian company should be audited? If yes, by whom? Different question. Audit needed? Yes. Sir, idu engen sir varudhu? In one of the sections I would have told few sections are applicable. Few sections are applicable, like books of accounts, audit, etc. I will read the answer. Where is it? Okay. What is the due date for filing audited FS with the ROC? 6 months from end of financial year. Are you following, guys? Ida in the previous workout in deposits. Deposits of which chapter? LLP la I did that dabba. So இங்கே தான் இருக்கும், இங்கே கரெக்டா? Yeah. So I would have given this dabba. Filing of FS and annual return instead of writing again. For a normal company, 6th annual return. Okay, FS பார்க்கலாம். Filing of FS in 137. For a normal company, 30 days from end of AGM. For a foreign company, 6 months from end of financial year. For LLP, 6 months from end of financial year. For LLP, additionally you will give declaration of solvency. For foreign company, related party transaction, repatriation of profit and transfer of funds. Comparative study. So answer is yes. What is the effect of contracts entered by Indian company if it has not filed FS? So if you are not compliant, then what will happen? 393 will operate. What will happen? Penalty will come, but apart from that, company cannot sue third party, but third party can sue the company. Which e-form and what period by which annual return of company has to be filed? எனக்கே ஞாபகம் இல்லை. Let's go check. FC4. Okay, now I will remember, guys. I will forget later. FC4 file பண்ணனும்னு சொல்றோம். Okay. It is just a one-off question like this. Jan 21. Let's cross check all the answers, guys. First is correct. Yes, audit has to be done in Indian operations. India business பண்ணீங்கன்னா டவுட்டே இல்லை, audit mandatory. Second question, within 6 months, correct? Third question, it shall not affect validity of contract. Third party, you cannot bring a suit on others, third party can bring a suit. 393. And last one, form is FC4 within 60 days from end of financial year. Are you following, guys? Understanding or sure? All of you clear, guys? Sanjay, understanding? என்ன எழுதுற? ஓகே, எழுதுறதுக்கு டைம் கொடுக்குறேன் நான். ஓகே, கொஷின் 17. எஸ் சஞ்சீவ், ரீட்.
TFA Limited, a company registered in Japan, started its operation in India by establishing a marketing division in Mumbai on 1st April 2021. Recently, the company decided to issue certain securities in India, therefore is planning to circulate in India a prospectus offering for subscription in securities of the company, assuming that all other formalities in respect have been complied with. Advise the person in change of Indian operation regarding the other documents required to be annexed to the prospectus in order to register the same, referring to the relevant provisions of the Companies Act and the rules made thereunder. Vaibhav Limited, a company incorporated in Singapore, is having a liaison officer in Delhi. The liaison officer seeks your advice regarding the documents to be filed with the register along with the financial statement under the Companies Act. Read with the Companies Act and foreign companies.
Both are repeat. Second question is basically 380 la what documents to file. Correct? What all documents? First one also இந்த பாயிண்ட் வரும் கைஸ். ப்ராஸ்பெக்டஸ்க்கு என்னெல்லாம் கொடுக்கணும்? அட்டாச்மெண்ட்ஸ், எக்ஸ்பர்ட், எம்டி அதான வரும். Assuming that all other formalities have been done, what are the documents to be annexed with the prospectus? Annexed வந்தாலே documents to be annexed with the prospectus is these 5 points. 389 registration of prospectus. Are you following guys? Same question, adhe annexure. Look at the same points: power of attorney, underwriting, then appointment of MD, material contract in last 2 years, and next is 3. Sorry, inga second question now. First question, what are the other documents required to be annexed in the prospectus? Another எங்க கீழேயா? இது கேஸ் 2 இல்ல, வேற கேஸ். செகண்ட் கேஸ் வாட் இஸ் இட்? அட்வைஸ் regarding documents to be filed with registrar. Okay, liaison office seeks your advice in what are the documents to be filed with registrar with the financial statement. Just now we saw, no, along with the financial statement, repatriation of profit, related party transaction and transfer of funds. Same thing is there in our book. Where it's there in the book? Here. Within 6 months you have to file. All these have to be attached. Same thing we have here also. Adan case 2. Are you following guys? Clear? Understanding? Because it's repetition, I am not spending much time. Are you understanding? First time படிக்கிறீங்கன்னா புரியுமா? Okay. Next. 18 minute came in exam. I think this is not in syllabus because RFC account we do. Oh, RFC Limited. Yeah, you can go ahead. Okay, this also is similar to that computation. Okay, quickly go ahead. Last 5 questions first.
RFC Limited has been incorporated in Singapore and has a business place in Mumbai. The company has issued 5 lakh shares of USD 100 each, consisting of 4 lakh equity shares, 1 lakh preference shares. The issued share capital is fully paid up except 5,000 preference shares where USD 50 per share is unpaid. RJW, an Indian citizen, is holding 26,000 preference shares which include 1,100 partly paid up shares, and R Limited incorporated in New Delhi is holding 2,23,500 equity shares of RFC Limited. The Registrar of Companies issued notice under section 379 of the Companies Act addressed to the person whose name and address have been deleted to the Registrar of by RFC Limited for compliance under Companies Act for foreign companies. The above notice was delivered at the address which was given by RFC Limited to Registrar of Companies. Answer the following: whether RFC Limited is a foreign company, whether service of notice by the Registrar of Company is valid.
Okay, adhe question now. We have to compute if 50% is there or not. My denominator is simple. Totally, it is much more easier than that question. Denominator is 5 lakh shares. In that 4 lakhs is equity, guys. So 4 lakhs into 100 plus remaining 1 lakh is how much? Preference. So I will do 1 lakh into 100 poduvana. No, 50 remains unpaid. So into 50. My denominator will become how much now? Oh, only 5,000 is unpaid. Sorry, I didn't read that. So my denominator will slightly change. It will be 95,000 preference shares into 100 plus 5,000 into 50. Are you following, guys? Correct? Except 5,000 preference shares of 50 is unpaid. So what is the denominator coming to? Quickly compute, guys. 4 lakhs into 100 plus 95,000 into 100 plus 5,000 into 50. Total capital base how much? 4 crore 4.9. Idha varda. This is what we got. So we did 4 lakhs into 100, 1 lakh into 95,000 into 100 and 5,000 into 50. This is what you all got denominator, guys. Now we have to find a numerator. In this question, numerator is much more easier because they have given only Indian citizen has 26,000 preference shares, in which 1,100 is partly paid up. So how I will do 1,100 partly paid up into 50 plus remaining is how much? 24,900. 26,000 minus 24,900 into 100 plus this Ronte is having 2,23,000 equity shares. So I will do 2,23,000 into 100. 23,500 into 100. Are you understanding how to do computation, guys? Now you might be looking at me. I will do an exam, but you should get the same numbers. What is the numerator now? 2 crores. எங்க போட்டிருக்கான் கம்ப்யூட்டர் பண்ணலையா அவன்? Next page liya. 2 crores 48 lakh 95,000. Same thing. நம்ம சொன்ன அதே தான். இந்த 26,000 into 100. 26,000 1,100 into 50. 2,23,500 into 100 and preference balance. In the computation தான், guys. This one. This is going to be my numerator. Are you understanding what we are doing? Hello? Okay. Therefore, percentage is coming how much, guys? 50 point? More than 50, yeah. Therefore, it is deemed to be a company incorporated in India. Sir, how do you compute? Numerator will be 24,89,500. Sorry. Numerator is 2 crores 48 lakh 95,000. Denominator is going to be 4 crore 97 lakhs 50,000, which is more than 50%. Are you understanding? All of you surely getting it. The catch is in both the questions like this, preference shares was partly paid up. This also is past exam question now. Yes, May 2022 in CA final. Now you tell me, at least this question is worth an exam for 5 marks. Correct? Okay. Daneshwar Purida, sure? Sure, 100%. Sure, அப்படி தெரியல எனக்கு பார்த்தா ஒன்று. Daneshwar தான் கேட்குறேன். புரியுதா? Okay. ஆமாம்மா 50% or more because the wording says not less than 50%. Honestly understanding. See, usually I will not solve like this. Neeta will put one table and write. எப்போ சார் நீங்கள் நீட்டாக போட்டிங்கன்னு கேட்பீங்க. But we will do it like that if we have time in regular batch. Okay. Fine. You got the logic. Question number 19. MNO, foreign joint venture, established place of business in India following IFRS. CA final question. So they are giving that. And its financial statements being prepared in German language. Desires to know the following things. Okay. Submiss of FS in German language. What you should do? Convert to English. Format of FS as per IFRS. What you should do? Convert to Indian accounting standards. Convert to India. How authentication of FS is to be done? We will see that. Whether documents can be submitted to register office at Mumbai? No. Delhi. Okay. Let's go check. It has to be converted to English. Second, the consolidation of FS shall be accordance with Schedule 3 and applicable accounting standards. IFRS you have to change. Okay. Next. What is the third point? In the provision only, I don't think we have in syllabus. This is something we don't have, guys. Final and vandirukku. I don't think we have this anywhere. Leave this part. Okay. Fourth one, can I give in Mumbai? Cannot be submitted in Mumbai. Delhi you should submit. Are you following, guys? Clear? I think this is not there. Yeah, we don't have this oaths and feeds. Okay, leave it. Illana, you just leave it off. Okay. If I told final questions, that's why. Next. Question number 20. Few more to go. Correct? Yes, read it, Sanjeev.
CNC Limited is a foreign company having its place of business in Mumbai and Ahmedabad in India. It has amended its MOA on 1st June 2022 and closed the branch office situated at Mumbai. Referring to the provision, advise the following. Compliance procedures as regard to amendment of MOA, compliance procedures as regard to closure of Mumbai office and discontinuing submission of documents to register of companies afterwards.
Very simple. Basically, 380 la irukra information you are amending. I told whenever you amend articles or MOA or when you are closing Mumbai office and discontinuing, you have to inform ROC again within 30 days. It will be the same thing, section 380. Whenever there is going to be amendment of MOA or anything, closure, you have to inform ROC within 30 days in form FC2. FC1 is first time, FC2 is amendments. Okay, understood guys? That's it. Question number 21. RTP May 24. Finally, new syllabus question for CA Inter. என்ன கேட்டிருக்கான்னு பார்க்கலாம். Yes.
Fine Publishers registered in Tokyo began operating in India during the financial year 2009. The company has duly submitted all necessary documents to the register within specified due date. On 1st March 2023, Fine Publishers has shifted its principal office in Tokyo. Is Fine Publishers required to undertake any steps due to change in address of principal office? Give your answer in reference to provisions of Companies Act.
என்ன கேட்குறான்? Registered in Tokyo, began operating in India during the financial year. Company has duly submitted all documents as per section 380. On 1st March, Fine shifted its principal office Tokyo. அவங்க ஊரில் head office they changed in Tokyo. Are they required to give information to ROC? Go to section 380 and see, am I giving details of, look at this, point 5. Full address of the company in India which is deemed to be principal place in India தான் கேட்டிருக்கான். Which point? The name and address of the names of the address of one of the more person resident in India authorized in the point இல்லையா? Oh, it's here. Then full address of the registered officer, principal office of the company. இதான் அந்த Tokyo. That means if this also is changing, any alteration you have to intimate ROC. Are you following guys? Let's check the answer, check if it's correct guys. Within 30 days of such alteration you have to intimate ROC in form FC2. Form number லாம் கொடுக்கல. So within 30 days. Are you following guys? Understanding all of you? New question, inter question. Okay. Again MTP March 24. New syllabus, inter question. Gatto Limited dealing in colored contact lenses is a company incorporated in Singapore. It is having branch office in Kolkata. So foreign company. The company approached its legal department, relevant provisions of the Companies Act, for filing of financial statements. You will file within 6 months from end of financial year. You will give following 3 attachments: related party transactions, repatriation of profits and transfer of funds. Are you getting it guys? Easier? Hello? Getting clarity guys? Same thing. பாருங்க இன்டர் எப்படி ஈஸியாக கேட்குறோம். Straightforward questions. Still no final. They have twisted everything. But you are able to answer. Okay. Same thing. Repatriation of profit, all of that. 23. MTP April 24. Again, go ahead.
What are the documents that must be annexed to a prospectus offering for subscription securities of a company incorporated to be incorporated outside India as per the Companies Act 2004?
What has to be annexed? Already 4-5 வாட்டி பார்த்துருக்கோம். What has to be annexed? These points. Expert, chairman, material contracts in last 2 years. Straightforward, direct question. Just know it came to Interno, foreign company. So he's asking, don't worry, it is going to be easy, those things. As time keeps going, that computation and all will come. Okay. That's it, huh? Super. So with this we are done with foreign company. Super, done guys. Now Companies Act actually done in workout guys. Super, all the questions done. Thank you guys, recording students. Happy New Year. Hi guys, welcome back to workout batch. Today we are going to discuss deposits chapter. We have around 30 questions. Our target is to do it in 45 minutes to 1 hour. இப்படி தான் சார் எல்லா வீடியோவும் சொல்கிறீங்க. Okay. Now ABC is having a net worth of 120 crores and wants to accept deposits from its members. From its members, do I have any restriction? Yes, only limit is percentage is there, but members we can. Directors of company have approached you to advise them as to what special care has to be taken while accepting deposits in case the company falls within the category of an eligible company. Now, can this company get deposit from members, sir? Yes or no? Yes. What percentage? ABC from members, sir. Public from members, maximum 35%. Correct? Huh? If I go to this table, so public company from non-eligible from members is 35%. Correct? Huh? Public non-eligible from members is 35. Eligible also from members you can take up to 35%, provided public is 0%. So in this question, yes, we can accept. And this percentage is of paid up share capital plus free reserves plus SP. Since nothing is given, I will assume this 120 only is net worth of the company. Okay. Then they are asking as to what special care has to be taken while accepting such deposit from the members in case their company falls within. So if it is an eligible company, exactly what you discussed. If it's eligible company, this composition will come. From public maximum 25, therefore from members 10%. Let's go check the answer. Straight away I'll go to the answer, guys. Look at this. Is it eligible company first of all? Yes, eligible company net worth should be more than or equal to 100 crores. Look at this. Eligible company, you remember the limit, net worth more than or equal to 100, turnover more than or equal to 500. Is this eligible company? Yes, because net worth is more than. Therefore, since it is an eligible company, maximum you can get from members exceeds 10% of paid up share capital. Are you following, guys? Clear? This assumption is because members is public is going to be 25%. Look at this. ABC has to ensure deposits from its members shall not exceed 10%. Are you following, guys? Okay. Anything else important in this question? Yeah, they are also defining. So exam, what you will write if a question like this comes, you will define what is eligible company and then you will write the percentage 10% and 25% and conclude for members you can go up to 10%. Are you following, guys? Okay. Next. Discuss the following situation in light of deposit provisions contained in Companies Act. Polestar Traders received a loan of 30 lakhs from Rachna, who is one of the directors. I told you in the chapter irukkiradhe two question. Depositor, not a depositor. Procedure for deposit. Correct? Now, you will tell me they received 30 lakhs from Rachna, who is one of the directors. Can director give loan? Is it a deposit, guys? Go back to our list. What is deposit? What is not a deposit? In what is not a deposit? Look at this. Money received from directors and relatives of a private company is not a deposit. Go back here. This is a private company. Polestar, it is not a private company. So is it a deposit, guys? Yes. Let's go check. We will be wrong many times, guys, in over here. What is the answer? என்ன கொடுத்துருக்கோம்? Where is it? We'll go back here. Money from directors of private company, then promoters loan, not this point. Okay, we'll come here. In terms of rule 21C8, 8 clause should be here. Okay, what they're saying? Amount received from a person who is director of the company at the time of giving loan to the company shall not be treated as deposit if director furnishes to the company at the time of giving money a declaration that amount is not given out of funds acquired by him by borrowing or accepting loans or deposits from others, and further the company shall disclose details of money so collected in board's report. What they are trying to say, when director, basically it's a loan, correct? When director is giving a loan and if they disclose that it is a loan, it will not be a deposit. If you disclose it's a loan, it is not a deposit. And one more point, I will come to that a little later. We will have this in the common points. One point will be there. That point also they are disclosing. I'll show you that one. This one. In common points, point number 8 only they are disclosing over there. அவன் என்ன சொல்றான், company shall accept deposits only when the depositor, here in our case director, shall submit the application and also state that deposit is made from money which is not borrowed from any other. That means, a simple example, let's say I have Bajaj Finance is there, Bajaj Finance. I want to make a deposit, let's say I am making a deposit to Bajaj Finance. I should not be borrowing from SBI and depositing in Bajaj Finance. The money I am depositing should be more like a saving. Now I cannot take a loan and I cannot deposit that. Are you following? That's what they are giving over here. If you see, if you're thinking where is this point in the book, the money given out of funds acquired by him by borrowing or accepting loan from others. That means I am not borrowing from others and giving the money. Are you following, guys? If such money is given, they will not accept deposits. That's what common point says. Company will accept only when you submit application that it is not a borrowed money. Are you following, guys? Next, it is in order of the Diamond Housing Finance to accept and renew deposits from public from time. It is in order for the Diamond Housing to accept and renew from time to time. What are they saying? Value inga irukku, value kudukliye. Okay, adhe question. Received loan of 30 lakhs from Rachna, one of the directors. Okay, what is the question? Further, it is assumed that she has furnished to the company at the time of giving money a written declaration. Oh, adhe point. Okay, case 1 again assumed. Case 2, Diamond Housing Finance Limited to accept and renew deposits from time to time. Okay, I will show this also in the book. This whole chapter is not applicable to a few companies. What are those companies? Banking company, NBFC, housing finance company and other companies registered with RBI. For these 4 companies, this whole chapter of deposit is not applicable. What is the logic? Because இவங்களோட வேலையே to collect and give loans. So for them it's not applicable. That's why they are saying it is assumed that National Housing is a registered National Housing Bank. Therefore, it is exempted from this chapter. They can go ahead and give deposits based on the provisions they have. Are you following, guys? Clear? Next, question number 3. Yes, Sanjay, read it fast.
NAM Private Limited is engaged in the business of manufacturing household plastic goods. The books of accounts of the company provides that aggregates of its paid up capital, free reserves and securities premium account is 35 lakhs. The company intends to accept deposits from its members to the extent of 35 lakhs. Advise the company whether it can do so. Support your answer as per the provisions of Companies Act 2013.
Simple. I told you most of the questions will come from that key table I told you. Now, this company is having paid up share capital plus free reserves plus SP. How much? 35. What type of company it is? Private. Private now they can accept 100%. So they can they get 35 lakhs? Yes. That is the conclusion. Since it is a private company, it can accept up to 35 lakhs from members. 2 mark question. Next question. Yes, Sanjeev, go ahead.
A government company which is eligible to accept deposits under section 76 of the Companies Act 2013 cannot accept deposits from public exceeding 25% of the aggregate of its paid up capital, free reserves and securities premium account. State with reason whether the following statement is true or false.
Answer true or false? False, because for government company it is 35% in any ratio. Correct? ஞாபகம் இருக்கா guys? 35% in any ratio. Okay. So, as per rule 3.5, a government company's limit is false. Maximum is 35%. Are you understanding, guys? Next. Question 5. I'll read this. Comment whether it is deposit or not a deposit again. Okay. 5 lakh raised by Rohit Limited through issue of non-convertible debentures not constituting a charge on the asset of the company and listed on a recognized stock exchange. We would have seen in the list. Somewhere it will be there in the list, guys. It should be there. Listed non-convertible debentures without a charge on the asset is not a deposit. So is this a deposit, guys? No. I will just mug up the terms. Listed non-convertible debentures without a charge. Logic we discussed only in regular class. Here point irka, that's it. Next, 2 lakhs received by Rishi Limited from its employee Tarun, who draws annual salary of 1,50,000 as non-interest bearing security. We will see security deposit from employee without interest not exceeding annual salary. What is the annual salary? 1 lakh. He gave deposit of which is more than annual salary. Therefore, yes, it becomes a deposit. Are you following? His annual salary is 1,50,000. What if the money security deposit given is 1,25,000? Then not a deposit because it's less than annual salary. Are you following, guys? What if it's 1,25,000 with interest? Then it becomes a deposit. Are you getting it, guys? Are you all following? See, the point is the deposit from employees cannot, without interest, should not exceed his annual salary. His annual salary is 1,50,000. So maximum he can give how much? 1,50,000 only he can get. How much he took? 2 lakhs. That means it crossed annual salary. Therefore it becomes, yes, it is a deposit. Are you following, guys? Clear? Doubt irka? So that is the first case. So for this answer is yes, it's a deposit. Now I am bringing one more case. If deposit is 1,25,000 without interest, is it deposit? No, because it is less than annual salary. If it is 1,25,000 with interest, then it becomes a deposit. Are you getting it, guys? So first case, it will not be a deposit. Second case, it is more than annual salary of 1,50,000. 2 lakhs is more. Yaar kudupa? Employee. எனக்கு வரதே annual salary 1,50,000. He will give me 2 lakhs as deposit. That means something company is doing. Company gave money for him to give the money. Okay. Next, who all cannot be appointed as a trustee for depositors? This also we saw in the class. Everything is there in the book, guys. Who cannot be deposit trustee? All these points: director, KMP, shareholder, material pecuniary relationship, guarantee. Basically, to put it in simple, these are all people who have some kind of interest with the company. The deposit trustee should be independent without any interest with the company. Are you following, guys? Okay. Next, question 6 is done. So on the list now, straightforward question. When they asked, MTP is when they asked. Next, question 7. Yes, Sanjeev, read it.
The promoters of J Limited contributed in the shape of unsecured loan to the company in fulfillment of the margin money requirements stipulated by State Industries Development Corporation Limited for granting loan. In the light of the provisions of the Companies Act 2013 and rules made thereunder, whether the unsecured loan will be regarded as deposit or not. What will be your answer in this case? The entire loan is obtained from SIDCL is repaid.
We would have seen this point also in what is not a I told you question 1 da what is not a deposit illana keela varudhu on the table. Here if you see, I would have told one point 7 in class. We will discuss this towards the end. Wherever you studied, promoters loan by way of unsecured loan due to stipulation imposed by lending institution. I also gave loan to my company because the lending institution told I have to give a loan. Do you remember this, guys? So that's what they are saying here. It is not a deposit. How do you know it's a stipulation? Promoters of JL contributed unsecured loan to the company for fulfillment of margin money requirement. Stipulation, put a condition. Are you able to connect this with the point, guys? Are you able to answer, guys? Sure. Okay. Therefore, it's loan provided by promoters themselves or relatives of both. Such exemption shall be available only till the loan is repaid. We discussed this also. Till the loan is repaid. If the financial or lending institution you repay the loan, then promoter's loan also should be repaid. That's what they are saying. Till the loan is repaid, that exemption is available. After lending institution, let's say this SIDCL, after you repay that, if promoters of J Limited loan is still not repaid, then that unsecured loan will be taken as a deposit. Are you following, guys? Clear? Is it going fast? Are you understanding? Faster ka? Fine. Sure, okay. Those who are watching online, of course, revise deposits and watch. சும்மா ரேண்டமாக டெபாசிட்ஸ் போட்டிங்கன்னா அவள் தான் இருக்கிற கான்ஃபிடன்ஸும் போயிடும். Question number 8. Quickly, Sanjeev. Yes, just read those 2 points, 1 to 2.
2 lakhs received by Yash Limited from its employee Mr. A, who draws an annual salary of 1,50,000 as a non-interest bearing security deposit under a contract of employment.
Repeat question. Just now we saw same thing. Next.
Textile Trader Limited received a loan of 30 lakhs from R, who is one of its director.
Director loan. What is that? Just like previous point. If they give disclosure, then it is not a deposit. We'll go check here, guys. So annual, first one is definitely repeat question. Annual salary 1,50,000. I got 2 lakhs. Therefore, it is a deposit. Okay. Next, any amount received from person who is a director shall not be treated as deposit if they furnish at the time of giving money declaration that amount is not given out of the funds acquired or out of the funds from some other borrowings. Just now we saw that. Next, question 9. Yes.
Shasha Private Limited received 3 lakhs from one of the relatives of a director. The said relative has furnished a declaration that the amount was received by him from his mother as a gift. Decide as per the relevant of provisions of Companies Act 2013 whether the said amount received by the company will be considered as deposit or not.
Is it deposit, guys? Yes or no? No, it is not a deposit. Why it's not deposit? Because he has furnished the declaration and the money is not from borrowings. It's from a gift. That means it is a proper, what to say, not a deposit case. Okay. What is the answer? Yeah, it is not a deposit. Are you following, guys? Wherever we get repeated questions, we of course we're going to go little fast. Next, question 10. Yes, go ahead.
Rashmika Limited received share application money 50 lakhs on 1/6/2021 but failed to allot shares within the prescribed time limit. The share application money of 5 lakh received from Mr. Kumar, a customer of the company, was refunded by way of book adjustment towards the dues payable by him to the company on 30/7/2021. The company secretary of Rashmika Limited reported to the board that the entire amount of 50 lakhs shall be deemed to be as deposit as on 31/7/2021 and the company is required to comply with the provisions of the Companies Act 2013 applicable to the acceptance of deposit in relation to this amount. You are required to examine the validity of the reporting of the company secretary in the light of provisions of Companies Act 2013.
Yeah, important question. Now, the question starts off with distraction. Rashmika Limited. நீ எக்ஸாமில் இருக்கும்போது you will think about something else. Question focus போயிடும். Examiner is very smart in doing all these things. What is they saying? Rashmika Limited got application money of 50 lakhs on 1st June 2021 but failed to allot shares. Here the provision that they are testing is, if you see in what is not a deposit in our book, 4th point, application money for subscription. If it's private placement up to 75 days, if it's other case up to 45 days, if the same is not refunded, it becomes a deposit. That's test pandrom. Okay. Rashmika got 50 lakhs on 1st June 2021 but failed to allot the shares within the prescribed time limit. That means if you have to refund the money, the share application money of 5 lakh received from Kumar, a customer, was refunded by way of book adjustment towards dues payable by him to the company on 30th July, almost after 2 months. கரெக்டாக ஜூன் அண்ட் ஜூலை என்ன பண்ணியிருக்காங்க, இன்ஸ்டெட் ஆஃப் பேயிங் ஹிம் 5 lakhs இன் கேஷ், அவன் கொடுக்க வேண்டிய காஸ்ட்டில் இந்த மணி ஹி ஹேஸ் டு கிவ், வி ஹேவ் adjusted the same. The company secretary of Rashmika reported to the board that entire amount of 50 lakhs shall be deemed as deposit and company is required to comply with the provisions of Companies Act. I am 100% certain that 50 lakhs minus 5 lakhs, 45 lakhs will definitely be taken as what? Deposit, because the time has gone. The only question is, what about that 5 lakhs which is book adjustment? Is it deemed refund? Are you getting what I am saying, guys? Okay. Question purida? Are you all following, guys? Question understood? Yes, Sanjay, understanding question? Which question? 10th. Okay. Fine. Now, we'll go check the answer. Now, okay. What is the time period? 1st June and end is 30th July. It was adjusted on 30th of July Now what is left? As of அவன் என்ன கேட்குறான், in the board he is reporting only on 31st of July. So I want to know as of 31st July only. As of 31st July available balance is only 45 lakhs. Is it deposit or not a deposit? Let's check the final answer. The company secretary is not correct entering the entire amount of 50 as refund. That means they are trying to say minus the 5 lakhs and only 45 lakhs can be taken as deposit. Any adjustment for any person shall not be treated as a refund. Thus amount of 5 lakhs adjusted against payment due to receipt from Kumar cannot be treated as a refund. And then what they are saying, now they are talking about provision. If such application money or advance is not refunded to the subscribers within 15 days from completion of 60 days. This private placement. Is this private placement or no? They have not mentioned if it's private placement. Ama allotment of shares analum 45 days standichu. 50 lakhs also will be deposit. Deposit eppadi? Illa ena see deposit is what he paid me. I am adjusting with what I have to pay him. I will come to it. Let's go through the answer. Okay. ஒரு question தானே இருக்குங்க. Okay. And they are asking, yeah. ஆமா 60 plus 15 only is correct. ஆமா only after 15 days. Okay. No, we'll go through the whole answer. See, any amount received towards an accordance for subscription of securities application money, so long until it's appropriated, we can keep it there. Next, it is clarified by explanation for which application money of securities received cannot be allotted within 60 days from receipt of application money or advance for such securities, if not refunded to subscribers within 15 days after 60 days, that is treated as deposit. So here they are taking as 60 plus 75 days. They are assuming this to be a private placement. Where they are assuming as private placement, Rashmika Limited received money only from one shareholder. Okay. No, they have not given private placement. Okay. They are assuming it is what? Private placement over here. Next என்ன சொல்றான், further it is clarified any adjustment of the amount for any other purpose shall not be treated as a refund. In the given question, Rashmika has received 50 lakhs as share application money on 1st June, failed to allot within the prescribed time. Further on 30th July, after 60 days, the company adjusted 5 lakhs towards the due. This full facts rewritten. Above first they wrote provision. Now they are coming to the analysis. In light of the above question, look at the analysis, guys. Such application money or advance is not refunded to the subscribers within 15 days. That means 60 days is completed. You still have left, still not yet refunded. Such amount shall be treated as a, if you don't refund, it becomes a deposit. In the question, the prescribed limit of 60 days will end on 31st July and the company still has 15 more days for refund. Only after 15 days amount will be treated as a deposit. Are you getting it, guys? அப்போனா இன்னும் டைம் இருக்கு. Therefore they are saying company secretary தப்புன்னு சொல்றாங்க. ஜெனரலா CS வந்தாலே தப்புன்னு வந்துரும் நம்ம CA எக்ஸாம்ல. ஓகே. So as of 31st July, is it a deposit, guys? No, you still have time until 15th of August you have to wait. Any adjustment of amount for any other purpose shall not be treated as a refund. Very simple. In private placement or in allotment of securities, did we anywhere learn that instead of refunding the money, I can adjust with something else? Where we learnt adjustment is possible? 127 let dividend payable can be lawfully adjusted with dues. Apona, if law is specifically saying something in 127, you can follow that only for 127 for dividend. In section 42 or 39 private placement allotment, nowhere we studied that refund money can be adjusted. Refund money has to be refunded. So they are saying this refund is not valid. We will not consider it as refund. 50 lakhs is fully still available. Are you following, guys? Understood the question? All of you clear? Anybody has a doubt, feel free to ask, guys. Yes. Okay, now his doubt is, sir, how can I assume it is private placement? அது purely assumption only, guys, because நீங்கள் study mat படிச்சாலும் they would have given allotment pending, 45 minimum subscription is not received. Okay, here what they are saying, okay, here what interpretation is taken now, 45 days if subscription is not received, application money for 75 days in case allotment is pending. So they are taking that kind of interpretation. Allotment பண்ணலனா 75 days, minimum subscription not received na 45 days. On that lines here question is saying, but fail to allot shares. So we are going with that. Are you following, guys? Okay. Next, question number 11. Yes, read it.
Enumerate the amounts which, when received by a company in the ordinary course of business, are not to be considered as deposits.
Full list. On the full list of 14 points, we are not going to go through that, guys. Full list is done. Next, question 12. Yes, read.
A Limited, having a net worth of 80 crores and turnover of 30 crores, wants to accept deposit from public other than its members. Referring to the provisions of Companies Act 2013, state the condition and procedures to be followed by A Limited for accepting deposit from public other than its members.
This case, can the company accept money from public? Is it an eligible company? Eligible company net worth should be 100 crores or more. Turnover 500 crores. Inga net worth 100 crores ada? Illa. Turnover crores ada? Illa. So therefore it is not an eligible company. Thank you. Bye bye. Next question. Yes, read it.
XYZ Private Limited may accept the deposit from its members to the extent of 60 lakhs if the aggregate of its paid up capital, free reserves and securities premium account is 60 lakhs.
Hold on, correct? True or false? Yes, paid up share capital, free reserves and SP is 60 lakhs. You can accept up to 100%. So 60 lakhs is yes. 2 marks. So far, which question is challenging? Or which one we have to think that application money on the Rashmika? So other than that, so Rashmika mark panni vechukkonga, guys, exam. Next
A government company which is eligible to accept deposits under section 76 of the Companies Act 2013 cannot accept deposit from public exceeding 25% of the aggregate of paid up share capital.
Same, repeat nee stop pannenu elo oru percentage 35%. Online recording, I hope you guys are following. Okay, any feedback for Sanjeevna solunga, guys. Yes, question 14.
Rinda Limited is a company manufacturing orange and strawberry candies for kids. Now the company wants to expand its business and start manufacturing of 10 more types of candies. The company has raised 1 crore through the issue of non-convertible debenture not constituting a charge on the assets of the company and listed on stock exchange as per applicable made by the Securities and Exchange Board of India. Advise whether the above amount of 1 crore will be considered as deposits.
Deposit no. இதுக்கு இந்த candy, strawberry, orange லாம் உன்னை டிஸ்ட்ராக்ட் பண்ணுறான் எக்ஸாமில். சடன்லி இன் எக்ஸாம் யூ வில் திங்க், ஓ ஸ்ட்ராபெரி கேண்டியா, இன்னைக்கு எக்ஸாம் முடிச்சு சாப்பிட்லாமா? ஸோ ஃபைன், ஓகே, எஸ் சொல்லுப்பா. ஓகே, டன் கைஸ். ஸோ இட் இஸ் நாட் அ டெபாசிட். நோ நீட் டு ரைட் அபவுட் வாட் Vrinda Limited, orange, strawberry candy, all of that. Fine. Next, question number 15.
Fire Electricals Limited, having paid up capital of 1 crore, availed a term loan of 10 lakh from ABC Bank Limited to purchase electrical items. Mr. Tar, one of the directors of the company, is the opinion that it shall be considered as deposit. It is contention correct?
Is correct. One of the first exception என்ன சொல்றான், amount taken from bank as a loan facility. Loan வந்து loan pa, not a deposit. That's what we have to say in terms of the provision. Term loan of 10 lakhs from bank is a deposit is not correct. Now இதெல்லாம் 2 mark question. Look how they presented. இதுக்கு facts support, analysis போட்டு conclusion போட்டு time will get over. First point, straight away provision. As per deposit rules, loan facility is not a deposit. In view of the above, Tar of loan office is not a deposit. That's it. 2 marks. Are you following, guys? Harish, clear? Next. 3 repeat. Okay, question number 16. So this chapter is a repeat chapter. That's I told no, there are only 2 types of question. Depositor, not a depositor. Key table. That's கேட்டிருக்காங்க in exam most of the times. Okay. what they're asking, is this a deposit? 5 lakhs non-convertible debenture not constituting a charge. நான் மகர்ஸ்னேன் இப்போது அந்த மாதிரி non-convertible debenture listed எங்கே இருக்கு? listed non-convertible debenture charge இருந்தா what is it? Not a deposit. Okay. 2 lakhs 1 lakh 50 அதே நம்பர் மாத்தாம கேட்குறான் இந்த எக்ஸாமினர். It came in November 19 and May 23 for 6 marks in exam, guys. Those attempts they were lucky. Okay, November 19 and May 23. Amount of 3 lakhs received from a private company from a relative of a director declared by depositor out of gift received from his mother. If declaration is given, it is not a deposit, but it is a private company here. Let's go check the third answer alone. Okay, not a deposit, huh? By private company relative of director. Fifth line, huh? Will not be considered as a deposit. If you give a declaration, it will not be taken as a deposit. Are you following, guys? Okay. Are you actually understanding, guys? Hello. Next question number 17.
Wiki Limited engaged in the business of consumer durables. It is managed by a team of professional managers. The company has not made default in payment of statutory dues, repayment of debentures, institution loan with interest. The company advertised a circular in the newspaper dated 20th September 2020, inviting the deposit from the members and public for the first time. The latest audited financial statement of the company revealed the following data. Paid up share capital 70 crores, securities premium 20 crores, free reserves 20 crores, long term borrowings 50 crores. The company in the advertisement invited public deposit for a period of 4 months plan A and plan B for 36 months. Explain the term eligible company and calculate the maximum amount of deposits that can be accepted from publics non-members for plan A and plan B based on the latest audited financial statement under the provisions of Companies Act 2013. Calculate the maximum amount of deposits Wiki Limited can accept from the public under plan B in case it is wholly owned government company under the provisions of said act.
Those who have been seeing workout batch from first will know November 20 pavamana attempt. In every chapter இருக்கிற difficult question was in November 20. அதுவும் கோவிட் இயர். கோவிட்ல கஷ்டப்பட்டு May 20 attempt was cancelled. Then they came to November 20 to see all these questions. Opt out பண்ணி Jan போயிருப்பான். Okay, fine. Now what is this question basically saying? Plan A, plan B and all, don't get confused. If you are issuing deposits from public, of course you can give a newspaper advertisement. That provision also we have, circular ad can be given. Plan B is nothing but government. Government, what is the percentage? 35. Plan A என்ன சொல்றான்? Explain the term eligible company and calculate maximum amount of deposit accepted from public non-member for plan A. That means how much percentage? 25%. Correct? So first point வந்து public கிட்ட எவ்வளவு வாங்க முடியும்? 25%. Oh, for plan A and plan B based on okay fine. So public na 25%, government na 35. What is plan A and plan B? Companies and advertisement for a period of 4 months plan A and plan B is 36 months. Excellent. அப்பனா 4 months is less than 6 months. How much you can accept for that? Only 10%. Let's do all the calculations. Here, long term borrowings, what to do with that? Nothing to do with that. I will take only paid up share capital, free reserves and securities premium. It is 70, 90, 110. So first in the 110 I want to find out 25%. I want to find out 35%. I also want to find out 10% short term. How much you are getting? 11. Then 25% is how much? 27.5. Correct? 27.5. 110 into 35. Thank you. 38.5. So the three answers will be over here. 25% will be 27.5. 35% will be 38.5. Within this, if you want to go for 4 months now, sublimit will be 11. Let's go check. I don't know if it's correct, guys. We will make mistakes. Okay. First one. So I want to look at the provision. First is saying, is eligible company. First of all, Wiki Limited. Advara check pannu. Correct. I missed to check. Is it an eligible company? Is the net worth more than Yes, with a 110 vanduche. So it's more than 100 crores. That means eligible company. Only then this percentage will be applicable. Okay. So come down. So first provision what he is saying, it is an eligible company. Is it an eligible company or not eligible company? Then come down. He is saying this answer they are not writing full provision, full analysis, because there are, whenever multiple cases are being asked within the same question, multiple cases, you follow the strategy of provision analysis, provision analysis, provision analysis. So here second paragraph he is saying total is 110. That's what we are doing. Therefore it is an eligible company in conclude pandram. Next is saying tenure for which deposits can be accepted 6 months to 36 months, and then if it is going to be less than 6 months, 4 months na up to 10%. That also, look at this, shall not exceed 10%. Why are we writing this? Because first question la ketirukam, can I go for 4 months? So I am explaining that normal provision is 6 to 36 months, less than that 4 months is possible. Now again come back to provision, that again they are saying maximum amount of deposits from public, it will be how much? 25%, and from government how much it will be, guys? 35%. Now look at all the computations. First for plan A, where we wanted 10% is 11 crores, we got the same answer. Then for plan B, 25% of public, 16 point. Okay, so no, I'll just tell you what it is. So 27.5 is the total we got. In that 11 is already short term, so how much is left? 16.5 is the remaining I can get from public for more than 6 months. So he is saying 16.5 is the maximum amount of deposits, because both are plan A. Sorry, this is plan B. Plan A is for 4 months, plan B is more than 6 months, which is for 36 months. I think plan A and plan B are for the same case, correct? In the one case I want for plan A and plan B. Apana overall is 27.5. In the 27.5 I will do 11 for 4 months, 16.5 for 36 months. Are you following, guys? Last government we got answer 38.5. Answer is 38.5. Are you following, guys? So this answer lies in how you present it, because computationally we are getting it correct. So how will you present, guys, if this question, if it comes in exam? First you are writing definition of eligible company, and then you are saying analysis. Yes, this is eligible company, we can proceed. Next again I am writing the time limit 6 months to 36 months, along with the exception less than 6 months na 10%. Then again I am writing the provision for in the first case on the 25% provision 25% and 10% provision, and then again I am writing analysis computing for 25% minus 10% and 10% separately, correct? Then again I am writing provision for government company, how much? 35%, and lastly I am writing analysis for government company. Are you following, guys? I am just giving you the flow. So you write provision, introduction, eligible company is done. Then relevant provision analysis. Sir, can I write normal way? Write the full provision, write full analysis. That is also fine. But cases where there are multiple questions, provision analysis makes it easier for the examiner. Following, guys? Okay. Next question 18.
Bhupendra, one of the directors of Moon Technology Private Limited, a startup company, requested his close friend Paras to lend the company 20 lakhs in a single tranche by way of convertible note repayable within a period of 6 years from the date of its issue. Advise whether it is a deposit or not.
Answer is it a deposit? Will go one by one. Which point? Deposit or not a deposit? Let's startup point. What is startup point? Startup company more than 25 lakhs from single person in single tranche. Here you are getting only 20 lakhs in a single tranche from convertible note payable within 6 years. All that is fine. It should be more than 25 lakhs. Here it is only 20 lakhs. Therefore, is it a deposit, guys? Yes. Look at the answer. We will immediately cross check. Deposit. Provision answer another. Received 20 lakhs in a single tranche by a convertible note which is repaid within 6 years. This amount received below threshold of 25 lakhs. Hence, amount of 20 lakhs shall be considered as a, it is considered as a, that's what we concluded, no. It's considered as a deposit. Adana conclude pannirkom. Yes. Only if it crosses 25 lakhs, then it is not a deposit. Correct only, no, guys. Case 1, correct. See, what is the provision saying? It has 4 conditions to call it not a deposit. What are the 4 conditions? First, startup company. Then they should receive more than 25 lakhs. Second. Third, single person, single tranche. And fourth, either that money received should be for equity shares or it should be for repayable within 10 years from date of issue. Here, it is within 10 years. In the question, it's within 6 years. Single person, satisfied. Single tranche, satisfied. Startup, satisfied. What is not satisfied? 25 lakhs. It should be more than 25, but it's only 20 lakhs. Sir, Mala they wrote it is not a deposit. Illa, idu provision eldran. He's writing 25 lakhs. Idu deposit illa nu solli full eldran. And then he's writing down below. It is a provision. Next.
Shriram Readymade Garments Limited wants to accept deposit of 50 lakhs from its members for tenure, which is less than 6 months. Is there any possibility to do so?
Yes. What is the possibility, guys? Less than 6 months, but should be more than 3 months. It can't be 1 month. 3 months to 6 months. So what is the percentage? 10%. That's it. Thank you. Next one.
The turnover of Y Limited is 400 crore as per last audited financial statement and net worth is 50 crores. Can Y Limited accept deposit from the public as per section 73 of the Companies Act 2013?
Eligible company and Kekana eligible company. What is the net worth limit? As per section, accept deposit from 73. Leave that. Eligible. First, can they accept deposit from public? Y Limited. Eligible company Lian Kekana. Eligible company is 76. Some error there. Leave it. Okay. Eligible company limit is what? Net worth more than or equal to 100. Inga 100 irka? Illa. Turnover more than or equal to 500 crores irka? Illa. Is eligible company? No. Come down. Case 2. Case 3. As per 76. Happy? 76 eligible company. Our question mistake pannita. So no problem. Or நம்ம team type பண்ணும்போது தப்பா போட்டுருப்பாங்க. It could be anything. Okay. So is it eligible company, guys? It cannot be treated as an eligible company, cannot get money from public. 6 mark. This is 6 mark question. Which attempt? December 21. On the November 20 தவிர everybody are happy people. நீங்க எழுதிங்க November 20 இல்லையா? Oh, you are doing like this. Next.
Explain the provision relating to credit rating which an eligible company should follow to raise public deposit as per Companies Act 2013.
We discussed in class also. Credit rating should be taken on a yearly basis. We have that point also in book, but இது எப்படி 4 மார்க் கேட்டிருக்கான்னு தெரியல எனக்கு. Okay. In the common points we would have added this. Today only we discussed also credit rating on a yearly basis. Every company should obtain credit rating from recognized credit rating agency every year along with tenure of deposit be filed with return of deposits. இதுக்கு மேல என்ன போட்டுருக்கான்? Sorry. என்ன போட்டுருக்கான்? Oh, that's it answer. Okay. That's what they also wrote. So you have to get credit rating on a எங்க போட்டுருக்கான்? He is given heading as per section 76 rule 3 அதெல்லாம் ஞாபகம் இருக்காது. 76 we will remember. Enough. 76 we will remember because there is unique points for 76. I would have told unique points. Accordingly, eligible company has to raise public deposits, obtain credit rating from recognized agency, and further rating should be obtained every year during tenure of deposits. It should also be filed along with return of deposits every year. That's it. Same point. May 22. Lucky fellows. Okay. Next question 20.
Perfect Limited Company raised the secured deposit of 100 crores on 30th June 2021 from the public on interest at 12% per annum, repayable after 3 years. The charge has been created within prescribed time in favor of trustee of depositors against the deposit, taking following assets of the company as security: land and building 60 crores, plant and machinery 20 crores, factory shed 20 crores, trademark 20 crores, goodwill 25 crores. Explain the validity of the charges created with reference to Companies Act 2013.
Excellent. Again they're testing இதே unique points of 76 we saw in class also. I will again read that for everyone's benefit. They are just testing the last third and fourth point in the book. Every company which accepts security deposits from public shall within period of 30 days accept deposits, should create a charge on the assets, and if it is eligible company, such charge should be only on tangible assets, and the amount of charge shall not be less than the number of deposits and valued by a registered valuer. In the point nyabam irukka, in our Gen Z notes also we wrote amount of charge, deposit and charge on tangible assets, that they are testing over here. So what are tangible assets here? Goodwill I will take a no. First of all, is this eligible company? How are you saying it's eligible company? First, it's a public limited company and they got deposits from the public. That means it's assumed illa, it's presumed, it's an, what to say, it's very clearly given, assumption illa, it is an eligible company. Okay, so trademark goodwill edukka maatan. I will take only these three. What is the total? 60 plus 20 plus 20, 100 crores. Excellent. That means asset available is 100, charge also is, loan also is 100. When did they create the charge? They took the loan on 30th June, repayable after 30 years. The charge has been created within the prescribed time. Adum kuduklana, charge has to be created within 30 days. So is the charge perfect here? Yes. Charge value matches asset value, it is perfect. Only thing is, in the provision in a book la parchingna, you are saved. Otherwise you will be okay, enna idu onume therilla, you will not know this. Easy question, but you should know the provision. So come back here. Therefore what they are saying, okay, trick question. So what they are saying, we compared only 100 crores with 100 crores and told not enough. I also made the mistake, guys. Now of course all of us made the mistake. Nobody, about 10 of us, nobody got the, what to say, point here. Epdilam kekram paranga, because the point says, okay, total value. So what you will repay is 100 crores and 12% interest per annum. So 100 crores plus 12 per year plus 12 plus 12, how much? 136. So he is saying total amount of deposits along with interest is 136. Since total value of security is less than the amount of deposits accepted, charge is not valid. Are you following, guys? So everything is correct, conclusion wrong initially when we did it, but now you understood, guys. So you, again along with Rashmika, this question will go and sit. Perfect Limited and Rashmika Limited will sit together. Okay, நான் எதுவும் சொல்ல, guys, question அப்படி வருது, important questions. Okay, fine, understood. Anybody has any doubt? Next.
NOP Limited, since its incorporation in 2002, is engaged in the production of premium quality glass bottles. According to the financial results of the company on 31st March 2023, net worth of the company was 90 crores and turnover of the year 22-23 was 510 crores. The company proposed to accept a deposit on 1st February 2024, which would be due for repayment of 30th September 2028 from the public expansion and redevelopment programs of the company. Furthermore, the company has accepted a loan of 1.5 crores from Mr. P. Kishore, director, and loan has to be repaid after 24 months. Company in its books of accounts record the recipient of loan under non-current liabilities. At the time of advancing loan, Mr. P. Kishore affirms in writings that such amount is not being given out of the funds accrued by him by borrowing or accepting loans or deposits from other, and the complete details of such loan transaction is furnished in the board's report.
Okay, go ahead, sorry.
Whether company is eligible to accept deposit from public, what is the criteria for acceptance of deposits, and tenure for which deposit can be accepted, whether the tenure decided by the company was in accordance with the provisions of Companies Act 2013. With reference to the loan advanced by Mr. P. Kishore to the company, state whether the same is to be classified as a deposit or not.
Okay, finally new syllabus questions, RTP May 24. First, is eligible company an kekran. I hope you read the question, that's why this time is there. If not, recording students, pause, read the question. Is it eligible company? Yes. Turnover crosses 1 cross panna podum, therefore this becomes an eligible company. So write the full point of eligible company. What is the criteria for accepting? What is the tenure of deposit? Tenure is what? 6 months to 36 months. இவங்க என்ன பண்ணியிருக்காங்க? Look at this. He accepted on 1st Feb. அப்போ 36 months will end on which year? 24, 25, 25, 26, 26, 27. Roughly 1st Feb 2027 repay பண்ணிரணுமா? Hello? But when they are repaying? 30th September 2028. That means they are giving deposit for more than 3 years. Allowed? No. What act is saying? You repay again get deposit. Renew பண்ணிக்கோங்க. But maximum is 3 years. Okay. So whether the tenure decided by company was in accordance with the provisions? No. Let's go check case 1. So he's given what is eligible company, and they have also given tenure of deposits, which is cannot exceed 36 months. Therefore in this case it is not valid as it's crossing 36 months. Are you following, guys? Second point என்ன சொல்றாங்க? With reference to a loan by Kishore, is this deposit? This we have seen many times. No. Look at this. Kishore, director, gave 1.5 crores repayable after 24 months, and at the time of giving the loan Kishore confirms in writing that it is not from borrowed funds. Disclosure கொடுத்துட்டான். Is it deposit, guys? No. This we saw as a separate question in previous items. So answer is, in the given case said deposit shall not be treated as a deposit. Are you following, guys? Easy chapter deposit. These are all scoring areas we should not miss. Question 21 done. 22. Quickly let me read this. Wood Limited received 4 lakhs as non-interest bearing, tick. Secure deposit, tick. From contract of employment, tick. But his annual salary is 3,85,000. You got 4 lakhs more than salary. Therefore deposit, yes. More than salary na, yes. Up to annual salary, so up to 3,85,000 it is not a deposit. It crossed 3,85,000, therefore it becomes a deposit. Can you see the difference? RTP la என்ன கேட்டிருக்கான்? RTP May 24 ல. Just know this big question. MTP என்ன கேட்டிருக்கான்? Generally MTP is one. What to say? பெருசா you won't find any interesting questions. Have you guys found any difficult questions in MTP? Generally no. That's why I don't even look at MTPs. Okay. Only RTPs exam. That's it. Question 23. November 23 question. November 23 and November 20, guys. November 23, November 20 were the two dangerous attempts for interlaw. Both PAVAM students, both of them. Go ahead. Yes, read.
V Remedies Limited incorporated on 26th November 1995 with paid up capital of 25 crores. According to the financial results of the company on 31st March 2022, net worth of the company was 120 crore and turnover of the year 21-22 was 350 crore. The company proposed to accept the deposits on November 2022, which would be due for repayment on 30th September 2027 from the public for expansion and redevelopment programs of the company. Besides that, the company accepts a loan of 1.5 crores from Mr. P, director, and the loan was expected to be repaid after 24 months. Company in its book accounts record recipient loan under non-current liabilities. At the time of advancing loan, Mr. Seth affirms in writing that such amount is not being given out of funds accrued by him by borrowing or accepting loans from deposits from others, and the complete details of such loan transaction is furnished in the board's report. Whether the company was eligible to accept deposit from public, what is the criteria for acceptance of deposits, and tenure for which deposit can be accepted. Whether the tenure decided by the company was in accordance with the provisions of the Companies Act 2013. With reference to the loan advanced by Mr. Seth to the company, state whether the same is classified as deposit or not.
Now while he is reading the question itself, you are all waiting. எப்போடா முடிப்பான்? Answer தெரியுமே. அடுத்த question போலாம். That is the confidence you should have for every question in exam. அந்த question படிக்கும் போதே how you felt confident. இது பார்த்தேன்டா. Just know we saw above. அதே question. That confidence you should get for every question in exam. If not for 100 marks, at least for 70 marks you should get that confidence. What is the answer here, guys? Said given to company depositor? No. இப்போதான் பார்த்தோமே. Same. He gave declaration and same question. அதே facts தான் கொஞ்சம் மாத்திருக்கான். Look at this. 2020 கொடுத்த deposit is repaying in 2027. 5 years possible? No. Just like the previous question. So this question you can take for writing practice. This or the previous question. So answer is eligible company என்னன்னு எழுதுங்க, and tenure Not possible. This company has not abided the provisions. Are you following, guys? Just know we did know. RTP May 24 and November 23 past exam question. Fine. Repeat. Oh, that's it. 30 questions sunenga. Fine. That's it. We are done. Oh, excellent. Less than 1 hour. We finished as planned, guys. Super. Thank you. Okay. Hi guys, welcome to the workout batch of LLP chapter. This is going to be a very small discussion. We are going to discuss questions here in 3 ways. First, we are going to do around 5 questions from the workout material. Okay, why only 5 questions? Because LLP Act was not there in Inter. So we can't take from last 5 years. Only inter source of questions are taken. Foundation questions are not taken in this workout material. Then RTP, latest RTP of September 24 and even Jan 25 RTP LLP questions also I will be solving it. And lastly, since we are only going to solve around 7-8 questions of LLP, once we finish the 7 questions, I will come down and I have listed down few important concepts which you should not skip for exam in LLP. Mostly LLP, it's all straightforward questions. Provision therinja application. Let's start off with our workout questions, then go to RTP, and lastly I will come down to this list of questions. First, LLP Act, questions for practice, first one. Mohit is a chartered accountant, creditor of ABC Limited. He has a claim of 10 lakhs against LLP. However, the assets of LLP are only valued how much? 7 lakhs. Now, Mohit seeks to hold the partners of LLP personally account for shortfall of 3 lakhs. Will he get the money, guys? No. Act lay solran, limited liability. It's like a company, they will only pay up to 7 lakhs. Remaining 3 lakhs, what Mohit should do? Nothing he can do. He can't recover. It is a loss for him because of concept of separate legal entity and limited liability. RTP May 24 this came, guys. You might be thinking the exam depends. It can come. LLP, it's always easy. There's never been a difficult question in LLP. Bookla padicha, you will know. So look at this. What is LLP they are writing? Then they are saying creditors we cannot claim up to 3 lakhs. Straightforward question. Let me not spend much time here. Mohan and Rakul are college friends and intend to do trading in musical instruments. They have met Mr. John and Kate who are non-resident Indian. So there are 4 people, Mohan and Rakul. They have met 2 people, John and Kate, who are NRIs. And they all have decided to form an LLP. Fine, we can start. Not necessary that the designated partner in LLP has to be in India. I mean, one is in India, that's enough. Others can be outside India. Under the name Style of Mohan John LLP. Yeah, they can start because their names are used. With an initial capital contribution of 1 lakh each, totally 4 lakhs. Fine. LLP was incorporated on 15th October 2020. LLP intends to appoint Mr. John and Kate as designated partner and consults the same with company secretary. Always they're consulting company secretary whenever there is wrong in the question. You should see. Question wrong na company secretary vanduruva. Okay. Now they're asking you, if you are the company secretary, what is the advice? Now we know in LLP, residential status, if you see, basic residential status, LLP should have how many partners, guys? Minimum 2 partners should be there. I can have any number of partners, but there should also be minimum 2 designated partners. Who are these designated partner fellows? They are responsible for law and regulation. Something goes wrong now, I'll catch these fellows. In this minimum 2 designated partner, at least 1 designated partner should be a resident who should stay in India for at least 120 days in previous financial year. Are you following, guys? This is one key condition. I can have any number of, there should be 2 DPs. In that, 1 should be resident. Now in this question, if you see, they want to appoint John and Kate as DPs. Possible? No, because both are NRIs. Either Mohan or Rakul, any one should be there in a firm. Okay. Are you following, guys? Second, they're also very subtly testing that LLP is incorporated on 15th October. We have a concept of financial year in LLP, where LLP is incorporated on 1st October or later. Then financial year, if it's starting on 15th October 2020, they have not tested this in the question directly, but financial year will end. There are 2 options. It can be 31st March 2021 or 31st March 2022, next financial year. Same concept we have in Companies Act. Their cutoff date is 31st December. Here cutoff date is 30th September. That's it. Okay. But here they are not asking that. You don't have to write that. Maybe just to waste your time. Okay. So here there should be at least 2 DPs. One of them shall be resident in India. This is not according to provisions because both John and Kate both are non-residents. Straightforward answer for this. What is the provision? Point 1. Point 2. This is nothing but your facts. Point 2 is your facts. Point 3 is analysis and conclusion. How simple they have finished this case. 3-mark question. Don't drag and write it. To the point. What we are learning is institute is expecting to the point answers. Next. This question has come in not MTP March 2024. It has come in foundation for several attempts. Randomly, if I take 5 foundation papers, 5 paper na one irukku. LLP is an alternative corporate business form that gives benefit of limited liability of company and flexibility of partnership. Yes, you get benefits of company and benefits of partnership. That's what is LLP. Explain those benefits in your own words. This has come so many times in exam. Basically, first point is about liability is limited liability they're talking about. Second point is flexibility of partnership. For everything you don't have to pass a board resolution, you don't have to pass a AGM, no need to have AGMs. Easily the affairs, there is no MOA, AOA, easy affairs. So LLP form enables entrepreneurs, professionals, enterprise providing any kind of service from vehicles owing to flexibility in structure. LLP is suitable for vehicle for small enterprise and investment by venture capital. I think they asked that in question or somewhere. Kekawel, I think some related point, but basically flexibility is there. That you will write. Are you following, guys? To form commercially efficient vehicles suited for their requirements. I think some question is missing here, guys. So some other answer is coming. Owing to flexibility in structure. LLP suitable vehicle. Okay. For small enterprise and investment by venture capital. Okay, nothing missing in question. Suitable vehicle now, it's an other alternate term for entity. Suitable vehicle, suitable entity for small enterprises. For doing like 10 people, 20 people, 30 people, all of that. Okay, fine. Pratik has started an LLP firm along with Brown Limited and Picture Limited. Next question. Designated partner or partners in LLP can be both individuals and body corporate. If it is individuals, no problem. We will easily appoint designated partner. But if it's a body corporate, how will that be individual? How will I count residential status? So body corporate says you have to appoint an nominee who will satisfy this definition of 120 days and resident. So here what they are saying, as per provisions, who can be the designated partner? So for Brown Limited and Picture Limited, they can appoint any nominee. But Pratik is already there. Pratik is one designated partner. So the other designated partner should be any nominee from the other two companies. Therefore, they're saying at least Pratik is there and one nominee from any of the other two companies should be designated partner. And either Pratik or this nominee should stay in India for at least 120. Did I write 180? 120, sorry, 120 days. 120 days is the days everywhere. Are you following, guys? 120 days or more. Clear? Easy, guys. Is the question straightforward? Yes. Now, beautiful question from Santana Krishna is asking a very beautiful question, guys. Sir, Pratik mandatory DPR kunuma? No. We have 3 partners. Pratik, we have Picture Limited, we have Brown Limited. Any 2 of them should be DPs. It can be Picture and Brown Limited. They can appoint 2 nominees and be DPs. Pratik cannot be the DP also. It's fine. There is no rule that individual irunda he has to be designated partner. No. Any 2 DPs. Both could be body corporate also. If nominee is there, it's sufficient. Are you following, guys? Like this, they should ask questions. A straightforward, a book LLP. Okay. This also, CA Foundation. They've asked so many times, even I got tired of this question. Now it came in Inter also. It's there in Foundation also, still there in Inter also. Enumerate the circumstance in which LLP may be wound up by the tribunal. Bookla, there are some 5 to 6 cases where tribunal will order for winding up. Just mug up and keep. Once in 5 points are there. Once in 5 attempts, they will ask this. Which attempt they don't know. Okay. Section 64, tribunal order for winding up. Straightforward question. I will just explain the points quickly. If LLP decides, it can be wound up by tribunal. And all these points are different concepts or provisions of LLP not followed now wound up. If for more than 6 months, number of partners is reduced below 2, same concept we have in Companies Act. Here also same concept. If number of partners falls below minimum requirement, which is 2, and business is carried on for more than 6 months, then LLP may be ordered to wound up, and also for LLP liability becomes unlimited. If LLP has acted against the interest of the sovereignty and integrity of India, the security of the state and public order, some terrorist activities they are doing now, order for winding up. Sir, LLP எப்படி சார் terrorist activities பண்ணுவாங்க? LLP is transferring funds to terrorist organizations. Source of funds for terrorist organizations. Now, terrorist organizations need guns, sir. How they will get it? They also have to buy from somebody. So, you are donating not to political parties, but to terrorist organizations. If LLP has made default in filing with the registrar, account and solvency for any 5 consecutive years. Here we have 2 filings in LLP chapter. Statement of account and annual return. If that's not filed for 5 years, and if tribunal feels it is just then equitable. These points you already know, nothing great. In concept batch, I will discuss this in detail. Here, I'm sure all of you watching, you know these points. Foundation la parchingla. With this, we are done with the 5 questions. Now, before I go to 2 questions, just for small deviation, I'll go for these concepts, which you should be aware for LLP. Since it's workout batch, aware of concepts. Expected question, from this I will pick a few. Okay. Basic features you know. I'm just connect with the provision. Separate legal entity, limited liability, artificial judicial person, all those, common seal, all of that. Designated partner has so many provisions. Some we just finished on top. We just learned about designated partner. Still there are so many things. What if you change designated partner? What if this, all those points are there in a book? You will read those. Dissolution by court, just now we saw those 5 points, what we just now saw. Declaration of solvency and annual return. 2 filings LLP has to do every year. One is 6 months, one is 60 days. Okay, from end of financial year, that should also be filed. Whistleblowing. Whistleblowing only came in one of the latest exams, May 24. Whistleblowing came. What is whistleblowing? Whistleblowing is nothing but if some employee raises voice against the company, then what will happen? He will be protected against the interest of the law. Fraud says if any partner does a fraud, liability becomes unlimited. Then you have a concept of liability of partners. Very important. Foundational, not that important. Here it's important because what is the liability of partners in a limited liability? Sometimes it becomes unlimited if acts is done by me. In partnership, what I do will bind the others. Mutual agency. Here it's not like that. So what is my liability? For example, in LLP, I'm using this laptop. I broke it. I should only bear the loss. Other partners will not bear it for me. Are you getting it, guys? In that, there are some concepts. Small LLP, amendment, and important area. Did they test in September 20? I think it's September 24. No. Small LLP, very important. Small company came many times. Like that, you have small LLP. Go through the limits. Amended area. Financial year we discussed in questions. That's it. One important concept which many people ignore. For LLP, books of accounts can be prepared in cash or accrual basis. In company na section 129 only in accrual. Here it can be in cash or accrual. Then name change and address change. We are going to see in RTP now. If LLP changes the name or if partner changes the name, partner also can change name. Correct? Santana Krishnan you can change. I can change if I want. Anybody can change the name today. Address change. Address change panna Aadhar la update pannuma. Like that what I should do there. Then new concept in CA Inter which is not there in foundation. Transfer of partnership interest section 42 in LLP. This was there in foundation, not in LLP act, in partnership act. That same concept is coming here. Difference between LLP and company, foundation irundha adhe same thing is there over here. Okay. In our detailed concept class, we will do, already I have a video on YouTube for LLP in 1 hour in marathon. Again, I will do one more for this Jan 25 exams with the notes, everything. So 1.5 hour we will finish full LLP. If you want to revise all these concepts, if you already know, it's fine. Now let's do both the RTP questions. So this is one RTP, I think September, and this should be Jan. Yeah, this is September. Okay, September RTP. For those who are watching recording, this is September 24 RTP. We are just doing RTP because book has less questions here. LLP was registered under the LLP Act with a name that was later found to be identical to an existing company's name, very similar to section 16 of Companies Act, rectification of name. Then if there's any name which is identical, RD will order for rectification. You have to change within 3 months. Here XYZ OPC Limited, the similarity was not noticed at the time of registration. So by mistake, sometimes they give the similar names. See, we can fool the system or we can fool the other person. So by mistake, if the name was coming in, then explain with reference to provisions when the name is identical, formalities of ROC. Question 17, very simple. You have to change the name within 3 months. That's it. This is question number 17. We will go to the question. Yeah. Notwithstanding anything contained in section 15, 16. Here also section 16. Companies Act also section 16. If the name is too identical of any LLP or any company or any trademark, then the company, central government will order the company to change within 3 months. Same section 16, which is in Companies Act. For trademark, you can apply to the ROC or RD within 3 years from the date of incorporation. If somebody is copying my trademark, if I want to complain, see, look at this, RD is here. If RD orders, I will change within. But if you want to complain to RD, asking somebody else to change the name, you have to complain within 3 years from date of incorporation. Another very subtle and beautiful amendment in LLP is, look at this, if the name is identical to any other LLP, company or registered trademark, this provision will come. If the name is identical to an partnership, can you see that word? Not there. If name is identical to a partnership, sorry, you can continue. Old Act, just 2 years back, partnership also was included here, or partnership. Now it's removed. That means I can start a name which is identical to partnership. Why? Idea is to get registered as an LLP or company. They don't want to promote partnership. Very subtle amendment. It came in RTP in 2023. I don't know how many of you noticed this. They removed partnership before it was there. All this in our detailed class we will see, guys. Definitely we will do it before Jan exams. I just need 1.5 hours of your time maximum. I will try in 1 hour concepts of full LLP. Separate video I will anyway put on YouTube along with the material. Okay. How I'll take that class? It will be comparison. Companies Act has this. What is there here? Partnership has this. What is there? Same thing actually we already did. For May we did a marathon which is already there. But freshly I will do again. So last question of LLP. Question number 17. Amit and Priya are partners in XYZ LLP. I'm not able to mark here. Okay, just leave it. Are partners in XYZ LLP, a consulting firm. Recently, Priya moved to a new address but forgot to notify the LLP within the required period. A month later, Amit's cousin Ramesh expressed interest in joining LLP as a partner. And after few discussions, he was accepted as a new partner. Two things. Priya left to a new address, she didn't inform the LLP. And they want to join Amit as a partner. Two things. However, XYZ LLP did not immediately update the registrar of companies regarding Priya's address change or Ramesh's admission as a new partner. 2 months after Ramesh joined, the LLP filed a notice to the ROC about these changes. They are asking you about 2 points. First point, Priya's address change. Second, Ramesh admission as a partner. That's it. 2 questions. I will quickly summarize that for you. Okay, we finished all these concepts, correct? Only 2 questions here. So first is address change. Second, admission of partner. Simple. Procedure is whenever you change address, you have to intimate LLP within. LLP will intimate ROC in 30 days. So here Priya should intimate LLP in 15 days. LLP to ROC within, which is not done. Disclose that. Admission of a partner. Whenever you admit a new firm, the LLP will intimate ROC within. That's it. That's it. When you admit a new partner, you have to intimate ROC within 30 days. This is to remember in exam. How did they write this question number 70 now? So here you can see point 1 here focuses on, here you can see point 1 says within 15 days you have to intimate ROC, LLP, and then LLP will intimate 30 days. No, sorry, here. Change in name or address. File notice to ROC within 30 daes. Are you following, guys? This 30 days is different. If there is a new partner or admission of partner, that one. Second, come here. This is the provision. Above is the provision. Come down. Priya's address change. She has to intimate in 15 days. ROC will file to ROC within 30 days. Come down. Ramesh admission for new partner. LLP must intimate ROC within 30 days. That's it. Are you following, guys? That's what is given as provision above. So this is in respect to LLP. I hope it's clear, guys. We are doing only questions that we have at source and disposal. Okay. That means LLP there is chance of a lot of new questions or C or CA foundation questions. Are you following, guys? That's about it. I don't think they will ask foundation questions in inter. Then there is no point, even though ICA knows. So I am expecting, if you ask me, sir, if I have to pick 5 questions from this now, this solvency I will ask. Then small LLP is second question for me. Books of accounts, cash accrual. This name change, address change was never asked in foundation. So they will ask in inter. Then transfer of partnership. These are the areas that they will come. And of course, designated partner left, foundation other questions, or even like this non-resident, all those. Key, very simple. LLP 1 hour parcha, more than enough. 4 to 5 marks comes in exam, or 6 also sometimes. That's it. Any doubts? Fine, guys. Okay. We'll close LLP then. Thank you. Yeah, hi guys. I know I said thank you and got over, but just a 2 minutes clarification. September 24 RTP question 17. Students had a doubt here. What happens when name is identical and formalities with ROC after change of name? Just to again reiterate on that, I have summarized the timeline here. I thought I'll share with all of you. Basically, whenever the name is identical to any company or LLP or a registered trademark, partnership not included, the central government may order the company to change within 3 months. If they order to change in 3 months, LLP has to change within 15 days and then intimate ROC. ROC will within next 30 days give a new certificate of incorporation. If central government is silent and not doing anything, I can apply to the central government directly for within 3 years from date of incorporation. Same provision in Companies Act. Instead of central government, you have regional director delegated over there. Then just to summarize the other timeline which we saw here, in Jan 25 RTP, whenever an LLP or a partner changes the address, he will intimate LLP within 15 days. Or even if partner changes his name, he will intimate LLP within 15 days. LLP within 30 days will intimate ROC. If LLP is not intimating in 30 days, then the partner can directly intimate ROC after a reasonable period. If whenever there is admission of partner in LLP or there is retirement of a partner, any partner coming in or going out of LLP, then LLP within 30 days will intimate ROC. Sir, why are you revising concepts in workout batch? I am revising the timelines in summary for the 2 RTP questions, which is September 24. This is your September 24 and this is your Jan 25 timeline summary of RTP I have revised. There are many more timelines in LLP like declaration of filing of solvency, all of that. That is in concept class, guys. Here the question I have discussed the concept. Okay. Hi guys, welcome back to the workout batch. Today we'll be discussing questions from General Clauses Act. Like you all know, in the workout batch, General Clause Act, we're going to discuss last 5 years from 2019 to 2024, all the questions from your past exam, RTP and MTP. In this workout batch for General Clause Act, all these put together in this material that we're going to solve, we have 40 questions. Okay. Now 40 questions our target to do in 1 hour. Sir, how is that possible? I'm going to focus on accuracy over here, correct answer. Those who are yet to see General Clause Act over here, Go to YouTube, find General Clause Act from my channel. It is freely available in marathon. Just 1.5 hours, I would have finished the entire General Clause Act. Even if you are studying for the first time, more than sufficient with this material that everything is covered. Now we are coming to focus on those students who know General Clause Act, who are the smart ones, because General Clause Act will guarantee you 6 marks in the exam. 2 3-mark question will come in every attempt. Let's go from the first question in our book itself. I will read it fastly, guys. Cope up with the pace. If the time I am giving you is not sufficient to read the question, no problem. You pause, read and continue, because I am not going to reduce my speed in this workout batch. Okay. If there's anything, we have some students over here, they will also tell us. If it's very fast, let me know, put your hand up, totally fine. Okay, any doubts you have, ask me here, put your hand up, totally fine. Second mic, I didn't give you, leave it. Next time I will keep the mic. Okay. Yogveer Singh has a mango orchard at some village, Bilsapur. Okay. Orchard has more than 100 mango trees. Super. Yogveer Singh has sold orchard along with all the mango trees. So in the Yogveer Singh, Yuvraj Singh, Matitang. Okay, or Yograj Singh. Okay, this Yuvraj Singh, basically what he is doing, he has 100 mango trees. Along with the mangoes, he sold it. To whom? Maybe Dhoni, they have not told. Explain in light of provisions of General Clause Act whether sale of trees is considered as an immovable property. I would have told in class, immovable property definition is very, very important. It includes 4 things. It includes land, benefits arising out of land, things attached to earth, and things permanently fastened to anything arising anything attached to earth. I told in class you have to mug up this definition also. So that answer is basically from here. This will be an immovable property because trees are benefits arising out of earth. Okay, land. Yes. So the same benefits arising out of land and port. They will tell trees are benefits arising out of land attached to the earth, and hence mango trees are immovable. 1 minute, 1 question. 40 questions here and there. 60 minutes we have to finish. Question 2. X owned, how many times it came? Ayo. Okay. X owned a land with 50 tamarind trees. What is tamarind trees? Terlana parvale, doesn't matter. He sold his land after cutting the 50 trees to Y. X sold trees to Y after cutting it. Is it sale of immovable property? Answer is no. Before cutting, immovable property. After cutting, no, it is not an immovable property. Therefore, adhe same answer, because it is cut after cutting. Therefore, this timber cannot be immovable property since the same are not attached to the earth. What is attached to earth only? You are cutting and destroying the earth. So once you destroy the earth, you don't call it as immovable property. Examiner, don't write all of this, guys. That's it. It is not an immovable property. Look at the presentation. First, he is not writing facts. These are all 2 to 3 mark questions. General Clause Act is a 3-mark question. I can't write facts over here. Here, straight away write the provision. Then analysis, conclusion. Save the time. Are you following, guys? Next. Direct questions I will not be discussing in workout batch, because direct question, instead of me reading from the book at that time, you can read, guys. I will just tell you what is direct question. You will read by yourself. Case study questions only we are going to focus. Repeal of provision is different from deletion of provision. Yes. Repeal na replacement. Simple. Repeal na a provision is being changed. No, it's being repealed. See, repeal of provision is different. Let me give. Repeal ordinarily brings about complete abolition of the provision as if it never existed. For example, VAT Act was repealed. The VAT Act was repealed. Now VAT is not even there. Okay. Thus, all the rights, all registration is taken away. Deletion means ordinarily it takes effect from the date of legislation affecting the said deletion, never to affect total effect or wiping out the provision as if it never existed. For example, in Companies Act section 11 is deleted. That section is deleted from that day, and 11 is replaced as section 10A. Yes. Okay. Are you following, guys? So got the difference between repeal and deletion. Repeal na fully gone. That act never existed. Deletion, that one part is deleted. Okay. This same case we have it in our book also. Okay. Where is it? If somebody has our book, I would have given key case laws. Okay. In key cases, I have told you repeal is different from deletion, update same wordings. You don't have to remember the case law name. What is there inside contents? If you just read it once, you will be able to write. Are you following, guys? Clear? Next, fourth, what is the meaning of service by post? Examiner's favorite question. Post vandale examiner will wake up. Post, the notice post. So many times it came. Repeat so many times. So for this, serving by post, we also have it in our book. In our book, we have something called key provisions. Meaning, according to me, what are all the important provisions of the act in Sully, I would have kept in a place called key provisions. In this key provisions, I would have told serving by post includes three things: properly addressed, prepaying, sent by registered post. If these three things are there, means post is valid. That's it. This dabba you write means 3 marks you will get. Same thing is there here. Serving by post is properly addressed, prepaying, and registered post. That's it. That's it. Direct question. Next. Now, and what to say? Same service by post, an application based question they're asking. Question number 5. Which color is better suited here? Green. No? I'm just trying different colors. Okay. A notice was served on Mr. P for appearing in the court. கோர்ட்டுக்கு வாடான்னு கூப்பிட்றான். Their notice is sent on P. However, the notice could not be served on account of the fact that the house of P was found locked. See, if somebody has done a crime, வீட்லயா இருப்பான். He is not in the house. So, house of P was locked. Thus, P did not appear in the court. He is saying, illa, I am not in the house. House is locked. I can't come to court because I did not get the notice. Examine the situation as per the provisions of GCA. Determine whether P will be liable. Answer. Yes. According to the concept, serving of notice by post means if the post is sent correctly to the address given, yes. Prepaid, yes. Sent by registered post, yes. All these three yes na, I don't care if you don't receive the post, if your house is locked or somebody else tore the post. No. Serving of post means in the moonume pantana, yes. So it is valid. So again same answer. These three. Therefore, they will tell a letter containing the document have been effected at the time at which the letter is delivered. Hence, where the notice could not be served on account of the fact that the house Mr. P was locked, it is deemed that notice is properly served. I follow the 3 points. Look how beautifully they have done analysis. Analysis is a mix of provision and fact. Now look at this. The first line, a letter containing the document to have been effected at the time at which the letter would have been delivered in the ordinary course of post. This is basically the provision part. Then, therefore, based on above concept now, normally I will deliver it here. So, based on above concept where the notice could have not been served, P's house was locked, still it will be a valid notice. Are you able to follow, guys? What do you mean by good faith? Good faith again is very simple. We would have given in our definitions of our book what is good faith. A thing shall be deemed to be done in good faith if it is done honestly. I did not enough. Whether it is done negligently or not doesn't matter. If you're careless, it's okay. Same definition. What is good faith? They will write good faith if it's done honestly, whether it's done negligently or not. Are you following, guys? Then they're also saying for General Clause Act, I will follow good faith. This some other act is saying something else. Now, please follow. That's some other act thing. That's all. Next, question 7, which talks about commencement of an act. SEBI issue of capital and disclosure requirements 5th Amendment regulations looks scary. Was issued by SEBI by notification 14th August with effect from 1st Jan. That means notification came on 14th August. But what is the effective date mentioned in the notification? 1st Jan. That means the SEBI ICDR regulations, issue of capital and disclosure regulations, will come into force from which date? 1st Jan. Commencement, we would have learned one thing. If notification has a date, what date is mentioned in notification only, that date will be effective. If no date is mentioned in act, date on which president is signing. Same thing they would give here. Okay, so it will come in on 1st of Jan. Are you following, guys? Next to question number 8. As per the provisions of Companies Act, a whole-time KMP shall not hold office in more than one company except its subsidiary at the same time. That means if I am a KMP in the holding, you cannot be KMP anywhere else not allowed, but they are allowing you to be a KMP in the subsidiary alone. Referring to section 13 of GCA, examine whether a whole-time KMP can be appointed in more than one subsidiary company. Now in the key provisions, I would have taught you one concept in key provisions in the class. If not also, you learn from whichever book you took. Gender and number la, I would have told in number, words in singular will include words in plural. Now the act is saying you can be a KMP only in the subsidiary. You can't be KMP in other companies. Now can he be in more than one subsidiary? Yes, the word except its subsidiary will include subsidiaries. Are you following? Therefore look at the conclusion. Thus a whole-time KMP may hold office in more than one subsidiary as per present law, because singular includes plural. Look how they have presented, guys. First they have given here. See, there are different ways to present. Okay, this question 3 marks only in exam. 100 GCA na 3 marks. GCA 3 marks in exam. Okay, one question I'm saying. Now they are saying act provides whole KMP shall not hold office in more than one except subsidiary at same time. Okay, this is they are writing the facts with respect to the issue whether a KMP or holding appointed in more than one subsidiary. Here first there are the first 2 points are facts, guys. Point 1 and point 2 is facts. How many marks for that? 0. If time is there you can, otherwise you can leave. Now why they wrote facts here? Because in this question if I write only analysis conclusion, one line it will get over. Look at this. Section 13 says singular includes plural. Therefore subsidiary includes more than one subsidiary. This 2 lines la mudichiruven. Examiners will not feel to give you 3 marks. So to make the answer look bigger, in the MTP itself they may wrote facts. Are you following, guys? Getting it? So when you think the answer is very small, singular includes plural. Therefore subsidiary includes subsidiaries. Is that an answer? That's what they wrote. But why they wrote the facts again? So that it elevates the answer. That's it. Okay. Next, question number 9. R, an advocate, fraudulently deceived his client Mr. C. Chandan, who was taking his expert advice on taxation matters. Now R is liable to a fine for his fraudulent act. Under both Advocates Act and Income Tax Act, I can predict the question. Can he be punishable under both acts? This also we studied. Answer is no. For this in GCA we would have seen provision has to be punishable under 2 or more enactment. This also key provisions. So in our material I would have told you, if you are skipping the whole act also, at least learn key provisions. See how many questions are coming from here. Simple. I can't be punished twice for the same thing. Get slapped once, enough. Daily I can't get slapped. Okay. That's what they are saying here. Advocate Act and Income Tax Act, which he will be punishable. Court will decide which one. The Supreme Court or High Court, wherever case is pending, that one. So where an act or omission constitutes an offence under 2 or more enactments, offender shall be liable to prosecute and punish under either of those. That court can decide wherever penalty is higher. Okay. Following, guys, that's it. Explain the term commencement. Now in these 40 questions, remember, guys, concepts are going to repeat. When the concepts are going to repeat, I am not going to repeat my explanation. We are in a workout batch. Workout is newly trending. Sir, we studied, sir. We know a concept. We want to practice. Weetla, I am lazy. 40 questions I will not do. 5 questions, 1 reel. 10 questions, 20 reels I will see. So quickly we have to do. Commencement. What is commencement? We already studied. Repeat with me, guys. Recording and here. Commencement. When act is coming in force, whatever date is mentioned in the official, in the notification, if no date is mentioned, date on which president signs. That's it. That's the same thing. Are you following, guys? Clear? Commencement means from which day the act is coming into force. So if they say 1st Jan, from that day they will catch you. Not wearing helmet. New rule in Tamil Nadu. 5,000 rupees penalty from 1st Jan 2026. But I'm telling you now itself. That means now you know, be prepared from 1st Jan. After that also I will not wear, sir. That is different. Okay. Explain the meaning of calculation of duty to be taken on a pro rata basis. This just came once, even though it's part of our key provisions. Pro rata basis. Pro rata na simple. ITC declared a dividend of 2,000 crores. Will you get fully? You will get your share for how many shares you have. I have 2 shares, sir. Then you find proportionately, I will calculate. That we know, no. That only is pro rata. So the same thing he's saying. Based on quantity, weight or measurement, then they are saying you give it on pro rata basis. That's what here also they are saying. That's it, answer. See, that's it. Duty to be, they are saying the same weight, measure or quantity should be on pro rata basis. That's it. This they have never tested in exam. Just one MTP it came. What they will test in this? Since it came in MTP, it's never workout. Okay, next. Question number 12. Again from key provisions question. Companies Act provides that the amount of dividend remained unpaid or unclaimed after 30 days from the date of declaration, section 123, pay within 30 days, then it shall be transferred to unpaid dividend account within 7 days from expiry of 30 days. That is section 124, unpaid dividend. Section number 13, leave it. If the expiry of such 30 days is 30th October, he's saying 30 days got over on 30th October, decide the last day on which you should transfer to unpaid dividend account. Companies Act other laws you mix panni kekran. He's asking count 7 days. So they are saying it shall be transferred within 7 days from the date of expiry of 30 days. 30 days expired on which day? 30th October. So from here 7 days. Will I count 30th October? No. I will only count 31st October and then, so 31st October 1, 2, 3, 4, 5, 6. Correct? It will go till 6th of. So that means within 6th of November I have to transfer. That's it. Answer should be that within 6th of November. How many marks? 3 marks it came in May 19. Lucky fellows. Got 3 marks. Okay. That this provision also is there in our key provision. In key provision, I would have given first concept, commencement and termination of time. From use panangna, that day I should not count. So if you see here, from is used here. 7 days from the expiry of 30 days now, then the day on which it ends, 30th October, I should not count. That means they are saying 7 days from 30th October and so on. 30th October I will not count and 7 days after that. If they use the word to 30th October, then 30th October also is included. This is the provision. What I am trying to do along with answers, I am trying to teach you provision also. Okay, so if you skip this concept now, you will know. Explain the validity of the following statement with reference to GCA. Things attached to earth have to be immovable property. Is it correct? No, things permanently attached to earth. How are you following, guys? Okay, so sorry. Oh yeah, you're right. Things attached to the third part of definition. So land, benefits arising out of land, things attached to earth, and things permanently fastened to anything attached to earth. You're right. So this is true. Yes. How to prove that in exam? Give definition of immovable property. Now we understood why I told you to mug up this definition in class. Mug it up how many times you wrote. The words bullocks could be interpreted to include cows. True or false? Bullock na anantirino, sir. Bullock is basically that male version of bull. Cow is, let's say, I may be wrong also, guys, but here they're testing that singular and plural. Okay, wow. So look at the answer. In General Clause Act, we would have studied one concept. Masculine includes feminine. That means, can I say bull includes cow? Bullocks illa, bull vechkonga. Bull long theriyuma. Can I say bull includes cow? Masculine includes feminine. Eppadi kekkaram paranga question. Okay. So what is the answer? Bullocks could be interpreted as cows. The statement is not valid. Here they are saying where a word connoting a common gender is available, but the word used conveys a specific gender. So if you read the provision here, words in masculine shall include feminine. However, where the law is specific, such assumption cannot be made. Meaning the word bull means male. I can't assume it to be female. When I can tell he includes she, if I write the word he, then I can tell it includes she. They can be male or female. I can interchange. So when specifically I am saying, for example, if I write Sanjay in Eldra, Sanjay na male. Can I say Sanjay includes female? Like that. So bull na male. Are you getting it? That is what they are saying here. So the word bullocks could not include cows, because as general knowledge, bull na male cow. Correct? Okay. Next, question number 14. Examine the validity of following statements with reference to GCA. Board of Sabharwal Construction Private Limited authorizes by passing resolution in board meeting Mr. Munim to appoint 5 employees for accounts department of company. Munim appointed 5 employees including Rupal, who was relative of one of the directors of the company. So they appointed 5 employees and one of them is a relative of director. This only is key so far. Next, after 1 month, Munim observed that Rupal was not performing his duties honestly. Munim issued the order of dismissal of Rupal with proper reasons. Rupal filed a petition in the court that his dismissal of order is not valid as board of directors authorized Munim only to appoint employees and not for dismissal. Whether Rupal is correct? No, we studied this. Where we studied this, I told in miscellaneous concepts, powers and functionaries. Power to appoint somebody includes power to suspend and dismiss. Hey, I am appointing class leader. I can even change the class leader by dismissing. This we discussed in class. Same thing. MTP 22. Ever a question? What is the question? If you can appoint somebody, you can dismiss them. Therefore, on the basis of above provisions, Rupal was not correct on, because as per GCA, power to appoint includes power to suspend or dismiss. 3 marks. Are you enjoying, guys? Either way, 100 marks in the chapter. Okay. Question 15. Yellow and pink had a long distance dispute. Okay. Had a long dispute regarding the ownership of land, for which a legal suit was pending in the court. Sana podrang, guys. Okay. Could be brother, sister. Court fixed the date of hearing on 29th April, which was announced to be holiday subsequently by the government leave and solta aniki. What would be the computation of time? We studied in general class as computation of time is not the next day, it is the next day on which the authority is next open. So if 30th April 2022 authority is open na that day, as per GCA, but in reality court will tell some other day. Are you getting it, guys? MTP March 23 and September 23 and Jan 21 it came 3 times. Yes, Harish. We'll go as per act. I'm repeating doubt for online students. Harish is asking previous question la power to appoint mattu irukuma, power to elect also will be there. The wording says the appointment, whoever can appoint has the power to suspend or dismiss. That's it. So elect is different from appoint. No, appoint na sonna you will be appointed. Elect na election rukum. Somebody will come in election. So that is not coming here. I hope your doubt is cleared. We'll go as per act. That's it. 2015 is done. 15 out of 40 done, guys. Okay. How much time we took? 25 minutes. Okay. Fine. The Income Tax Act provides that the gratuity paid by the government to its employees is fully exempt from tax. You are required to explain the scope of the term government and clarify whether exemption for gratuity will be covered by state government employees. We studied the term government includes those 3 lines that we studied in school. In class, I would have told. Ayo, it went off somewhere. Those 3 things. Government includes legislative, executive, and judiciary. That's it. That is the answer. Government shall include and the government securities will include securities, and government includes central and state government. Of course, central state government including legislative, judiciary, and executive. Okay. So here they are saying government includes central and state government. Therefore, state government employees it will be covered. That's it. Therefore, Income Tax Act says gratuity paid by government to employees it's fully exempt. Exemption is for both central and state government employees also. Correct? That's it. This is not like CSR. Only PM CARES fund I will take, CM CARES fund I will not take. Okay. This as per GCA. Okay. Examine the validity of following statements. Again, they're asking true or false. My insurance policies covering immovable properties have to be immovable property. He's saying insurance policy is also immovable property. Bullocks again came off. I'm not repeating. Bull cow. Just now we finished. What is first question? Insurance policy covering immovable property have to be taken as immovable property. Statement is not valid. Written insurance policy is a written document containing an agreement between insurer and insured. It's basically service. Service. Very simple. In 1897, did we have service? Did we have insurance policy that time? No. Apona that in the definition irundirukadu. Common sense. Because that time they'll cover only goods. It's a matter issue for purpose of recording the matter. It's a document. Hence, insurance policy is not definition of immovable property. I will just check in case law it's there, but I don't think it will be there in the case laws that I would have given you in the books. Because that time insurance policy in case law eppadi varum irukadu. Okay, are you following, guys? See, when we are solving 40 questions, one or two questions will be out of the box. They tested this twice. That's why we are doing workout. Are you following, guys? It's a very unique question. That means if you have the workout book with you, in the question important and mark panni vechukkanum, or edavadhu or star nu podnu, because it's little different. So day before exam, you don't have time to again watch this 1 hour or 1.5 hour video. In the question number 2, paathirukanu. Insurance policy, service not covered. That's it. Yes. Yes. Very simple. Insurance policy, why it's not covered, sir? I'm not able to understand. Very simple. Go to definition of immovable property. Okay. Is the definition covering anywhere document or policy? No. Land, not insurance policy. Benefits arising out of land, not insurance policy. Things attached to earth, not immovable, not insurance. Permanently fastened, not insurance. That's it. Therefore, not immovable property. Correct. See, your point is saying, then if you say, then everything else will be interlinked somewhere. No. You are saying is insurance policy is covering immovable property. I can't call it as immovable property. Simple. I have an Activa. It's a immovable property. I'm taking insurance on Activa. It will become PP. Yeah? Insurance will debit to P&L because Activa insurance is for 1 year. Got it? Feel free to ask the doubts case. Bullock and cow, I'm not explaining. Repeat of question. Okay. The path act done negligently shall be deemed to be done in good faith. Yes. Because good faith says that. Comment with help of provisions. What to comment? Adna good faith definition. How many times it came? So many times. Okay. You have to explain that in your own words. Look at that. Good faith has been defined differently in different laws. Contract Act, it has different meaning. Therefore, this definition is only for this act. Andamai. That's it. Okay. Next. Notice is back. Registered post. Okay. And acknowledgement due. A notice when required under statutory rules to be sent by registered post, acknowledgement due is instead sent by registered post only. Whether the protection of presumption regarding serving of notice by registered post under the GCA is tenable. In class you have studied, but I will quickly say. Notice by acknowledgement due and registered post. Same thing we have in our book. Where? In key provisions. Key provisions I would have given here. At the point, look at this. The statement we have is the question. Where a rule states that notice to be sent by registered post, acknowledgement due is sent by registered post, it is not tenable. That's it. Therefore, answer is it is not tenable. But what is the provision? What is acknowledgement due? Sometimes post you are putting sign in the house courier. That is called registered post. Acknowledgement வாங்கிக்கோங்க. அப்பதான் post is complete. Registered post no need sign. வீட்டுக்கு வந்து post boxல போட்டு போட்டுருவோம். Post boxல sir தூக்கி போட்டு போவோம். That's enough. So, if somebody is, where the provision is saying you get the acknowledgement, you have to send by that mode. You can't send in different mode. Are you following, guys, all of you? Shall we speed up the pace or continue same pace or slow down? Continue same pace. Hurry. Okay. Anybody wants me to slow down? No, then fine. Okay. Next. 20th question. Half over. In the Mursta half over. Okay. Sohan has issued a promissory note of 1,000 to Mohan on 17th May 2021, payable 3 months after date. Foundation ஞாபகம் sir. Okay. After that, a sudden holiday was declared on 20th August due to Muharram. As per the provisions of GCA, what should be the presentation of promissory note of payment? 19th August or 21st? நல்ல வேளை Muharram sudden holiday ன்னு சொன்னோம். Because sudden holiday means we always know it is next day. But as per GCA, even if it is Sunday, national holiday, whatever day, it is always next day, next to working day. Therefore 21st August. What if it was 14th August was Muharram? Then it will not be 15th August, because 15th August is not working day. It will become 16th August. Next day when the authority is open. Okay. In the May, they have not asked in exam because I am not setting the paper. Next. Question number 21. This is only my favorite question in GCA. I start class with this. What is financial year as per GCA? How many times they would have asked this? Many times. Ayush and Vipul are good friends and pursuing CA course. Unga pathaan pesanom. Okay. While doing group studies for the paper corporate and other law, they are confused about the provisions of section 3 of Companies Act. Section 3 provides a company may be formed. Oh, and the question illa, but fine. And the mayu question varum. When I saw CAs na, it will come like that. We will find that question. Okay, don't worry. They are saying section 3 provides a company may be formed for any lawful purpose by both Ayush and Vipul are in difficulty of the meaning of the word may, whether it shall be taken as mandatory or directory. Interpretation of statutes GCA mix பண்ணி கேட்டான். May is mandatory or directory? Directory. May is directory, shall only is mandatory. But in iOS you would have also studied 3 cases where may is read as shall. Okay, that's it. So what is may, directory, all of that. Are you following? Actually இது வந்து iOS question, but they have mixed it and it's coming over here. Are you following, guys? Clear? Next. Section 218 of Income Tax Act provides that company is said to be a company in which public are substantially interested. If a company which is registered under Section 25 of Companies Act, after the advent of the Companies Act 2013, the corresponding change has not been made in 218 of Income Tax Act, explain with the provisions of GCA how this provision of Income Tax Act will be considered. Beautiful concept. I have told in class also. Exam like this question will come. It has been floating in RTPs for quite some time. Which concept I will tell you in little detail. In general rules of construction, section number 8, in class also we would have discussed this. Beautiful concept. Towards the end in class we would have done. Work out, don't worry about which class. Okay. Construction and reference to repealed enactments. Okay. This concept, if now those who studied our class will know which concept. I will explain this again in detail because it's a very beautiful concept. In my view, in 2025, 3 attempts are there for CA Inter. Any one attempt, this question will be there in the exam. Okay. That's just a gut feeling, guys. Okay. Gut feeling has generally come out well. Because as a faculty, we will know. Romanala Kekla, it should come. Okay. What they are saying, Income Tax Act is referring to the 1956 Act Section 25. But Income Tax Act 1961. Now, this act is removed and replaced with Companies Act 2013. But in this old Income Tax Act, they are still referring to the old Companies Act. What to do in Kekran? What to do? It means it will automatically lead and refer to the new act. Same thing we would have done in book also. Where an act is referring to a provision which is amended or act is replaced, then you are referring to the new act. That only they are saying here. They are referring to 25 of Companies Act 1956. Now that new act 2013 came, you have to refer to the parallel section of Companies Act 2013. You will not refer to section 25 of Companies Act, the deemed prospectus. This concept will now be in some other section of that concept. So, what they are saying, as per the question, it will be referred to the new act. Where is that? So every act, it is later, if this is only a key point. If a later act merely makes a reference to a former act or existing law, it is only a reference and all amendments, repeals, new law subsequently made will have effect unless it is saved by the new provision. Okay, the new act will take the replacing the old act unless they are saying don't do that. Okay, how to write the answer you read, guys. Presentation is, that's why you have this hard copy or soft copy, whichever mode you are watching. We are only focusing on accuracy of answers, here and there presentation. Explain briefly 4 effects of repeal under section 6. I told you guys in class to mug up 4 concepts in GCA. What are the 4 concepts? Definition of immovable property, definition of good faith, definition of document, and effect of repeal. I told to mug up these 4 because this only they asked directly. These are all the past history. Immovable property came so many times. Good faith came so many times. Now effect of repeal. 2 times it got tested in 2 May exams. Okay. Generally ICA has a thing. Mail repeal ana mail mattum dhaan varum. November la varad. If you see the pattern. Okay. All that I do it for expected questions. All that analysis. So here இதே பேஜ்ல effect of repeal. 4 things: revive, not anything repealed, previous operation, right, penalty, enquiry. Previous case will continue, any refund will continue, all those points. Sir, then why did you ask us to mug up even document definition? Document is one which is not yet tested. I should not only tell you to mug up what is there in the past, but what can come also. This is one thing that can come. So that's why I asked you to mug up document. Okay, same thing, the same points what we have in book, those 5 points. Clear? That's it. Next, 24. What do you mean by good faith? We're talking about good faith. November 19. What is good faith? Mug up that fully, guys. One answer you learn good faith, it's done. Clear? Now I'm going fast because what is repeated, I'm not spending time on that. Okay. Define the term affidavit. We would have studied. I told you to mug up one sentence there in affidavit. Affidavit means in its grammatical variation and cognate expressions, affirmations and sollirpen. That point you should write. Definition of affidavit. Affidavit na the court la vandu aluvaangle. Na satyam pandra, I didn't do anything, giving evidence. Affidavit, oath, swear. Are you following? Person giving evidence. With its grammatical variation and cognate expression shall include affirmation and declarations of the person. By law, allowed to affirm. Very important. Allowed to affirm na, simply I am going to court. Can I run to that place and tell na promise pandra? No. Who is allowed to affirm only they can affirm. That's it. Definition. Like this nowadays don't expect in 2025 exams, guys. This is November 19. அப்போ அப்படி தான் கேட்டாங்க. Now they're asking only case study based questions. If you can even see the pattern, see, these are all direct questions. If you see on top the questions that we did, see, these are all 2023, 2021. Can you see here? 2023, 2021 case. Here, see, 2022 case. That means those days it used to be direct. Now they're asking what, guys? So that means 2019 timeline it used to be direct. Now they're asking case study. This is a proof for you. Okay. Next. Which question? Affidavit over. 26 November 20. Okay. Nice. Case study questions only we enjoy. K went to a jewelry shop to purchase diamond ornaments. இப்படிலாம் டெம்ப் பண்ணுறான் பாருங்க, காசு இருந்தால் என்ன பண்ணலாம், சிஏ படிங்க அப்படின்னு. தி ஓனர்ஸ் ஆஃப் த ஜுவல்லரி ஷாப் ஆர் நொட்டோரியஸ் and indulging in smuggling activities. Mrs. K purchased diamond ornaments honestly without making proper enquiries. Was the purchase made in good faith? Answer. A honest purchase made carelessly without making enquiries cannot have to be said to be in good faith so as to convey good title. Hold on. A thing shall be done to be done in good faith, where in fact done honestly, whether it is done negligently or not. But this is as per General Clause Act. They are asking us as per which act? As per General Clause Act only. The definition of good faith as in generally understood in the civil law and which may be taken as practical get and understanding expression. Indian Contract Act, nothing is to be done in good faith which is done without due care. That means as per Indian Contract Act, this is not good faith. Correct? Because Indian Contract Act says that doctrine of caveat of emptor. Buyer has to be careful. Buyer should make enquiries. So, how he has given the answer? Look at this. This question, as per GCA, it is a good faith. But same thing in our book also I would have given. Look at this. StudyMat has this. Good faith, a honest purchase made carelessly without making proper enquiries cannot be done in good faith so as to convey good title as per Indian Contract Act. But this paragraph is there in your StudyMat. That's why I have it here also. Are you getting it? Therefore, the answer also, if you see, they are saying here, clear paranga, as per Indian Contract Act. So he has given the answer as per Indian Contract Act. So this is one case where they are giving the final answer. In exam, if it comes like this, what to do? Okay. Exam, always our thought process should be, yes, what is right? But sometimes in a very few questions, now out of 40 questions, this is the first question where we have, look at this, case 1. Oh, the case 2, sorry, my bad. So sometimes we will have two alternative assumptions. ஓகே, இதுவும் கரெக்டாக இருக்கும், அதுவும் கரெக்டாக இருக்கும். பட் வாட் ICA is following, we have to follow that. Here, because study material has this word where they are telling you good faith. இப்போ எக்ஸாமில் குட் ஃபேத் எழுதுனா this definition also I will write and this also I will write because book has that. So you give the conclusion as per Indian Contract Act itself because book has it like that. And past also, not only this question, including the latest Jan 25 RTP has this question in MCQ where they have answered as per Indian Contract Act. Yes, son. Yes. Yeah, his doubt is he is using iOS. Indian Contract Act is here. GCA came after that. So GCA is not applicable to Indian Contract Act. But for a transaction which is applicable, whichever act is more specific. Correct. So we will go with Indian Contract. And also Sale of Goods Act came after Indian Contract Act. Sale of Goods Act only has the principle of Indian Contract Act. Are you getting it? இதை நம்ம அனலைஸ் பண்ண வைக்கணும், அனலைஸ் மோர். பட் கன்சிடரிங் எக்ஸாம் அண்ட் வேர் எக்ஸாம் ஹி ஹஸ் கிளியர்லி டோல்டு ஆஸ் பர் GCA குட் டைட்டில் போகுமா, போகாது. ஆஸ் பர் GCA போகும், பட் ஆஸ் பர் இந்தியன் கான்ட்ராக்ட் இட் வில் நாட் கோ. இந்த கேஸ் கோர்ட்டுக்கு போனால் வாட் வில் ஹேப்பன்? கோர்ட் வில் கிவ் இட் டு பெனிஃபிட் ஆஸ் பர் இந்தியன் கான்ட்ராக்ட் ஆக்ட். தட்ஸ் வாட் இஸ் கிவன். லுக் அட் திஸ். ஆஸ் பர் இந்தியன் yeah, look at this. As per that's why he has given one disclaimer mari. The definition of good faith as in generally understood in the civil law, which may be taken as a practical guide in understanding the expression as Indian Contract Act. That's why he has done a detour here. So in the my question vanda, go with ICA's answer. Let's not take that risk. Are you getting it, guys? Okay. And the same is there in Jan 25 RTP. Remember that. Second question, there are two ways to reach from city A to city B. There are many ways to reach. Bus la polam, train la polam. Okay. The distance between the two cities by roadways is 100, waterways is 80 kilometers. Boat liyum polam. How is the distance measured for the purpose of GCA? Roadway or waterway? No, straight line between 2 points. Everybody confused pantan. Look at this. It shall be the straight line on a horizontal plane. Roadways kadiyadu, waterways kadiyadu. Straight lane. That's it. Are you following, guys? Okay, 3 marks. Yes. Twenty-fourth question or case X is buying from watch. Yes. Okay. So 24th question we skipped that time fastly. That good faith came where X purchased the watch from Y carelessly without making proper enquiry. Can it be made in good faith? As per GCA, answer is yes. But as per Indian contract, answer is, if you look at this, they are giving conclusion as per Indian எங்க எழுதிருக்கான், எழுதவே இல்லையா? Okay, it is to be determined with reference to there is anything done with due care and attention which is not manifest presumably done in good faith. But answer is as per Indian Contract Act. That means this next answer is more betterly explained because they have mentioned Indian Contract Act. You got the clarity? They are giving conclusion for this as per Indian Contract Act because StudyMat has both the provisions. That's it. Clear, guys? Okay. Purila. Understood? Sure. Feel free to ask the doubts because the doubts you have, those who are watching online also can have. So raise the hand. Don't worry about recording, guys. I am not going to edit anything. நீங்க கேக்குறது அங்க போல, பட் ஆஸ்க் யுவர் டவுட்ஸ். ஓகே. டிஃபைன் த டேர்ம்ஸ் அஃபிடவிட் குட் ஃபெய்த். ஸோ அப்போனா எக்ஸாமில் இஸ் ஆஸ்கிங் டிஃபைன் குட் ஃபெய்த், யூ ரைட் திஸ் டப்பா அண்ட் ஆல் திஸ். இந்த நம்ம இந்த டப்பா இருக்குல்ல, ஃபுல்லி யூ ரைட் இன் எக்ஸாம். அப்போ தான் 3 marks இட்ஸ் வர்த் இட். ஆர் யூ ஃபாலோயிங், கைஸ்? சொல்லுங்க. ஆமாம். See, according to GCA, definition ends here. His doubt is, yes sir, இப்படி ஆன்சர் பண்றாங்க ICA. Correct. According to GCA, if you take the bare act, it ends here. But our StudyMat has given 3 more points. It depends on facts and circumstances. Good faith has different meaning in different acts. And in Indian Contract Act, the concept is வேறன்னு சொல்லி StudyMatல கொடுத்துருக்கான். If study matter, they have not given other contradictory concepts. This one concept he has given as per ICA also, Indian Contract Act. So since it's there in our material, our questions are based on materials. That is why for this one question, they are giving that answer. Are you getting it? For example, if you take, if a holiday is there now, we are always taking next day. But as per negotiable instrument act, it is even previous day. But that is not coming here because study matter is not having that. That's it. Because our material is designed like that. That's all. Clear, guys? Okay. Affidavit, good faith, they are defined. Okay. Inga paranga, they have just defined what is good faith. And the key points, the Indian contract எழுதலாம். Okay. Next, 28, fast. Last 12 questions. Let's try in 15 minutes. Okay. அப்படிதான் சொல்றீங்க சார். Ajit was supposed to submit an appeal to High Court. I can predict what the question is. You can also predict. And எப்படி என்ன இருக்கும் question? Leave next day. But we will read. On 30th March, which was the last day on which appeal could be submitted. Unfortunately, on that day, High Court was closed due to lockdown, due to COVID. Examine the remedy available. What you should do? Next working day, COVID, இப்போதான் lockdown start ஆயிடுச்சு 30th March. Court is closed for 6 months. அப்போ 6 months கழிச்சு தான் வரும். How they have tested? See, COVID timeல July 21ல கேட்டிருக்கான். COVID related question. Okay, COVID batch. So, Ajit can submit appeal on the day on which the High Court is open. When it will be open, we itself didn't know. அவ்வளோதான், அது நீங்கள் எழுத வேணாம். That's it. Okay. Next, question 29. The MCA published in Gazette of India the proposed draft rules to amend certain rules under Companies Act. The MCA made some modifications in the draft rule already published. In the light of the provisions of GCA, answer the following. Is it required for MCA to publish a draft of the proposed rules? We are discussing how a law is made. I was told in class, this one. This one. Provision applicable for making rules or previous law. I would have told you have to publish a draft of the, I told in class also, correct? Publish a draft. Yes. Let's go check. Yes, draft is needed. Next. In case of irregularities in the publication, can it be questioned? No, draft la eppadi question பண்ணுவான். See, can it be questioned why there are irregularities? அதனால தான் draft. If there are irregularities, I will make the changes. So, in case of any irregularity in publication, can it be questioned? What they are saying, no, in case of irregularities, it cannot be questioned. The publication official gazette or bylaw shall be conclusive proof it has been duly made. Later, any irregularities in draft cannot be questioned, but you can amend it later. Meaning, if there are mistakes, it will be there until amendment comes. That's it. Is MCA entitled to make suitable changes in the draft? Yes. If there are changes, yes, they can make this. Now you got the clarity. Yes, MCA is entitled to make draft before publishing them. Draft na mistake irukkum, guys. Okay. Is it necessary to republish the rules in the amended form when the changes are ancillary to the earlier draft? Meaning there are act and rules. They are testing two concepts here, and the act rules concept too. If the act is now lightly amended, should I again change the rules? Not necessary. It will still be there. Answer is no. It is not necessary to republish the rules. Are you following, guys? Look at this. We studied one concept that rules can be made before also. Okay. That will come this side. Making of rules and bylaws. Look at this. The power may be exercised anytime after passing the act or regulation, but rules shall not take effect till the commencement of the act. Rules thing epona panikkalam, munnadiyum panikkalam, I told. Rules can be made before also. Act can come later, but rule comes into force later. I don't have to repass the rules again. Remember this case we have done in class. If act is 2013, if rules are 2014, act rules came later. But if the rules are 2015, vechkonga. Act came in 2017. Is it fine? Yes, it's fine. But rules comes into effect after act comes into effect. Next, quickly, question 30. Landlord staying in Delhi, rented his flat. In my question, what is this? Notice sending in post. No, I'm guessing. Okay. Tenant for 20,000 per month to be paid annually. An agreement was made between them that during the tenancy period, if A requires his flat to be vacated, 1 month prior notice is to be given to B. After 8 months, a notice was sent by A to Mr. B to vacate his flat by registered post, which was refused to be accepted by C, wife of B, and B denied to vacate the flat on non-receipt of notice. B is saying, I didn't get the notice. Unga wife தான் தூக்கி போட்டாங்க. So, my duty is to send it to you. This only we discussed in the starting. The 3 points: properly addressed, prepaid, posting by registered post, covered. That's it. Now, will I arrest wife and B or only B? B. I will not arrest the wife because notice is on B. So, wife was smart here. Okay. Next, question number 31. What is the meaning of official gazette? We studied in class. Official gazette is the official publication of the government, which will be published on how many basis, guys? Weekly basis, monthly basis, quarterly basis? It's published on a weekly basis. It is the public journal, authorized legal document. Official gazette, na, logically for those who are watching, it is where the official news of government comes for the first time. That's it. What is the gazette? It is published on a weekly basis. It is the gazette which prints all the updates. It is printed by the Government of India Press, GOI Press. Same thing is there here. It is printed by the Government of India Press. Okay. 32, last 8. Whenever an act is repealed, it must be considered as if it never existed. Yes or no? This is basically effect of repeal. Those 5 points I told you, guys. Mug up, I told I will come in exam. May 23 it came. What is effect of repeal? 3 marks or 4 marks? I think 3 marks only. All those 1, 2, 3, 4, 5. Inquiry, penalty, right, all of that. Are you following, guys? Clear? Next, 33. No person shall be prosecuted and punished for the same offense more than once. Yes or no? Yes. You can only be punished only once for the same offense. But if it's different offenses, you can be punished in different act. If you are acquitted of one, does not mean you are acquitted of the other. In our class, I have told, just because you didn't do assault, hitting, theft you would have done, wallet. Okay, May 23. Same concept. Are you following, guys? Clear? Next. Period question on that. RTP November 23. Okay. Question could be big, but I am guessing the answer will be small. Neelu Chandra was a director in Laddu Sweets Private Limited. Once while dealing with supplier of raw materials for company, she agreed to get some secret commission from supplier for making the deal. Because I signed deal with you and I got a commission. Afterwards, on finding the facts, the company has filed a suit against Neelu Chandra. She contended that section 66 of Companies Act provides a director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or his relatives, partners or associates, and if such director is found guilty of making undue gain, he shall be liable to pay an amount equal to that gain to the company. She contended section 166 is applicable to male directors only. She being female, it will not be liable. What concept? Here in law, he himself or his relatives, he includes she. Masculine includes feminine. இப்படிலாம் கேட்கலாம் பாருங்க question. Section 166 வச்சு குழப்பறோம். Masculine includes feminine. That's it. You know the answer. Neelu Chandra is bound to comply with section 166. Beautifully you are given. Look at this. First provision, analysis, then conclusion. Are you following, guys? Clear? Recording students, you will read this. I am only getting through the provisions. Or do you want me to read this also? Okay, no, because I am just trying to be fast. Next, question 34, MTP October 23. Shri was supposed to submit an appeal to High Court of Delhi on 8th September. That was the last day. Next day. Okay, appeal could be submitted. However, on that day, High Court was closed due to lockdown in Delhi for 30 days due to foreign delegates. G40 submit to examine the remedy. Next working day. That's it. On the day on which the High Court is open. That's it. 5 more questions. Getting far. Again, same question came. G40 submit. 8th September. What do you take? Next working day. Let's analyze. MTP October 23. Repeat H. Okay, that is my fault, guys. Leave it. One question coming. MTP March 24. New syllabus. Now new syllabus questions. Can you see new syllabus na இப்படி பெருசாக்கிட்டான் பாருங்க. Case study. Rakshit purchased a new house and after some time he shifted to his new house. He was regularly filing income tax return but did not update his address with the income tax department. The income tax department sent a show cause notice to Mr. Rakshit where the time limit to reply was 15 days from serving of notice. I think again that post question. The notice was properly sent by registered post to his address which was in the records of the department. In my records this address only is there. The notice reached that old house and present owner of that house refused to accept the notice. He didn't take. After a certain period, income tax department took a penal action against Rashid. He requested the department, please, he should not be charged that he didn't receive the notice. Is he right, guys? No, because he didn't update. I'm update panla. His mistake. But your answer should have those points. Properly addressed, prepaid, posted by registered post. If it is sent to this, notice is valid. How many times we are seeing this question, guys? That means what you should do now after this video gets over, you should go and the key provisions la in the dabba update you should eat it and wait for the exam. Okay. Next question 37. Look at this. How many times it came? Finally, my favorite question. Financial year na enna kekran. Okay, a confusion regarding meaning of FS arose between the financial executive and accountant of a company. இங்க எதுக்கு CA ன்னு போடல? They didn't want to make fun of CA. அது கூட தெரியாதான். Accountant பண்ணிட்ட பாருங்க. Both were having different arguments regarding meaning of financial year and calendar year. Financial year na April to March, calendar year na as per British calendar Jan to December. 1, 2, past exam December. It came more, guys. இதுக்கு மேலயும் இருக்கு. Only few we are writing here. That's it. 3 marks. Let's hope that in 2025 they repeat this again for you guys. Chances are less because it came recently many times. What is the meaning? Okay, definition ketranga. What is movable property other than immovable property? What is person? This all we saw no in class. Definition of person: company, association, body of individuals. That's it. Moone. Okay. Next, rule and oath. Oath is nothing but affidavit. Affidavit, oath and swear is same. Rule what he has given. As per 351, rule shall mean a rule made in existence of power conferred by enactment, shall include regulation under enactment. Ideally, they should not be asking this in exam. December 21, April 22 and MTP. It's a one-off question. Rule alone, make a note, guys. Rule shall mean a rule made in existence of power conferred by an enactment and shall include regulation as rule made under any enactment. But my view, it will not come in new syllabus. Make a note, but இதெல்லாம் old syllabus pretty bang 21-22. So varakudadu, but just make a note because it's there in the new MTP also. Make a note of rule. Recording students, pause and make a note because rest you have it in our book. Correct? Okay. Last 2 questions. For you guys, we'll finish this. I'll again go back to rule if you want to copy. 39. A clause that begins with the word is iOS. Notwithstanding anything contained is a clause that has effect of making provision prevail over others. It can operate at 4 levels. Explain any 2. What is this? Notwithstanding. Well, so notwithstanding anything contained is called non-obstante clause. Subject to clause and this question, let me come back to this case. November 23. Okay, I'll come back to this. Last I will take that. Let's finish this also. Avinash currently holds the position of a whole-time director, KMP at Moon Pharma Limited, company that maintains substantial ownership in X Limited, Y Limited and Z Limited. So there are 3 subsidiaries which are X, Y and Z. Avinash has expressed his desire to expand his role as whole-time director through encompass both X and Y. He wants to be whole-time director in both the companies. Determine the validity of his appointment as a whole-time director in additional companies as per GCA. Okay. As per GCA or Companies Act, they are defining what is subsidiary company controls the composition more than half. Taking into account the above provision, X, Y and Z are subsidiaries. We are told it's subsidiary. Regarding the question if Avinash can be whole-time director in multiple companies, That singular includes plural. So if you can be KMP, whole time director X Limited, provides that whole time director of KIM shall not hold office in more than one company except its subsidiary at the same time. So subsidiary here includes plural subsidiaries. Therefore, a whole time director may hold office in more than one subsidiary as per present law. Hence, Avinash can hold office in both X and Y. Okay. Now this 39 mattu mudikalam. 39 in our class we didn't discuss. So let me just discuss here because it is a November 23 question. That means out of 40 questions, one question is like that. That's why we are doing this workout. In my question vanda we will add it. Okay. Fine. I'll just teach this over here. Then you make a note, screenshot and take a note. Notwithstanding clause na, you know what is it. Notwithstanding na, that will override over other things. But idla there are 4 types in solran. What are the 4 types? Notwithstanding any section contained in either subsection, notwithstanding anything contained in the statute, notwithstanding anything contained in the specific section or subsection, notwithstanding anything contained in any other law for the time being in force. Beautiful, simple points na solran. First, notwithstanding anything contained in any other section or subsection. For example, let's take Companies Act. Let's say this is used in section 42. Okay. அவன் சொல்றா notwithstanding anything contained in another section or subsection of that statute within that law, with that means 42 will override all other 469 sections. The clause will override such other sections and subsections. Notwithstanding anything contained in the statute, this will override the full act. Full act it will override. Are you following, guys? Above only in other section. That means first I will just rewrite again. If they say in 42, for example, if notwithstanding anything contained in section 43 to 52 and 42 now, 42 will override only this range, it will override. In second, it will override the full act. Third, notwithstanding anything contained in specific sections or subsection, under section, this clause will prevail over the other. Notwithstanding anything contained in specific section or subsection of all the provisions in other statute. So let's say section 42 is mentioning that it will override FEMA Act. Then it will override the other act. Are you following, guys? Not the whole act, the section in FEMA. Section or subsections in the other act. Notwithstanding anything contained in any other law for the time being, this clause will override all other laws. Are you getting it? Above வந்து அவன் mention பண்ணும் FEMA மட்டும், then அந்த FEMA மட்டும் I will override. Here all other laws. So 4 types of notwithstanding. I will override my act, I will override other acts, I will override some sections in our act, I will override some specific act. That's it. For the time being in force na, at this point of time, whichever acts are active. Whichever, for the time being in force na, at this point, whichever act is active. Are you following, guys? That's it. We are done with GCA 40 questions. Was it useful, guys? Yes, speed is fine. Fine. We'll continue in same pace for rest of chapters also. Thank you those who are watching online. Bye bye. Thank you. Hi guys, welcome to the workout of meetings chapter, the one most of you are waiting for. In meetings workout, we have 50 plus question answers we are going to discuss. Like I always say, 1 hour la mudika porom. Not possible for this chapter. Let it take its time. And then I also have the Gen Z notes of meeting where I will keep referring to during our revision. We also have a separate video of Gen Z revision itself for full meetings. Concept book also that you guys have used in the class, that also we have for referring. And also lastly, we also have the mega timeline that we have for full meetings chapter, full all the timelines before and after AGM, which we will refer. This also is detailed explained in a separate video. We are just referring back to our notes because it becomes easy for the whole workout. Whichever material you have also, you can follow that because provision is the same. It's only the style of presentation. Along with this 50 question answers, for a few questions we will also discuss on presentation style. Okay. At the end of this chapter, we will see some questions. How do you answer for the same question, 2, 3, 4 marks, and all of that we will discuss with the questions. Today we also have a special guest because we have 50 questions to read. My throat might pain, and to help us, this has been my dream for so long that I wanted students also to participate in a recording class. So you guys from your house also, students are sitting here but you will never see them and hear them. One day in the future through CA Classroom, I'm very sure that we will launch a class where there will be two videos, one you see me and one you see the students who are attending, so you get that personal connect. Today is the first step in that, where we have a student who's going to read questions for us at different pace. Hi Sanjeev, கேக்குதா?
Hello, sir.
Are you all able to hear him, guys? Yes ன்னு நீங்கள் வீட்டில் சொல்லுங்கள். Maybe after 5 years நீங்கள் வீட்டில் சொல்கிறதும் எனக்கு கேட்குற மாதிரி பண்ணுவோம். Okay, fine. Now we'll start off with question 1. Yes Sanjeev, read the question.
At a general meeting of XYZ Limited, a matter was to be passed by a special resolution. Out of 40 members present, 20 voted in favor of the resolution, 5 voted against it, and 5 votes was found invalid. The remaining 10 members abstained from voting. The chairman of the meeting declared the resolution as passed. With reference to the provision of Companies Act 2013, examine the validity of the chairman's declaration.
Okay. What they're testing here, I hope you followed what he was reading. Of course, I will reread the key points because you have to read every question in exam 2 times. Here the testing section 114, which talks about special resolution, when a resolution is valid. They say 3 times the vote should be in favor than against. Do we take all the members for that? No. We take only those votes which are passed totally in the election. For example, over here, out of 40 members present, we only take people who are present. We don't take about total company has 3000 members, sir. They didn't come. I don't care. We only consider people who are present in the meeting. Out of 40 present, 20 in favor and 5 voted against, 5 were invalid. That means out of this 40, invalid 5 votes I will remove. I should not consider for my special resolution. Remaining 10 abstained from voting, them also I will remove. So who are the people who actually voted? 40 minus 5 minus 10. In calci also you can do. Without calci also we can do. That means I should only take the number of people who have voted. I should not care about the people who have not voted or who have abstained from voting or whose votes were invalid. Now in this 25, how many voted in favor? 20. So 20 divided by 25 percentage is close to 80 percentage. Therefore, will there be a special resolution, guys? Yes, because you need more than 75 percentage. Are you following, guys? Final answer, yes. Decision of chairman is in order. Since this is the first question, let's see how they are presenting. Section 114, like I said, for a valid special resolution, the votes cast in favor of the resolution by members present in person or by proxy or postal ballot are not less than 3 times the number of votes cast against the resolution, so entitled and voting. That is the main keyword. This is the main keyword. Then other points are, the notice should contain your passing special resolution. Members should have been specified in the notice. Notice should mention that there is going to be SR. That means section 102. Explanatory statement, all that will be attached. But this point 3 is the key provision, guys. ICA will give marks for this provision only. Then coming to analysis, in this terms we have found we will not count even absentees, invalid votes should not be taken into account. And simply he is saying votes cast 20 being more than 3 times votes cast against. So 20 is more than 3 times votes cast against. You should not compute 75% also, like how I did. For rough working, yes, because the provision doesn't use the word 75%, it says not less than 3 times the votes passed against. So 20 is more than 5, more than 3 times. So 5 into 3 is what? 15. 15 or more is there now, SR is passed. So nowhere in the act they use the word 75% or 3/4. அவன் என்ன சொல்றான்? Votes in favor is 3 times votes against. Okay, next question. Question number 2. Yes, quickly.
Examine the validity of the following with the reference to the relevant provisions of the Companies Act 2013. The Board of Directors of Stray Limited called an extraordinary general meeting upon the requisition of members. However, the meeting was adjourned on the ground that quorum was not present at the meeting, advised the company. Mr. Beam is holding 500 shares of ZYZ Limited of total worth of rupees 5,000 only. Advise whether he has right to inspect the register of members.
Okay, Excellent. What they are saying, first question, member called for an EGM. Member called for an EGM. Generally in meeting, if quorum is not present, meeting gets adjourned. Here, member called for an EGM, and however the meeting was adjourned on the ground that quorum was not. நீங்களே கூப்பிடுவீங்க ஒரு மீட்டிங்க்கு, நீங்களே வரமாட்டீங்கன்னா எப்படி அட்ஜர்ன் ஆகும்? ஸோ செக்ஷன் 100 ஹேஸ் ஒன் எக்ஸெப்ஷன். Read along with section 103, quorum. It says, where in an EGM, members who called members itself did not come, meeting will not be adjourned. Second, Beam is holding 500 shares of total worth 5,000. He has shares. Can he inspect register of members? Can member inspect register of members in section 88? Can member inspect, guys? Yes, member can inspect. Therefore, the meeting stands cancelled. First, it cannot adjourn. Second case, accordingly, Beam, who is a shareholder of company, has the right to inspect register of members without payment during business hours. Sir, I am getting confused, sir. Member can inspect, a member cannot inspect. Simple. Anything which has member details or related to members, he can inspect. Minutes, avanoda meeting, he can inspect. Member can't inspect minutes of board meeting, not related to him. Member can inspect FS. Member can't inspect books of accounts because that is management side. Management prepares it. Member can inspect register of members because my name only is there. My community name is there, so he can inspect. Common sense, we will answer. Next, question 3. Let me read this quickly. We will keep switching, guys. Okay. Examine validity of board. In an AGM of company having share capital, 80 members present in person or by proxy holding more than 1/10 of the total voting power demanded for poll. Chairman of the meeting rejected the request on the ground that only members present in person can demand for poll. Let me answer this using our Gen Z notes. Here they are talking about, can proxy demand for a poll. In proxy we have many provisions. Proxy cannot talk in meeting. Proxy cannot do anything in the meeting, but proxy can do only one thing. Proxy can demand for a poll. Okay, where is it? Proxy. Yeah. If one, okay, not this. What he can do, cannot do is he cannot talk, cannot vote by show of hands, no quorum, but he can only vote by poll. Because he can vote by poll, he can demand for a poll. Poll is which section? 109. So 1/10 of total voting power or 5 lakhs paid up share capital, whichever is less, it's enough to demand for a poll. So members can vote, proxy can vote for a poll, so proxy can also demand for a poll if he has 1/10. Here he has more than 1/10 of total voting power. Yes, therefore the proxy, the demand for poll may be, okay, so in case by a member present in person were allowed not less than 1/10, therefore chairman cannot reject the demand for poll. Are you following, guys? Understanding? So here you will write section 109, demand for a poll. Poll can be demanded if somebody has 1/10 or more of the total voting power. Even proxy can demand for a poll, because proxy panna vendiyad only one thing is he can vote by not show of hands. Only thing that proxy can do, guys, we would have seen, only thing that proxy can do is what? Vote by poll. He can only vote by poll. So since he can vote only by poll, he has the right to demand for poll. Okay, if he has that 110%. Next, question number 4. Examine validity of board of directors. In an AGM, during the process of poll, again poll is section 109, the members who earlier demanded for poll want to withdraw it. The chairman of the meeting rejected the request on the ground once poll started, cannot be withdrawn. Sir, I didn't study this, sir. Common sense, very simple. You filed a case on somebody. Can you withdraw that? Yes, he came and threatened me, sir. I will withdraw. Threaten பண்ணிட்டான். இல்லனாலும் you can withdraw. Suddenly you change your mind. So if somebody demands for a poll, poll will take place. If he says I don't want the poll, poll will not take place. Chairman should follow what members request if they have the right to request. Chairman cannot reject it. 2 times MTP RTP, again same provisions. You will write section 109. You will write someone should have 1/10 of total voting power or holding shares aggregate not less than 5 lakh. Okay, whichever is lower you will take. In case of any other company, member present in person or proxy not less than 1/10 of total voting power. If there is no shares, withdrawal. The demand for poll will be withdrawn by the person who made the demand. If you make a request, you can withdraw that request. You asked me a doubt. By the time I replied, doubt got cleared. You will delete the message. I can't ask why you deleted the message, why you don't want the explanation. No. If you make a request now, you can, of course, close that request. Next, question number 5. Yes, Sanjeev.
Examine the following with reference of the provisions of the Companies Act 2013. Mirage Limited issued a notice with the agenda for 9 businesses to be transacted in the AGM. 2 businesses were regarding appointment of Mr. S and Mr. P as director. The chairman decided to move the resolution for all the 9 businesses together to save the time of the members present. Examine the validity of the resolution.
Question என்ன பண்றோம்? There are 9 businesses, correct? 9 businesses now. 9 times you have to pass resolution, ordinary or special. That means voting has to happen 9 times. என்ன chairman சொல்றான்? எல்லாமே சேர்த்து ஒரே வாட்டி vote பண்ணிடலாம். Means let us not do 9 times voting. All 9 businesses only once. Come on guys, pass the resolution. Special resolution pass பண்ணுங்க. Are you all okay? Proceed. Can I do that guys? How can I do that? Maybe you want to vote yes for something. Maybe you want to vote no for something else. எல்லாமே சேர்த்து வச்சு எப்படி vote பண்ணுவீங்க? It's like saying, let's say you want X to be the chief minister and you want Y to be the prime minister. I am saying for both together do the vote. அது எப்படி போட முடியும்? I will have different decisions, correct? So here answer for the sake of avoiding, yeah, every resolution is moved separately in an AGM. There is nothing illegal if chairman desires that 2 or more resolutions should be moved together. See, act is actually not talking about this, but if any member objects, it cannot be done. Where notice has been given for several resolutions, each resolution must be put separately. If the meeting unanimously adopts all the resolution, this would not be illegal barring a few occasions. Why are they answering like this without any section number? Because idukku Companies Act la guidance illa. Companies Act just tells pass resolution, there is no guidance. Then sir, why are we discussing this? It has come in May 18 and RTP. There is no guidance for this in Companies Act. So what is Companies Act saying? Hence in instant case all the 9 businesses cannot be moved together as 2 business regarding appointment of S and P as directors. Besides these 2 resolutions, other 7 can be moved if members unanimously agree. அவன் என்ன சொல்ல வரனா, he is also giving an open-ended answer only. Appointment of S and P cannot be done together because you may want to have S, you don't want to have P. So இதை டெஃபினட்டாக சேர்த்து பண்ண முடியாது. அதான் சொல்கிறான், ரிமைனிங் 7 if all the members are okay, 100% members are okay na என்ன பிரச்சனை? Even if one member is against, don't do it. So common sense answer. Companies Act has answer for this? No. Are you getting it guys? When it came May 2018, new syllabus that time, students, and that to MTP October 18. Okay, that's it, never came back. So sometimes if you get questions like this where it is not there in the act itself, not there in act is different from you not studying. Okay, not there in act or you didn't study also, common sense la answer பண்ணிருங்க. 9 out of 10 times it will be correct. Yes Sanjeev, next one.
Examine the following with reference to provisions of Companies Act 2013. Zorab Limited serve a notice of general meeting upon its members. The notice started that resolution to increase the share capital of the company would be considered at such meeting. A shareholder complained that amount of proposed increase was not specified in the notice. Is the notice valid?
Is the notice valid guys? What is happening? Notice stated that resolution to increase share capital of company would be considered at such meeting. The notice stated, yeah, a shareholder complained the amount of proposed increase was not specified. Is the notice valid? Now, whatever you are going to pass resolution for, meeting should clearly state. You are going to increase the share capital. Okay, currently share capital is 10 lakhs. It is going to increase to what? 70 lakhs. Adu kudukkala. I am going to increase share capital to what? Then only I will be okay. If you want to increase to 70 lakhs, na I am fine. But if you want to increase to 7 crores, na I am not fine. Adu therinjadana I will come prepared. So again, is this there anywhere in the exam? Anywhere in the question? in the syllabus? No. But syllabus talks about one thing, explanatory statement under section 1 or 2, which says if any resolution is going to be passed, give detailed explanation regarding the same. Have they given detailed explanation here? No. Therefore, I am just guessing the answer. The notice therefore is not a valid notice. Are you understanding guys? These are all common sense questions. Full information is not given. I am inviting you to marriage. The invite should have all basic details. I gave only boy's name. பொண்ணு பேர் கொடுக்கல. இது இன்வைட் தான், நீ வருவ எக்ஸைட்டடாக வருவ யாருன்னு பார்க்குறதுக்கு. பட் இன்வைட் இஸ் நாட் கம்ப்ளீட். லைக் திஸ் யூ கேவ் half information. Okay. Next. Question number 7. Yes Sanjeev.
M Limited held its AGM on September 15, 2017. The meeting was presided over by Mr. Venkat, the chairman of the company's board of directors. On September 17, 2017, Mr. Venkat, the chairman, without signing the minutes of the meeting, left India to took it after his father, who fell sick in London. Referring to the provisions of Companies Act 2013, examine the manner in which the minutes of the above meeting are to be signed in the absence of Mr. Venkat and by whom.
How many times it came? Okay. Now, what is the question? Crux avana parchan. Chairman வந்து meeting 15th September got over. Immediately 17th he left. Why? Father was not well. Remember, family only is more important than anything else. Okay. So let him leave. That's not my problem. He did not sign. What is the resolution? Section 104 says, chairman of a company, if he is not able to sign the meeting, this is which book? Minutes are which one? Minutes. So section 118 read along with section 104. 104 is chairman, 118 is minutes. 118 we have a concept called signing of minutes. We would have seen that. If I go to 118, signing of minutes. If chairman is unable to sign, yes, board meeting means chairman off. Next meeting, general meeting, director authorized by board. This is what meeting? Board meeting. Company's board of directors, correct? Oh, AGM. It is the AGM. Therefore, AGM means if the chairman is not able to sign, then who will sign? Anybody else authorized by the board of directors. So what if he is not there? Somebody else can sign. Therefore, minutes of meeting referred in the case can be in absence. Any other director is authorized by the board. Update that keywords. This is the provision, but I am connecting with by adding the word here, Venkat. In absence of director, who is Venkat, others can sign. Now, same question. This can be for 4 marks, this can be for 3 marks, this can be for 2 marks. Sir, how do I write if it comes for 2 marks? If it comes for 2 marks, I don't have time for writing provision, analysis, conclusion. One para. One paragraph. How I will write? As per section 118. The minutes of the AGM, I will not even talk about board meeting. 2 marks question. Correct and the point. General meeting. So if it's a 2 mark question, what I will write? As per section 118, the minutes of general meeting will be signed by chairman. If chairman is not able to sign, any other person authorized by chairman will sign. In the above case, Venkat, director, is not able to sign. Hence, any other person authorized by the board on behalf of Venkat should sign. Full stop. That's it. This easily you will write. ஒரே பேரால முடிச்சிடணும். ஒரே பேரால provision, analysis, conclusion. As crisp as possible. Idhe 4 marks na you know. This you are expert. How to write lengthy also. Provision, analysis, conclusion in detail. Okay, are you following guys? 3 marks na you will again shorten it little bit. Depends on the marks you have to change. Same question I can ask for any number of marks. You got it now. In this question we learnt for 2 marks. 4 is anyway there here. 4 now look at this. They are giving some more detailed points. Every company shall prepare and keep minutes in the AGM, including minutes of requisitionist, minutes of creditor meeting, all of that. Then they are saying within 30 days minutes shall be kept, should be signed within 30 days. Then again they are saying 118, each page of the minutes shall be signed on last page. In case of general meeting, chairman of the same meeting. In death now, in case of board meeting, a person authorized by the board. Therefore here they are saying. So little more detailed explanation about minutes concept. Are you understanding guys? Okay. But actually இதெல்லாம் signed on the last page லாம் எழுத வேணாம். ஏதாவது கேட்டிருக்கானோ? Examine the manner in which minutes of the above meetings are signed to be signed. Okay. So since it's 4 mark and how to sign it, they are asking other points also. Signed on every page, in the last page, all of that. Clear guys? Of course you have to read these answers at least once guys. Question 8, yes.
Bazaar Limited called its AGM in order to lay down the financial statement for shareholders' approval. Due to want to quorum, the meeting was cancelled. The directors did not file the annual returns with the registrar. The directors were of the idea that the time for filing of returns within 60 days from the date of AGM would not apply, as AGM was cancelled as the company contravened the provisions of Companies Act 2013. If the companies has contravened the provisions of the Act, how will it be penalized?
Okay. Here let me discuss 2 sections, 137 and 92. 137 is filing of financial statements within 30 days from AGM. 137 ல அவன் என்ன சொல்றான், if the company is not able to hold AGM, still you have to file within 30 days. But 92 talks about annual return. In 92 annual return, we don't have a provision like that, where if AGM is not held, you still have to file within 60 days. All need to say is within 60 days of AGM we have to file it. So what is the conclusion over here? Look at this. Now look at this. Every company shall file within 60 days from date on which AGM is held, or if no AGM is held, from the last day on which AGM should have been held. So if you remember 137, this you are very clear. AGM vekanalo from the last day. From the end of financial statement, AGM should be held within. That means if my financial statement ends on 31st March, then AGM should be maximum within 30th September. If you don't keep AGM here, 92 is saying, okay, no problem, within the next 60 days of 30th September, you file the annual return. Sir, why sir? AGM vekkle sir. I didn't even adopt the FS. In annual return, you know the contents. Contents of annual return has nothing to do with FS. It has promoters details, all of that. So the provision says you have to file. Therefore, as per amendment, okay, penalty, remembering penalty is very, very difficult, guys. Very difficult. Exam la vandano, out of 100 marks or 4 to 5 marks, once in 4 to 5 attempts only it will come. Okay, remembering penalty is very difficult. Anyway, I would have given in our class what are the important penalty sections to remember, at least those you remember. If you remember, well and good, but it's very, very hard. Even All India rank 1 may not remember all the penalties. It's that hard. Is it worth the effort? Depends on the time that you have. Okay. So should have been held within 6 months from date of closing FS. Idea of directors that since AGM was cancelled, provision requiring to file 60 days is incorrect. Applying common sense, otherwise they will never file it. Therefore, penalty of section 92 will be applicable. Next, question number 9, let me read this. Shambhu Limited was incorporated on 1st April 2018. The company did not have much to report to its shareholders. So no general meeting of the company has been held till 30th April 2020. Now if a company is incorporated on 1st April 2018, the financial year will end on 31st March 2019. Upper first AGM should be held within 9 months from end of financial year. They give 9 months time, which is 31st December 2019. Now only I remember my company deadline is there in 1 week. First new company startup. இப்போதான் ஞாபகம் வந்துச்சு ஃபைல் பண்ணணும். ஆமாம், ஓகே. டுடே இஸ் அரௌண்ட் 20th December. ஃபைன், 10 daysக்குள்ளே ஃபைல் பண்ணிடணும். ஐ வில் டூ இட். தேங்க்யூ. ஒர்க் அவுட் பேசலாம், ஐ ரிமெம்பர்ட். Okay. So 31st December 2019 kulla they have to file. They have not filed, or they have not kept the AGM. Sorry, they have not kept the AGM till 30th April 2020. Have they delayed? Yes. Not keeping AGM. Penalty section 99, 100 munadi and 96 after that. So here if you see, come down, the first AGM should be held before 31st December 2019. Further, the registrar does not have the power to grant an extension of 3 months for first AGM. Normally, ROC will have power 6 months plus 3 months extension. But here already you have 9 months. Idhik mela what extension do you want? Are you getting it, guys? Okay. Next. Provision, look at this, very simple. According to 96, you should keep within 9 months. In this case, what is the financial year they have written? Therefore, they have to keep. ROC also cannot extend, therefore company has not followed. Simple, easy question. Came in RTP, MTP, that's it. Not yet in exam. Question number 10. Yes, Sanjeev.
P Limited had called its AGM on 30th August 2019. Mr. Pawan has filed a complaint against the company that he could attend the meeting as the company did not serve the notice to him for attending the AGM. The company in turn provided the proof that they had sent the notice by way of email to Mr. Pawan, inviting him to attend the AGM of the company. Mr. Pawan alleged to never received the email. In the light of the provisions of the Companies Act 2013, advise whether the company has erred in the serving the notice of AGM to Mr. Pawan.
Okay, simple question. If notice is not sent, meeting is not valid. If notice is not sent, meeting is not valid. But I can't be confident that once I send notice, if everybody got an enabdi theriyum, I can't go call everybody and check. So my work is to send it. What is my proof? As a shareholder, your email kuduthirpa when you became shareholder. I will send it. It will be there in my sent option. That's it. Beyond this, I can't do anything else. Beyond this, I can't do anything else because the other party received or not email. Now what I will do? So if the company has proof that they have sent, that is sufficient. Fault in Gmail, fault in postal department, you can't blame the company. Na send panla sir. Outbox le ukandirukku mail. Matikich outbox la. Then I am responsible. So if I'm okay, are you getting it, guys? Okay. So come down. If a member is entitled to receive notice, fails to provide or update relevant email, tappa kuduthirpan to the company or to depository, the company shall not be in default for not delivering notice via email. Hence the company has not erred, not made mistake in making thing. So the word erred should have been used in question. Whether the company has erred in serving notice. So company has not erred. Ama use panna word avanga against use pannuvaana. Example. Okay. That's it. Our provisions is just explaining section. Which one? 101. What are the key words in the answer in 101? So rule number you remember na, right? Otherwise fine. It can be sent through email as a text or an attachment to email. Okay. Next. Yeah, the email shall be addressed to the person entitled to receive email as per records. It's all general. Also, company shall provide advance opportunity of at least one opportunity to the member to register his email and change therein request there. Okay, general points to update fresh ID. In light of above provisions, company's obligation shall be satisfied when it transmits the email sent on the and company shall not be held for failure in transmission beyond its control. Okay, instead of post, this is online mode. MTP 21. Yes, quickly.
The Board of Directors of Swati Limited called an extraordinary general meeting upon the requisition of members. However, the meeting was adjourned on the ground that the quorum was not present at the meeting. Advised the company on the basis of the provisions of Companies Act 2013.
What question? Repeat. Same question came. What is the answer? Can they adjourn? No. EGM la quorum varlana I can't adjourn, but very important. Now, no, actually it's not the same question. Can meeting be adjourned, guys? I didn't follow carefully. You guys should tell me. EGM quorum is not present. Can meeting be adjourned? The answer yes or no depends on who called the meeting. Meeting will not be adjourned if the shareholders call for the meeting. Shareholders call panna meeting ke shareholder varlana meeting will not be adjourned. But here Board of Swati called in EGM upon requisition of members. However, the meeting was adjourned on the ground that there was no quorum. If Board of Directors called it, can meeting be adjourned? Yes. Now you tell me in this question who called? Board or shareholders? Who called? No, I'm asking you who called? No. Requisition of members. So members only. I'm just trying to confuse you. Okay. Members only called. So see, the process is shareholders will ask Board of Directors. Board of Directors will conduct the EGM. Second case is Board of Directors will call the EGM by themselves. So when they call by themselves, can you adjourn? Yes. When it comes through shareholders, can you adjourn? No. That is the same answer. Hence, meeting stands cancelled and stand taken by board to adjourn is not proper. Board is not adjourning. Okay. Next, question 12. I'll quickly read this small question. State with reason whether the following statement is correct or incorrect. An AGM can be held on a national holiday. Answer is no. What are national holidays in India? What are the dates? From Jan Linsang, Jan 26, August 15, October 2. I'm sure all of you remember this. These days, it is full national holiday. Everybody better stay home. Movies varum, pudu padam varum, padam paranga, enjoy pannanga. No AGM. Only one thing is, so far exam vehicle I say Diwali tukitam. Christmas next day CA final results this time. Pongal from no Pongal for all Jam Atom students. No Pongal itself. September na Ganesh Chaturthi will mostly come around that time. Gone. So the results will come around Diwali. Only these 3 days ICA has still not touched. Okay, fine. Can you keep on national holiday? No. Can you keep on Sunday? Yes. Sunday தான் வருவாங்க எல்லாருமே. Sunday தான் மேரேஜ் வைப்பாங்க. Okay. A company should file its annual return within 6 months from closing of financial year? Answer is no. Should file under within 60 days from end of AGM section 92. Are you following, guys? Foreign company will come. Foreign company only, it will come like this. Fine. Next. So 60 days from date on which AGM is held. What you will write in provision where no AGM is held, then within 60 days from the date on which AGM should have been held, together with a statement for not holding the AGM. These are points that people miss. You will end up writing that it should be filed within 60 days from AGM. If AGM is not held within 60 days from the date on which AGM should have been held, these are points which will carry that extra half mark. Yes sir, 5 out of 5 varla. Okay. Next. Question number 13. Yes.
Best Limited has decided to conduct its AGM on 28th September 2021. They have sent the notice on the meetings on 9th September 2021, for which they have taken consent from 90% of the members entitled to vote read. Comment on the validity of the notice of the AGM as per provisions of the Companies Act 2013.
Yeah. Sanjeev, padikumbodhu question over na you can leave off. Comment. Okay. Slowly you can develop that. No problem. Okay. Now here the testing section 101, 21 days notice. 21 days are 21 clear days are. 21 clear days. So from 9th September 28th September, exclude pannitingana, exclude both these days. In middle I should have 21 days. How to compute this quickly? 28 minus 9 ninga first pananga. How much you are getting? 28 minus 9, 19. Patla. You need at least 21. I'm just doing a rough calculation. I'm doing a rough calculation. The shortcut is 28 minus 19, 9 plus 1. Okay. Okay, leave the shortcut, guys. 19 days. That means it's definitely not there. If there is a shorter notice, up to 14 days, or any shorter notice is possible, if members of how much? 95% of members give consent. Okay. Section 101, if you see notice la, it says less than 21 days if 95% of members agree in writing or electronic mode. Here how many agreed? 90%. Therefore 21 clear days are needed, at least 21 clear days. If it is less than 21 clear days, how much should give consent? 95% should give consent. In the given case it was given less than. So look at this, first 3 points are provision. Next time analyzing and saying in the given case it's given less than 21. Also consent for calling was a shorter notice was given only by 90%, that is less than 95. Clear analyze pandram. 95 venu kuduthathu 90, so it's less than 95. Hence meeting cannot be said to be validly called. Can you see, guys, how we have broken down the answer? Provision, analysis, conclusion. I don't have to write idan sir provision, idan sir analysis, idan sir conclusion. Elavati eludinga 30 questions into 3 times, 90 times you will write a provision, provision, provision. The way you have to write, examiner itself will know, okay, he is starting with provision, he is going to analysis, he is going to conclusion. Now eludunu avashyam illa. I keep telling provision, analysis, conclusion is the flow. Nee heading elda vena, nee heading eldamne communicate pannu, appadhaan pa eldirka. When they read, they should understand. Are you following, guys? Okay, nothing wrong if you write, just that time. Provision, analysis, conclusion, 3 words into 30 questions. That means 90 words you have to write. How long this will take? At least for 5 minutes aguma idukku overall full exam, or 4 minutes or 3 minutes adla or question mudikalama. If you want you can write, I'm not saying don't write, but it's just only an option. Next, question 14. Yes.
Kavita Limited scheduled its AGM to be held on 11th March 2020 at 11 am. The company has 900 members. On 11th March 2020, the following persons were present at 11:30 am. P1, P2 and P3 shareholders, P4 representing ABC Limited, P5 representing DEF Limited, P6 and P7 as proxies of the shareholders. Examine whether the quorum was present in the meeting. What will be your answer if P4 representing ABC Limited reached in the meeting after 11:30 am?
Perfect. Quorum should be present within the first 30 minutes. Can meeting start at 11 am? Yes, it can start. So quorum should come before 11:30. 11:30 kulla inga 4 பேர் வந்துட்டாங்க. I have to count for quorum. Now company is private limited or public limited? Question la கொடுக்க மாட்டாங்க. Kavita Limited. Kavita private ன்னு இல்ல. So it is Kavita Limited. Limited now it becomes public. Company has 900 members. Go to our slab. 103 up to 1000 5 members இருந்தா போதும். 1000 to 5000 15 members, more than 5000 30. Remember, you have to remember here company has how many members, therefore how many members are needed in quorum? 5 are needed, so I have to count if they have 5. P1 2 3 3 shareholders. P4 representing ABC, upon a representative of company, will I count? Yes. P5 representing DEF, will I count? Yes. Representatives of corporation, section 112 113 we will consider. Proxies, no. So company has totally how many people? 5. So correctly they have 5. Quorum is valid. Whether quorum was present? Yes. In my second case question ketale, mostly it should be other answer. Mostly. Okay. What will be your answer if P4 reads the meeting after 11:30? Then in the first 30 minutes you have only 4 people. Correct? Because P4 is not there, I can't count him. So you have only 4 out of 5. Meeting will be cancelled and adjourned for want of quorum. Adjourned to what day? Next week? No. Decided by the board. If board is not deciding, next week, same date, same place, same time. Are you following, guys? Okay. Hope all of you are understanding. Next, the same question not only will be given. If essential part, if he reaches after 11:30, the meeting would be adjourned as provided above. Look at this. The wordings also. See, not presented by this or as decided by board of directors. Okay. So it's just given in simple answer. The actual provision says board will decide. Board decide pallana next week, same date, same time. That's why they just wrote both the points over here. Fine. Question number 15.
Examine the first AGM of the company shall be held within a period of 6 months from the date of closing of the first financial year.
Stop. It will be held within. First AGM will be held within 9 months from end of. You can keep in 6 months, but the law says first AGM ku 9 months. Second.
The registrar may, for any special reason, extend the time within which the first AGM shall be held.
Answer. Can he extend for first AGM, guys? No. ROC can extend by 3 months only for subsequent AGM. For first AGM he cannot extend because already 9 months is there. Man already discussed pantom oru question la. Same thing we would have seen if I go to section 96. Okay, look at this. ROC 3 months extension not allowed for first AGM. Gen Z notes covers all the points, guys. I won't say 100%, but all the core provisions. Quick revision. Okay. Next, same thing. Look. These are all 2 mark question. Correct? 2 4 marks irukum. Or 3 marks 1.5 1.5. Look how they wrote. இது ஒரே paragraphல எழுதிரலாம், but they also wrote again short. According to provision 96, for any special reason the ROC can extend the time for which AGM other than the first AGM can be exceeded, not exceeding 3 months. Registrar cannot extend for the first AGM. Given statement is incorrect. Give the provision, tell statement is not correct. Okay. Next.
Amar, a director of Google Electronics Limited, gave in writing to the company that the notice for any general meetings and the board of directors meetings to be sent to him only by the registered post at his residential address at Kanpur, for which he deposited sufficient money. The company sent notice to him by ordinary mail under certificate of posting. Amar did not receive the notice and could not attend the meeting and contended that the notice was improper. Decide as per the provisions of the Companies Act whether the contention of Amar is valid. Will the answer be the same if Amar remains in USA for 1 month, during which the notice of the meeting was served and the meeting was held?
Perfect. Beautiful question. You can mark it as a good question because it's combination of section 101 notice along with section 21 serving of 20. Correct? It should be 20. Yeah, section 20 serving of documents. What section 20 in incorporation chapter says? A notice will be sent to the member by the company in any mode, email, post, courier. But if a member asks for a specific mode, I have to send only in that specific mode. Inga member clear anna kuduthirukkan, it should be sent to him only by registered post at his residential address at Kanpur. Adukku thaviyana kaasu money he deposited. But still, company did not follow the instructions under section 20 and notice is sent to him in ordinary mail. He did not receive the notice. Has company followed instructions? No. Therefore, the notice, is it valid, guys? Contention of Amar is valid? Yes, because the notice is not valid. the meeting itself is not valid because notice is not sent in the way it is supposed to be sent. 101 read along with 20. That will be the answer. Look at this section. 20 says you will send in speed post, registered post, all of it. Provided a member may request for delivery through a particular mode, then company will do it in that. But you have to give the fees. Look at this. Fees should be given. If a member wants notice to be served to him only by registered post at his residential address for which he has deposited money, the notice may be served accordingly. Otherwise, service will not be deemed to have been effected. Here, contention of Amar is tenable. Reason for this notice was not properly served. Second case, Amar on the US போயிட்டான். US trip. That time notice came to his house. He never saw it. Now whose fault? Amar's fault. Therefore, second case, in the given circumstance, company is bound to serve valid notice to notice registered post, not outside India. I think question we have understood differently. Let me reread the question. Will your answer be the same if Amar remains in USA for 1 month during which the notice of meeting was served and the meeting was held? My understanding of question is, if the notice is sent to his address in Kanpur in the mode of registered post, the notice is valid. Just because he is in USA, I can't send to USA. அவன் கேட்கவே இல்லையே. I can send to USA if he is asking for USA and giving money. அவன் எங்கே கேட்டிருக்கான்? கான்பூர். ஸோ அந்த கன்க்ளூஷன் என்ன கொடுத்துருக்காங்கன்னா, in the given circumstance, company is bound to serve a valid notice to Amar by registered post at Kanpur. நீ கான்பூருக்கு தான் அனுப்பணும். Because he asked for Kanpur and not outside India. But if Amar is asking for US and he is paying the money, then it's valid. Yes. If Amar is asking for USA, then it is very much. அது company ஒத்துக்கிட்டாங்கன்னா very much valid. Are you following, guys? Got clarity now? Yes. Question number 17. Very simple. Let me quickly read this. Company engaged in manufacturing. This Kurk Limited. Private or public? Public. Manufacturing paper. Company is approached to examine the following provisions. Quorum. If company has 800 members, what is the quorum? Range test பண்றான் 5. Quorum. If company has 6,500 members, more than 5,000, how much? 30. Quorum. If company has 5,500 members, the articles has prescribed 50. Then quorum is 50. It is act or articles, whichever is higher. Act is saying 5,500 இருந்தா 30 போதும். பட் நானே சொல்றேன் ஆர்டிகல்ஸ்ல 50 தான் வேணும்னு சொல்லி. எந்த கம்பெனியும் பண்ண மாட்டாங்க. மெம்பர்ஸ் வரலன்னா என்ன பண்றது? So we will keep it at 30 itself. But if article says 50, you will go with 50. Are you following, guys? Very simple question. These kind of questions are very jackpot for you if it comes in exam. ஆனால் அந்த லிமிட் ஞாபகம் வச்சுக்கணும். லிமிட் ஞாபகம்னா ஆர் தான் கொடுத்துருக்கா. அப்புறம் you will go for R. Samayak is engaged in business of manufacturing paper. மறுபடியும் kindly explain. ஐயோ அதே what is this? ஆரும் அதான் ரிலேட்டட் டு கோரம் கேட்டிருக்கான். ஸோ கோரம் படிக்காத ஆள்னா இந்த கொஸ்டின் எக்ஸாம் இருந்தால் காலி. ஆர் ஷுட் யூஸ்வலி பி சம் அதர் கான்செப்ட். அதே சாப்டரில் வேறு கேட்டிருக்கலாம். ஓகே, பட் தேங்க்ஃபுல்லி இட் கேம் இன் MTP only, so it's fine. Okay, that's it. The same limits will be there, guys. First 5, 30. Quorum shall be 30 members personally present. However, if articles is saying 50 now, you will go with 50. Are you following, guys? So look how they explained. First they wrote provision and then they are again rewriting the same 3 points giving the answer. So first provision எழுதுங்க, then compare that with the question and write the analysis. இதே same question comes for 2 marks. Merge both. ஒரே லைன்ல provision, continue the analysis. Next, question number 18, examiner's favorite question. A question like this we have already seen question. Who is attending meeting? Count பண்ணுங்கன்னு சொல்லி. So quickly read the question.
The AOI of ABC Limited require personal presence of 7 members to constitute quorum of general meeting. The company has 870 members on the date of meeting. The following persons were present in the EGM to consider the appointment of managing director. A. The representative of Governor of Karnataka. B and C shareholder of preference shares. D. Representing Green Limited and Blue Limited. E, F, G and H proxies of shareholder. Can it be said the quorum was present in the meeting?
Simple. A representative will I count? Yes. B and C. Preference shares? No. Logic is who can vote only I will count. I will count preference shares in a meeting where preference shares are eligible to vote. Then I will take them. Okay. D representing Green and Blue Limited. Representative I will count him as. Count him 2 times. E, F, G, H proxy. Answer is no. So மொத்தமாக பார்த்தீங்கன்னா 1 yes plus 2 yes. It is 3. This company quorum சொல்லுது. You should have how many members? 7 members. You have only 3. என்ன பண்றது? Meeting is not valid. Usually in practical scenario what will happen? கம்பெனியே ஒரு ஆளுங்க வச்சுப்பாங்க. கோரம் கூட 30 மெம்பர்ஸ்னால் ரெடியாக வச்சுருப்பாங்க. கம்பெனி செக்ரட்டரி they will keep some people ready. நீங்கள் டெஃபினட்டாக வரணும்னு சொல்லி. Then they will all come and sit off before 9:30. ஃபோட்டோ எடுத்துருவோம். ஃபோட்டோ தான் ப்ரூஃப் ஃபார் ROC ஒர்க் டன். சம் மூவிஸ்னால ஃபஸ்ட் டே ஓடாது. அப்போ ப்ரொடியூசரே அவங்க ஃபேமிலி கூட போயிடுவாங்க. கரெக்டாக ஆல் ஆஃப் யூ கம் ஃபஸ்ட் டே. ஒன் ஆஃப் மை ஃப்ரெண்ட்ஸ் மூவி ரீசென்ட்லி இட் ரிலீஸ்ட் இன் பெங்களூர். ஓகே, மை ஃப்ரெண்ட் வாஸ் அசிஸ்டன்ட் டைரக்டர் ஆஃப் திஸ் மூவி. கடைசி உலக போர்னு ஒரு படம் வந்தது, ஹிப்ஹாப் தமிழா. ஐ வாஸ் இன் பெங்களூர் தட் டே. சரி, ஐ வாண்ட் டு சப்போர்ட் ஹிம். ஃபஸ்ட் டே படம் போகணும்னு சொல்லி பெங்களூரில் ஐ வென்ட் டு தியேட்டர். ஃபஸ்ட் டே ஈவினிங் 6:30 PM. புக் பண்ண போனால் தியேட்டர் காலியாக இருக்குது. ஃபஸ்ட் டே நோபடி புக்டு. Then I told him, okay, I will at least book. 2 of us were there, me and my wife, we both will go watch the movie. இல்லை minimum 10 people book பண்ணதான் we will run the show. Then I told, okay, பரவாயில்ல, நானே 10 book பண்ணுறேன். 10 into 300 நான் கொடுக்குறேன், பரவாயில்ல, ஃப்ரெண்டு படம் we will contribute. 10 into whatever, it came to around some 3,500. I will pay, நாங்கள் போய் பார்க்குறோன்னு சொன்னோம். அவன் பண்ணுறதுக்குள்ளே ஷோ கேன்சல் பண்ணிட்டாங்க in the PVR system, so it went off. Like this, some movies will happen where the producer team itself will come and sit fully for first day. அந்த மாதிரி இன் ஏஜிஎம் எதுக்கு சரி சொல்கிறேன்னா, இன் ரியாலிட்டி இன் ஏஜிஎம் அவங்களே ஒரு டீம் வச்சுருப்பாங்க, எல்லோரும் போய் உட்காந்துருவாங்க. ஸோ தட் ஏஜிஎம் கோரம்னால அர்ஜன் ஆகக்கூடாது. ஓகே, எங்க ஓகே, தேங்க்ஸ் ஃபார் பிரிங்கிங் திஸ் அப். Quorum is needed for general meetings, whether it is AGM or EGM. Any meeting we need, any general meeting of shareholders, we need quorum. Thanks for bringing it up, Harish. So for AGM and EGM, we need quorum. Correct? Otherwise, previously we saw for EGM it's adjourned. அங்கே எப்படி அர்ஜென்ட் ஆகும் quorum இல்லைனா? Quorum is needed for both. Okay. Next. So look at this. This much detailed and all you don't have. இது ஃபுல்லாக எழுதினாலே 4 பேஜ் போகும் உங்களுக்கு. Okay, he has given the full provision. You will write CRISPA, who all I will count for quorum, and then connect that provision in analysis. Okay, question number 19. Yes, Sanjeev.
Happy Limited received a proxy form 54 hours before the time fixed for the start of the meeting. The company refused to accept the proxy form on the ground that AOA of the company provided that the proxy form must be filed 60 hours before the start of the meeting. Defined proxy decided under the provisions of the Companies Act. Whether the proxy holder can compel the company to admit the proxy in this case?
Okay, excellent question. If you go to our Gen Z notes for section 105, we would have discussed in class, can you change the hours of proxy? If AGM is here, we would have discussed proxy form should come at least 72 hours before. And beautifully in the class we would have discussed, can you reduce the time from 72 to 60? Answer is no. Answer is yes. Can you reduce? Yes. Can you increase the time from 72 to, let's say, 80 hours? Answer is no. That means you can reduce the time. What is the logic, sir? If AGM is on 10 AM on, let's say, 13th of October, example, then 72 hours will become 10 AM on 10th October. If you reduce the time from 72, let's say I make it 70, then the time will become 12 noon on 10th October. Now I'm asking you, look at this. When I make 72 hours of as 70, I'm repeating concept for workout batch students. If I make 72 hours request for inspection, is request for inspection then or appointing proxy? No, this question is what? Appointing proxy form. Okay, understood. So here, okay, first let me finish off this. A 10 AM deadline is becoming 12 noon deadline, na, it's good for you. So 72 kammi aichna, it's good for you. Same way follow, guys. Okay. Now same way, here they are discussing about appointing proxy, which is 48 hours before. Can you increase the 48 hours? No. Can you decrease it? Yes. Same logic. If you decrease the 48 hours, you get more time. If 48 hours becomes 24 hours, 2 days munadi irukra deadline is becoming 1 day before. That means 48 hours can be reduced, it cannot be increased. Come to this question, you will mark it as important. Limited received a proxy 54 hours before the fixed time. You should receive how many hours before? 48 hours முன்னாடி வந்தா போதும். He gave how many hours before? 54 hours. That means it's fine. Correct? But the articles are saying you should file it 60 hours before start of the meeting. In Gen Z notes what we said, can you increase the time from 48 to 60? Answer is no. You can't increase the time. Why you can't increase? If you're increasing the time, I am reducing the time for shareholder. Shareholder time கம்மியாகும். Sir புரியல sir. How? 48 hours before 10 am now, it will be 10 am on 11th October. If 13th October is my AGM, this will be on 11th October. If 48 becomes 50 for example, then the time becomes 8 am. Will you accept if I change the deadline from 10 am on 11th October to 8 am on 11th October? No. So you can't increase the time. Therefore, company by keeping 60 hours is against the Companies Act. They can only reduce. I'm sure in class we would have spent so much time for all of this. Can you increase or decrease? But I'm repeating this logic because students get confused here. Are 4 of you understanding here? Sure. Okay. So here, a member, look at this. A company entitled, okay. Which question is this? 19. Okay. Proxy should be received 48 hours before the meeting. It will be valid if the articles provide for a before the meeting. Yeah, okay, Act provides. In the given case, company received it 54 hours before the time. Happy Limited refused to accept on the grounds that articles provided for 60 hours. In the line, a proxy received 48 hours before the meeting will be valid if the articles provide for a... Okay, I'm just 1 second. That they're trying to say basically shareholder is correct, because if you get 48 hours before, na, it is enough. He gave it 54 hours before. Therefore, yes, it is valid. What they are saying, proxy holder can compel the company to admit the proxy. 60 hours is not correct. Happy Limited refused because it's 60 hours. Where he is given 60 hours is not correct. That also we have to write. You have to write 60 hours is not correct. Are you understanding, guys? Okay. I will again repeat, guys, because it's an important question. Mark it as important. And unme purla sir, I want to mug up. Very simple. Mug up these things. Logic. I told now, logic is 48 hours increase panlama. Can I make it 60 hours? Answer is no. 48 kami panlama. Yes. In this question, company made 48 to 60. Not allowed. And the shareholder gave it 54 hours before itself. That means he gave it well before in advance. At least 48 hours munadi kodukano. He gave it 54 hours before. Are you getting it, guys? Therefore, it is valid. Very, very important question. Logic, I don't have time to explain the whole thing, but I hope you're getting the clarity. Yes. Yes, Act overrides MOA and AOA. So, very, very good. You can actually write a beautiful point here. Section 6, Act overrides MOA and AOA. Here, AOA is saying 60 hours. Act is saying 48. You can do anything in the MOA and AOA which is not against the Act. Beneficial to Act panikalam. Are you following, guys? This point exam clear irukadu. But if you write this, it will impress the examiner. Okay, fine. Question number 20. Have you all genuinely understood this question? I just feel I went little fast, but are you understanding? Sure. Okay. Question 20.
With a view to transact some urgent business, Ratna, Rimpi and Ratnesh, the 3 directors of S Construction Limited, are desirous of calling a general meeting of shareholders by giving shorter notice than 21 days clear notice. The 4th director, Nilesh, of the opinion that such action will attract penalty provisions since there is contravention. The paid up share capital of the company is 30 crores divided into 3 crores shares of 10 each. Keeping the view applicable, explain as per provision of Company Act 2013.
Answer. What is it, guys? Can I give a shorter notice? Yes. You need consent of 95% of members in writing or e-mode. Here, what is the shares? 30 crores. So, what is 95% of that? 95% of 30 will be 20.5. Without calci also we can do. With calci also you can do. 28.5. So the answer also will say not less than 95% should agree. Therefore in this question have they obtained consent? Idha kuduthirukano? How much consent they have obtained? Nothing is given. So you just have to give an open-ended answer that if a meeting is called after obtaining consent of members holding 95%, then the meeting is valid. Why have they not given the computation? They can compute that also actually. Because they have given 30 crores. So they have given question like 30 crores share capital. So what is 95% of that? 28.5 crores. Consent of members holding 95% of paid up share capital. What is paid up share capital in the question? 30 crores divided into 3 crore shares of 10 each. So 28.5 crores should give consent. They have not given in the answer. Please write that also. Next question 21. Yes, fast.
Mr. Chris, a shareholder of ABC Limited, has made a request to the company for providing a copy of minutes of books of general meeting. His name is already entered in the register of members of the company. Whether Mr. Chris is entitled to receive a copy of minutes book?
Chris is a shareholder made request to company for providing copy of minutes. His name is already there in register of members. Can he get copy? Yes. They're discussing section 119. What is 119 saying? Where is that? Yeah, 119 inspection of minutes. Idan summary. Who can inspect? Only members. Any business hours? 2 hours. Inspection is free. If you want copy, ask in 7 days. You will get the copy once you ask. Copies you want hard copy, maximum 10 rupees per page. Then 120 says documents can be in soft copy. Therefore soft copy should be given free. But you can get soft copy only for last 3 financial years. If company defaults, penalty, tribunal can order company to pay. Can you inspect for board meeting? No. Ida 119 crisp. That's it. We have this in our Gen Z notes. So over here, can he get the request, guys? Yes, he can get the copy of the minutes book. Since they have not given hard copy or soft copy, we will take any assumption here. In the given case, member show entitled to get the copy of the minutes of general meeting. That's why they are given here both. 7 working days. Can you see? He has to get within 7 days on behalf of the company on payment of such sum as may be prescribed. What is the sum? 10 rupees. It's the maximum. Company can keep less. Soft copy not free. Not also I can add because question is not very clear. Next question 22.
G Limited, a listed public company, conducted its AGM on 31st August 2022. However, 10 days have been passed since 31st August 2022, but it has still not filed a report on AGM. The accountant of the company has approached you to advise them whether G Limited is requested to file report on AGM.
Section 121 talks about report on AGM. We would have seen this also in class. Listed company should file within 30 days report of AGM in MGT 15 to ROC. It will contain details of notice, quorum, resolution, adjournment if any. So here we have to file within 30 days. How many days over? 10 days na aichu. Wait panna. Have some patience. They still have time. Therefore you have to file within 30 days of 31st August. So there is still time. That's it. Are you following, guys? Basically the testing section 121 not in exam. Only MTP and RTP. This section is yet to be tested in the main exam. Even once it has never come. Next 23.
In a general meeting of Alpha Limited, the chairman directed to exclude certain matters detrimental to the interest of the company from the minutes. Mukesh, a shareholder, contended that minutes of the meeting must contain fair and correct summary of the proceedings thread. Decide whether the contention of the Mukesh is maintainable under the provisions of Companies Act 2013.
Simple. Let's say in meeting, one shareholder came. He took the egg and threw on the chairman. Or Sunday each. Some fight happened. Then some shareholder took the mic. Asking someone titran chairman. Then they sent him out. Now, company secretary, minutes I should write down everything. Will I keep all of this? Section 118 it says, only those things which are fair will be kept. Fair and important key things. 118 says, any defamatory or irrelevant or immaterial or detrimental to interest of the company, we will not keep it in the minutes book. Getting the logic of why all these things. What happened only I will keep material things. Okay. So the chairman only has the final authority. The chairman feels to exclude a few matters detrimental to the interest of the company from the minutes. Yes sir, provision அப்படி இருக்கு. Negativity life ல remove பண்ணுங்கன்னு சொல்றோம். Minutes section லயும். anything that happens negative, minutes lu vekkada, forget about it. This act was drafted when before, that time there was no digital evidence. So if something happened in 1995 meeting, minutes la if I record it, something negative happened, minutes will be preserved permanently. Apona you are preserving negative thoughts permanently. எல்லா வருஷமும் ஷாரோட பார்த்து டென்ஷன் ஆகும், அது எழுதவே நினச்சிக்கோங்க, மறந்துடுவீங்க. That means if you have any negative things in your phone, some chat, some photos you don't want, delete it so that you will forget it completely. Otherwise Google will keep giving you those memories, guys. Very difficult to handle it. Okay, so here they are saying next, shareholder is not valid, chairman has absolute discretion for inclusion or exclusion. How are we learning life lessons, guys? Companies act or psychology no? So we will keep doing more like this. நீங்களும் படிக்கும்போது if you are able to connect any actual psychology, sir இது கனெக்ட் பண்ணலாம் சார் அங்க, you let me know. அடுத்த batchல I will share that. Okay, with credits. 24.
Primal Limited is a company incorporated in India. It owns two subsidiaries, Privy Limited, in which it holds 75% of shares, and Malvi Limited, a wholly owned subsidiary. Both the subsidiary companies are incorporated outside India. The board of directors of Primal Limited intends to call an AGM of Primal Limited to urgent basis. Advice: EGM is held in India. EGM can be held in Netherlands.
Now, this also is important question. I think a very similar question came in one of the recent exams also. I think in September exam, yeah, September 24 la this question came. Why it's not here? This is prepared little after that, or I'm not sure when, but I remember seeing this question, September 24. Primal is a company incorporated in India, so I'm writing Primal. Okay, it has two subsidiary, Privy in which it holds 75% and Malvi in which it holds 100%. Both the subsidiaries are incorporated. Foreign company, they will not follow provisions of Indian Companies Act. Board of Directors decided to call an EGM of Primal on urgent basis. Advise the board. Primal is which company? Here. Oh, Primal is holding, correct? Huh? Primal is incorporated in India. Indian company, where I should keep India? It should be only in India. Yes, answer is no, but let me just check this answer once. The board of directors can keep in India. The board cannot call the EGM of Primal outside India as it's incorporated in India. Are you following? Yes, EGM should be in India. I think September 24 is a little variation of this. Adla vena kepana, not this question. Let me add the September 24 question here. This company, which is this, Privy. Can Privy be kept in India? It is a foreign subsidiary, correct? Two subsidiaries, both are incorporated outside India. So Privy is a foreign subsidiary. Where to keep their EGM? Are you following, guys? And Malvi is a foreign subsidiary. Where to keep this? 100% foreign subsidiary. What do you mean by 100% foreign? Wholly owned, 100% wholly owned. Can I keep this in India? இப்படி கேட்டான் in the September exam. They asked for Privy and Malvi. Answer: can I keep in India, guys? Both. See here, you can keep in India. This also you can keep in India. But can I keep in foreign country? Can I keep in foreign country? Here the provision, one rule says, if the company is a wholly owned subsidiary, you can keep in foreign country. That is one exception. Wholly owned subsidiary, foreign company, you can keep the AGM in that other country. EGM you can keep in the other country. That is one exception. Came in September 24. I think in our last question we will have that, because we have till September. When it comes, I will discuss with that September 24 question. Anyway, September 24 la vanda Jan 25 la chance is less. Yes, Harish, doubt. It is just one exception given. அவன் எதுக்கு அப்படி சொல்றானா, wholly owned I am the full control. So I will keep it in other country, because that is company operating there. It's அவங்க லாஜிக் என்ன சொல்றானா, let's say I am in Chennai. My wholly owned subsidiary is in Dubai. துபாயில் தான் கம்பெனி இன்கார்பரேட்டட். ஐ ஹாவ் த ஃபுல் கண்ட்ரோல். ஆப்ரேஷன்ஸ் நடக்கிறதே துபாயில் தான். எவ்ரிதிங் இஸ் ஹேப்பனிங் இன் துபாய். நான் இஜிஎம் மட்டும் இந்தியாவில் வச்சு என்ன யூஸ்? தே வில் ட்ராவல் அண்ட் கம் ஹியரா? டேரக்டர்ஸ் அங்கே தான் இருக்காங்க. ஐ ஹாவ் ஃபுல் கண்ட்ரோல். So law gave an exemption saying if your foreign company is 100% outside India, then you incorporated there, then you can keep the EGM in that country. If it holding company EGM கிடையாது. Holding company EGM will be in India only. The subsidiary company's EGM I'm talking about. Subsidiary which is in Dubai, I can keep it in Dubai if it is a 100% subsidiary because I have full control. Reason being why, I'll give logic. Okay, this came in exam, so I'm just giving logic. அவன் என்ன கேட்குறான்னா, let's call A, B, C மூணுமே companies. A is a company incorporated in India, B is a foreign company, C is a foreign company. In both are my subsidiaries. Here 75%, here I have 100%. Now A is in India, EGM can be only in India. These two companies also, they can keep the EGM in India. Now let's say B and C are companies in Dubai. Let's say they are in Dubai. Can I keep B company in Dubai EGM? Answer is no. Why? Because you are having only 75%. Remaining 25% is held by others. நீ துபாய் வச்சா அவன் எப்படி வருவான்? So you have to keep it only in India because holding is, it's happening in India. Okay, but this company C, which is 100% held by an Indian company, I can keep it even in Dubai because it's operating in Dubai. Of course, it's against the provisions of keeping EGM in India, but I am the shareholder. Now than 100%. Who's going to attend? I am only going to attend. Unanimous resolution pass panna, I can keep it in Dubai. Exemption given. Act should make it simplify. Operation is happening in Dubai only. Since it's happening in Dubai, now than 100%. Who's going to attend the EGM? Now so I can keep it. So wholly on subsidiary mattu answer is yes. Otherwise answer is no in foreign country. Good question. If A is having 100% shares in foreign company C, A oda shareholders will attend, A limited will attend. Owners and company are separate. Here it's owned by whom? A limited. So A limited will appoint a representative to attend the AGM, not the shareholders of AGM. A limited. Okay. Shareholders of A limited will get to see consolidation. That's it. Understood. September 24 it came. Those who wrote September 24 will know. I think end 50th question or something should be that. Next, question 25, quickly.
Mr. Pink held 100 partly paid up shares of Red Limited. The company asked him to pay the final call money on the shares. Due to some unavoidable circumstances, he was unable to pay the amount of call money to the company. At a general meeting of the shareholders, the chairman disallowed him to cast his vote on the ground that articles do not permit a shareholder to vote even if he does not pay the calls on the shares held by him. Mr. Pink contested that the decision of the chairman. Decide whether the contention of the Mr. Pink is valid.
Section 106 of Companies Act talks about who cannot vote. Only in two cases, if there is right of lien or there is calls in arrear, you cannot vote. Here, Mr. Pink, calls in arrear irka? Yes. Therefore, can he vote, guys? 106. He has not paid call money. He cannot vote. Simple answer. But adukku nee 106 படிச்சிருக்கணும். Are you following us? How we studied 106 who cannot vote. 107, 108, 109, 110 is types of voting. Are you following, guys? Do you remember section numbers? No, it's been some time. Able to recollect, guys? Okay. Fine. Next, Ridgwan Limited, a listed company, is in the business of garment manufacturing and has its registered office in N Tower Commercial Beta Complex, Rajasthan. The company has called its 6th AGM at 3 PM on 22nd August. Is it fine, guys? Yes. At Ansal Plaza, Bhiwadi. இதெல்லாம் கன்ஃபியூஸ் பண்ணி டிஸ்ட்ராக்ட் பண்ணுறதுக்கு ராஜஸ்தானில் அட்ரஸ்லாம் கொடுத்து. Some of the members of the company have opposed to calling of the meeting at Ansal Plaza. Company has approached you to help them out. Now, where is the company registered? Registered office is in பிவாடி ராஜஸ்தான். இவங்க எங்கே வச்சுருக்கான்? பிவாடி தான். பிவாடி தான் கனெக்ட் பண்ணுவாங்க, ஒரே சிட்டி. கரெக்டா? ஆர் யூ ஃபாலோயிங், கைஸ்? ஓகே. அதே ராஜஸ்தான் ஸ்டூடெண்ட்னா ஜாலி ஆடுவான், எங்கள் ஊர் தான் எக்ஸாமில் வந்துடுச்சுன்னு சொல்லி. ஓகே. எனி ஆஃப் ராஜஸ்தான் ஸ்டூடெண்ட்ஸ் வாட்சிங் மை கிளாஸ்னா மெசேஜ் மீ. ஐ வில் ஆல்சோ பி ஹாப்பி தட் கிளாஸ் ஹஸ் கான் டில் தர். ஓகே. நவ் பிவாடி சேம் சிட்டி. கேன் ஐ கீப் இட், கைஸ்? AGM should be kept at what place? If not, you have to keep in the same city. Is the same city, yeah? Yes. Where did we see this? In section 96. A registered office or same city, town or village. 96 na 9 am to 6 pm. Okay. So, Bhiwadi la vekkala answer. Hence, if consent is given in writing by electronic mode by all the members, oh, Jaipura. Second case na padikla. Can you keep it in Jaipur? So, can you keep it somewhere else, guys? Anywhere else in India, if there is a unanimous resolution. So, there is demonstration of how to not read the question. Second part full ah padikanu. Adnala da Sanjeev vechirukken padikradhukku. So, if can you keep in Jaipur, guys? Will your answer differ? Answer is yes. So, first case, in the first case, company is rightful in calling in Ansar Plaza. Okay. In second scenario, in case of unlisted company, AGM can be held at any place if consent is given by all members. Therefore, if consent is given by all members, you can keep in Jaipur. Bhiwadi pati pesave liye. You can keep in Ansal Plaza, but they should write the word no. Oh, here it is. In any other place within the same city, town or village. But you also have to write. I will not agree this answer here. Sometimes it happens like that. Enga Ansal Plaza. Ansal Plaza, Bhiwadi. So you have to establish that registered office is in Bhiwadi. Ansal Plaza is also in Bhiwadi. Bhiwadi, same city. So you can keep. Okay. That's miss pantanga answer la. Okay. Question 27. Yes.
Wills Private Limited convened its AGM with the intention of presenting the financial statement for approval by the shareholders. However, due to the absence required quorum, the meeting had to be cancelled. Subsequently, the company's directors forgot to submit the AGM to the ROC. The directors held that belief that a 60 days time frame for filing return from the AGM date would not apply. Since the AGM itself was cancelled, has the company violated the stipulation outlined in the Companies Act 2013? In the case, if the company has breached the provisions of the Act, what are the potential penalties it might face?
Same question, repeat. Company forgot to file unwritten to ROC within 60 days because AGM is not held due to want of quorum. We saw this question where AGM is not held, you have to file within 60 days. What? Annual return to ROC from the last day on which AGM should have been held. So private company la matter kadiyadu because 92 says every company shall file within 60 days, and if it's not within 60 days, they should file within 60 days from the date on which AGM should have been held, specifying the reason. What is the reason? Quorum is not there. Private company quorum rundal na. And the undu perum varala. Okay. Possible only in exam. So in the given state, Wills has contravened the provisions. Every officer has to pay because they have not filed within 60 days, the last date on which AGM should have been held. Are you following, guys? All of you understanding with me, guys? Clear? Okay. Now what we will do, recording students, we are just continuing question 28. I am just stopping the recording and again starting recording. You can see the next video. Hi guys, welcome back to part 2. We are just resuming after 5 minutes from the previous video itself. We are all here only. So again, Sanjeev, continue with question 28.
A general meeting was scheduled to be held on 15th April 2019 at 3 pm. As per the notice, the members who are unable to attend the meeting in a person can appoint a proxy, and the proxy forms duly filed should be sent to the company so as to reach at least 48 hours before the meeting. Mr. X, a member of the company, appoint Mr. Y as his proxy, and the proxy form dated 10/4/2019 was deposited by Mr. Y within the company as its registered office on 11/4/2019. Similarly, another member, Mr. W, also gives two separate proxies to two individuals named Mr. M and Mr. N. In this case of Mr. M, the proxy dated 12/4/2019 was deposited with the company on the same day, and the proxy form in favor of Mr. N was deposited on 14/4/2019. All the proxies with Y, M and N were present before the meeting. Explained as per the provisions of the Companies Act 2013, who would be the person allowed to represent as per the proxies for members X and W respectively.
Beautiful question, came in May 23 and quite a few MTP, RTP. In my question, if it comes in exam, first you will get fear. Ayo, so many dates are there. So first thing you have to do is create the timeline. That solves everything. What timeline, sir? AGM is there 15th April 2019. AGM is starting at 3 p.m. Can I start after lunch AGM? Yes, between 9 to 6, whenever you can start. Now, proxy form should be submitted 48 hours before. When does 48 hours before come? This is 15th now. 13th April 2019, 3 p.m. is my cutoff. In the 13th April 2019, 3 p.m. kulla proxy form should come. After this, if it comes, form is not valid unless company reduces the time. Okay, the company can reduce the time. We saw in the other question. Let's not confuse over here. Now, X is one member. Mr. X deposited a proxy for appointing Y, and his proxy form was dated 10th April, and it was deposited to the company and registered office on 11th April. Date of form is not relevant. When company is receiving, when you are depositing only is relevant. So they deposited on which day? 11th April. Is it before 13th April? Yes. Very much valid. First, so X work is over. X appointing Y as a proxy is a valid proxy. Next, some other member. Ivanuku X ku samandhame illa. Another member W also gives two proxies. Two people he is disturbing. Poi attend pannu meeting nu solli. Two individuals M and N. So W is sending M and N. And the proxy was submitted, deposited to the company. Okay, so N order proxy. M order proxy is deposited on 12th April itself. M came on 12th April, which is 12th April before the cutoff data. Yes. N order proxy form was deposited on 14th of April, which is after the cutoff. That means whose proxy is not valid? N order proxy is not valid. N cannot attend the meeting. All the proxies N excited were present before the meeting. Is Y valid? Yes. Y is valid before because it came on 11th of April. Is M valid? Yes, because it came on 12th of April. Is N valid? No, because it came on 14th of April. Are you following, guys? Can N at least eat lunch and go? No. AGM kulle vada maatanga avana. Appadi velli kalami poidum. Okay. According to provisions, this is the answer. Now, you are an expert in presentation. If a question like this, you can perfectly write the provision analysis conclusion. Idoda complicated question varadu for presentation purpose. How will I write this? First provision. Simple. A proxy form should be submitted 48 hours before the AGM. The same time can be reduced but cannot be increased. Any form received after this 48 hours within the time, proxy form is not valid. Next provision. If a member appoints two proxies, whoever is appointed later will be valid provided that later is within the cutoff time of 48 hours. I will stop. Then in the analysis, you have to establish these dates in pointers. Cutoff time is 13th April. Anything before 13th April is valid. Anything after 13th April 3 p.m. is not valid. Why 13th April? Because from AGM 15th April 2 days before. Then you will show again analysis. First, Y came on 11th April, which is before 13th April, therefore valid. M came on 12th April, which is before 13th April, therefore valid. N came on 14th April, which is after the cutoff time of 13th April 3 p.m., therefore not valid. That's it. Are you understanding, guys? That's how they also received in pointers. First is the provision, and then they are saying 48 hours you can reduce or not. Next, member have the right to revoke proxy if member attends by himself. Not relevant point here. When two proxies are given, which you will take, whichever is given later, the former one will be counted. Okay, if shareholder are lodged in a manner that one is lodged before and other after expiry, then former is taken. Okay, here, thus in case member X, no analysis, Y will be permitted to vote in his behalf because it's submitted within the permitted time. But what is the permitted time? You should write that also. You should give before 13th of April. They gave on 11th of April, so it is before 13th April. Very, very important. Okay. Next, however, in case of W, proxy M will be permitted to vote and N was deposited in less than 48 hours before meeting, or you can write N came after cutoff time. I prefer writing the dates before 13th, after, because it came before 13th, it's valid. Examiner will be more convinced. Are you following, guys? Time illa sir, write like this. Yes, super. Now Harish is asking, sir, my question, sir, n is not on 14th, n came on 13th at 1 p.m. it came, then is it valid? Yes, because it came before cutoff time. Now both proxies came, M and N both are before cutoff time. Whom I will take? Whosoever is the latest. The latest within cutoff time will revoke the previous ones. Are you getting it, guys? Next, question number 29. Let me read this quickly. Abhiyogi Limited, having 1,000 members with paid up share capital of 1 crore, decided to hold its AGM on 21st August and received a notice on 2nd July. Do we have enough time? Yes. Okay. It received a notice on 2nd July from its 60 members. Where a concept? Holding paid up share capital of 7 lakhs in aggregate for a resolution to be passed at AGM for appointing Vedya and Co. This is which concept? Section 111. Circulation of members resolution. What is circulation of members resolution? In section 111 we would have seen that, yeah, in 111, if AGM is there, you should provide members can circulate resolution to include any business in notice for AGM. It should come at least 6 weeks before. If you just want to give information, then it should come 2 weeks before. If you want to include something in the notice la onu pudusa na solradha add pannunga sir, it should come at least 6 weeks before. I just want to give information regarding something that is already going to happen, then 2 weeks before. Section 111. For that you should have how much of paid up share capital? 1/10 of paid up share capital. That concept only is being tested here. Now look at this. What is the share capital of company? 1 crore. Correct? 1 crore is the paid up share capital. In this, these people have how much? 7 lakhs. Is how much percentage you need? 10%. Do I have 10% here? No, you have only. So first of all, notice a not valid. Let me see, read the question. I'm not yet done. In aggregate for a resolution to be passed. Did it come on time, guys? We have to see. Now resolution is for appointing Vedya as auditor from this year. Apana auditor appointment, not 111. 115 special notice vandrum. Adhe concept na special notice says if you want to, retiring auditor shall not be reappointed or appointment of auditor other than retiring or provision change age, guys. I was thinking 111, but if it's for auditor, it's only special notice. In that case, how much voting power you should have? 1%. Here my friends have how much, guys? 7%. Valid. Okay. So don't arrive at conclusions without reading the full question. அதை demonstrate பண்றதுனா இப்படி பறிச்சேன். Okay. 7%. So you should send it 14 days before AGM or 3 months. In the gap it should come. 14 days before AGM or 3 months in this gap. Here it came within that gap. Here it actually came within that gap because 2nd July is well before the AGM. நீங்க கவுண்ட் பண்ணீங்கன்னா. Next, instead of existing auditor Chepal and Co, which was originally appointed for 5 years and completed 4 years, he has one more term, 1 more year. Before that I want to appoint somebody else. Such a notice for resolution was forthwith sent by company to Chepal and Co, which gave its representation in writing to the company along with a request for its notification to members of company, but it was received too late, 3 days before the meeting. Okay, this facts. Whether the said notice was given by adequate number of members? Answer is yes. You need 1%. Here we have 7%. Answer is yes. First case answer enga irukku. Thus it can be sent that notice made by adequate number of members within the prescribed time limit and within the prescribed percentage. Okay, not less than 1%. Here it is 7%, which is 1 crore having paid up share capital of 70 lakhs, which is within more than 1%. And next it should come within at least 14 days before AGM and 3 months before. In this question, when is the AGM? 21st August. 14 days before AGM, na somewhere around 7th August approximately. 3 months before, na it will be somewhere in July, June, May kitta vandrum approximate. When you got the notice? 2nd July. Appo in the time limit la definitely it's falling. rough computation. So the notice is again valid before, because it's received at least 14 days before and 3 months before. Are you following, guys? Beautiful question. Again, these kind of questions only if you're able to write, your presentation skills are actually tested. Sir, I want to practice presentation. This is the question to pick. Not dividend declared, not paid in 30 days. What is the penalty? Narla Elta, sir. Okay. Next, second case. Whether the company was bound to send its members such representation made by Chepal, and if it could not have been sent, then what is the responsibility of company? Section 115 also says this notice which is sent should be sent to everybody. Okay. But for that, you should circulate to all the, look at this, if this notice which came from members should be circulated to all the members 7 days before the AGM. If you are not able to circulate, not possible, publish in newspaper plus website. Okay. So what is the second question? Such notice for resolution was sent by company to Chepal, which gave its representation. Idu vera. Chepal gave representation with a request for its notification to the members, but it was too late. So what happens if you are not able to circulate? The company should allow Chepal to make a representation in the AGM itself before they pass the resolution. So case 2, what they are saying, accordingly, apart from giving the right to be heard orally to Chepal, to be read to the AGM, if so required, shall file representation with registrar respectively. So what is the main concept? The representation shall be read out at the meeting and the copy shall be filed with registrar. What is trying to say? Chepal kurta representation I am not able to circulate to other members. Now give him an opportunity to speak in the AGM. So if any notice of members is given, state the fact, send a copy of that to every other member. However, in the present case, receive the representation made by Chepal too late. It was not bound to send the notice to its members. Therefore, read in the meeting. Are you following, guys? Proper good question for presentation. Are you understanding? You will practice this. Okay. Question 30. Simple. Very small question. Let me read. A and B have joint demat account. I can guess where it's going. Joint account. Now who can vote? Let me not be proactive. The company's annual general meeting is held on 28th August. In such a case, who will cast the vote? Simple. If there are joint holders, who will cast? Whosoever name is present first in the register of members. Generally, sir, yaar name sir ruko. Both of us became joint shareholders. Instruction kudukla. Then we will add in alphabetical order. A and B. So here, in the order in which their names appear in the register, the joint holders have a right to instruct in the order in which their names. That's the order of seniority, not age. Whose name is first. Are you following, guys? Thus, in given case A or his wife B, whosoever name appears first in chronological order shall be entitled to vote. Next, question 31. Yes.
Prabhas Limited is a company having its shares listed on a recognized stock exchange. The company has 5,000 members. The AGM of a company has to be held on 7/9/2022. As per the provisions of the Companies Act 2013, advise the company to remote e-voting period time of losing to of remote e-voting.
Section 108 talks about remote e-voting. Quickly, guys. If AGM is there, voting should be open at least for 3 days in such a way, minimum 3 days, you should close at 5 p.m. previous day. So if meeting is held on 7th September, then at least on 6th September 2022 up to 5 p.m. Up to 5 p.m. it should be kept open. Where do we see this? In section 108 we would have discussed this. Voting should be closing at 5 p.m. on the previous day. Sir, there are so many time limits, sir. Voting should be there at least for 3 days. That's why we have in our mega timeline, all the timelines are there. 3 days. Look at this. From AGM, voting will be, where is it, guys? Remote e-voting. Section 108, minimum 3 days, 5 p.m. on the previous day. This, it has everything. This also is available for you guys. Okay. Next, 31 is done. That same thing, guys. 5 p.m. on previous day. It should be kept open for minimum. How many days, sir? 3 days. Question answer la 4/9. Yeah. So shall open on 4/9. 4, 5, 6 to 5 p.m. 3 days. Okay. Next, question 32. Quickly.
U Nidhi Limited was about to hold an AGM on 25th August 2022, for which the notice of AGM along with the relevant documents as prescribed was sent to all the members including the following. A members individually holding shares with face value of 800, which amount to 0.16% of total paid up share capital. Two members jointly holding shares with the face value of 1600, which amount to 0.32% of total paid up share capital. 42 members each holding individually shares with face value of 600, which amount to holding 0.12% of total paid up share capital each member. All the remaining members holding individually more than 1.2% of the total paid up share capital of the company. In the AGM held on 25th August 2022, the members were not provided with the facility to vote by electronic means. In the context of aforesaid case scenario, please answer whether U Nidhi Limited was required to send the notice of AGM along with relevant documents to all its members as aforesaid.
This question, if it comes Nidhi company provision தெரிஞ்சா full mark, தெரியலனா காலி, choiceல தான் skip பண்ணும். What is Nidhi company provisions? Since it's notice, we will go to section 101. Yeah, in section 101, where is this Nidhi company pointer? Where do we have this, guys? Okay, this is the 136. Okay, 136 they're discussing. That means our book also we will have in 136. 136 will come in. I'll just show you the provision because it is Nidhi company. Look at this. Okay, I would have given this in section 20. இங்க என்ன கொடுத்திருக்கேனா bookல for Nidhi company sending of notice to members, same exception as given in section 20 is applicable. So in our book, one place only I will give it, guys. So I will go to section 20. Also in the first page of the chapter I would have given Nidhi company engella sir exception irukku. In the first page of the book I would have given for Nidhi company, these are the only cases where what is there, guys? Exceptions. Sir, I want to study this quickly. So what you guys will do, instead of asking me sir all these materials, that's why I made one proper video for this. If you just go to YouTube and search for Nidhi company போட்டா வேற எதுவும் வராதுல, Nidhi company inter law. Okay, so I would have given one video for Nidhi company, வந்துச்சு பாடு, நல்லா skip பண்ணியாச்சு. So in this I would have discussed all the Nidhi company provisions summary. Just in 5 minutes, if you finish 7 minutes, everything will get over. Okay. In our book also we have that. We will go to section 20, serving of documents, which is, let's say, in page 45. Yeah, somewhere here. Here it is. In the question now I test பண்ணிருக்கான். Because it's a unique question, I'm taking time to show you guys. If you want those provisions also, you can revise watching that video. Okay. Exception to a Nidhi company, serve the documents only to members who are having. That means for Nidhi company, notice will be sent for AGM or FS in 136 will be sent to members only who have 1000 rupees in face value or more, or they should have 1% of total paid up share capital, whichever is less. For other shareholders of Nidhi company, document may be served by public notice in newspaper la போட்டா போதும், நீங்க வாங்கப்பா, உனக்கெல்லாம் வீட்டுக்குலாம் அனுப்ப முடியாது. So to send to your house you should have at least 1000 in face value or more than 1% of total paid up share capital, whichever is less. So I will come here. Here either you should have 1000 or 1% of paid up share capital. A member is having how much? 800. பத்தல 0.16 பத்தல. Will I send notice to him? No. Newspaper பார்த்து வாப்பா. Second, two members jointly holding shares of 1600 which amounted to 0.32. Now these two members jointly holding how much? Which is more than 1000. Therefore answer is yes. Next, third, 42 members each holding shares of 600. No, it should be 1000. Amounting to 0.12. Answer is no. All the remaining members individually having 1.2. Therefore answer is yes. So my answer is no yes, no yes. Let's check the answer. Ingappa answer poichu. Okay, ana 1.1600 and 1.2 answer is yes. அதான் both the yes they have summarized here. Are you following guys? So in the provision study matல நீங்க இத பார்க்கலனா gone. And has this come in the exam in the past? No. RTP May 23. That means the chance is pretty not very high, but Nidhi company கேக்கணும்னு முடிவெடுத்தனா they will ask this. Are you following? For 2025 exams, one of the exam Nidhi company definitely it will come because it has not come in the past 3 to 4 attempts. So Jan, May or September 2025 ஏதாவது ஒரு examல it will come. For that you have to watch the expected question அதுல இருக்கும். Okay. Now question 33 quickly.
Explain provisions of the Companies Act 2013 relating to quorum for general meeting of a public company having total 30 members, of which 2 members are body corporates and 1 member is the President of India. Whether the representatives appointed by the body corporate and President of India to participate in the general meeting shall be counted for quorum and such representatives cast vote at the general meeting.
Section 112 and section 113 கேக்குறான். Will I count them for quorum? Yes. Can they vote in general meeting? Yes. Out of 30 members, 2 members are body corporate and 1 member is President of India. Body corporate will come in section 113, President of India will come in section 112. The representatives they appoint will be treated as equal to the member for all powers. Okay. Simple questions, straightforward. Easy questions I will just quickly run through guys. 34 let me read. If member of listed company who has casted his vote through electronic voting, can he attend the AGM of company and change his vote subsequently? And can he appoint a proxy? Good question. They're asking if member of listed company who already voted in electronic mode, can he attend the AGM and change his vote subsequently? Act has not spoken about this. Common sense I will say no. You can only vote once. Online la vote pantana you can't come to AGM. You can come to AGM and attend, but you can't change the vote. And can he appoint a proxy? Yes. Electronic voting is different. In AGM we do different business. You can appoint a proxy. This is common sense. Okay. Now clearly states that members who have cast the vote by electronic vote may also attend the meeting but will not be entitled to cast the vote. Again, why we are doing electronic voting is to allow more people to vote. You can definitely attend the meeting but you can't change the vote. எதுக்கு sir logic? If I allow them to change, சில பேர் அப்படிதான் அதுக்கு தான் இருப்பாங்க. ஆன்லைனில் எஸ்ன்னு போடுவான், இங்கே வந்து நோன்னு சொல்லுவான், ட்ரபிள் பண்ணுவான், சிஎஸ்க்கு வேலை அதிகம் ஆகும். You are allowed to vote once. If you miss it online, you can vote over here. Instant case, member of listed company is already casted his vote, can attend but cannot change his vote, and is also not permitted to appoint proxy. Actually fair point. Why is proxy appointed? No, why is proxy appointed? To vote. You already voted. Why proxy? Are you getting the logic here? And can he appoint a proxy? First of all, if he is attending, you can't appoint proxy. நானே இருக்கும்போது proxy எதுக்கு? And second, proxy is coming to vote. Already voted online now. Why proxy? Are you getting it guys? Okay. Fine. This one is not there anywhere in the act guys. It's just common sense. We are answering. Like this, see, out of 50 past exam questions in 6 years, 1 or 2 questions will come like this. That's why we are doing workout. To protect ourselves from these kind of questions. 35. Let me read this quickly. Home Limited served a notice of AGM on its members. The notice stated the following resolutions will be considered at that AGM. Resolution to increase authorized share capital of company. Section 61. Read along with section 13. Alteration of MOA. So what resolution? Special resolution. We will also attach explanatory statement under section 1 or 2. All points will come. Appointment and fixation of the remuneration of Mr. Pratik as the auditor. Appointment and fixation of remuneration of Pratik as the auditor. This is what business? Ordinary business. Therefore, what resolution? Ordinary resolution. A shareholder complained that the amount of proposed increase in the remuneration was not specified in notice. Is the notice valid? No. We saw similar question. You are increasing authorized capital. Okay. Provisions na theriyama solta question full padikama. Valid? No. How much increase is not there? Appointing remuneration. எவ்வளோன்னு சொல்லுப்பா ஆடிட்டர் ரெம்யூனரேஷன். நீ பாட்டு இங்கே வந்தோடனே பிரதீக் தான் என் கசின், அவனுக்கு வந்து ஆடிட்டர் 5 கோடி, என் ஃப்ரெண்டு 5 கோடி, கசின்னா ஐ கான் கம், ரிலேட்டிவ்ல வந்துடும். இல்லை கசின் வராது. கசின் இஸ் நாட் தேர் இன் ரிலேட்டிவ் இன் 2 subsection 77. ஸோ கசின் ஐம் அப்பாயிண்டிங் 5 கோடி. நோ, send the amount. So section 102 says you have to give all key points. Therefore here not allowed. Any amount which is material should be there. Therefore it is not a valid notice. Similar to the previous question, marriage invite without the girl's name. Okay. Next 36. Yes.
PQ Limited is a public company having its registered office in Mumbai. It has 3,680 members. The company sent notice to all its members for its AGM to be held on 2nd September 2019 Monday at 11 a.m. as its registered office. On the day of meeting, there was only 12 members personally present up to 11:30 a.m. The chairman adjourned the meeting to the same day in next week the same time and place. On the day of adjourned meeting, only 10 members were personally present. The chairman initiated the meeting after 11:30 a.m. and passed the resolution after the discussion as per agenda of the meeting given in the notice. Comment whether the AGM conducted on after adjournment is valid or not as per the provisions of section 103 of the Companies Act 2013. Explain the relevant provision on this regard. What would be your answer in the above case if PQ Limited is a private company?
I am enjoying this chapter questions because so far repetition illa. They are testing all possible concepts. It may be delayed in our class, but you are getting to revise almost the full chapter. Here the concept is very simple. In the AGM, okay, in AGM, if quorum is not there, meeting will be adjourned. In this case, company has 3,680. Slab la second la vandrum. Second la vandichna 15 will be the quorum limit, but only 12 are present. So quorum is not present. Meeting has to be adjourned. Adjourned meeting you quorum varala. Then the act says in adjourned meeting also if quorum doesn't come, then the members present will be the quorum. The intention of lawmakers உன் கம்பெனியோட கதி அதான். Nobody wants to come. 15 பேரே வர முடியல உன் கம்பெனிக்கு. 3,600 members even 15 can't come. I will allow adjournment once. There also nobody comes, can't do anything. Whoever is present is valid quorum. So in the adjourned meeting also only 10 people came. They were personally present. Then the 10 people will be valid quorum. இதுக்கு மேல adjourn பண்ண முடியாது. Can you give any real life example for this concept? Okay, we will come to the class first. எனக்கு அசிங்கம் அப்போ அந்த எக்ஸாம்பிள் சொன்னேன். பசங்க யாருமே வரல. இந்த மைக்லேயே சொல்.
படின்னு 2 டைம் 3 டைம் சொல்லலாம். மறுபடியும் படிக்கலைன்னா அவன் தான் சீரியஸாக இருக்கும் லைஃப்பில்.
ஓகே, இது ஒரு வேலிட் பாயிண்ட். ஓகே, ஸோ அதான் கான்செப்டும் சொல்கிறோம். ஹென்ஸ் ஸோ பேசிக்லி ஆஸ் பர் ப்ரொவிஷன்ஸ் இன் கேஸ் ஆஃப் ப்ரைவேட் கம்பெனி 2 members. Oh, second. Oh, fine. Trippy again, same mistake, guys. What would be the answer? You are also enjoying this chapter. If PQ Limited is a private company. Private company na quorum enadhu 2 இருந்தா போதும். In that case 12 இருந்தாலே போதும். But private company க்கு எப்படி 3680 இருப்பாங்க members? Question drafting ஏ தப்பு. Okay. So what they are saying, it is not specific. If quorum is not present within half an hour, it's adjourned to next week, all of that. In the instant case, there are only 12 members on that meeting. Therefore, it is not in compliance for required quorum. In the adjourned meeting also, required quorum is not present. But in the adjourned meeting, the members present shall be considered as quorum. Idampa analysis. This is how you write an analysis. Inge they have used technical terms. No. What they are writing, this paragraph is the analysis. First meeting, 12 were there, so it is adjourned. In next meeting also only 10 came. That becomes the quorum. In the adjourned, the required quorum was not present in the adjourned meeting. The members present shall be considered as quorum. How beautifully I inserted the provision within the analysis as per section 103. Therefore, AGM conducted by PQ after adjournment is valid. Second, private company case, in case of private company, 2 members are enough, shall be for quorum. Therefore, in case PQ is a private limited, only 2 members shall be personally present. There was no need for adjournment. But question A தப்பு. November 20 private company எப்படி 3680 இருப்பாங்க? ஓகே, கொரோனா பேட்ச். ஸோ பேப்பர் செட் கொரோனா பேட்ச். ஓகே, 116 பற்றி என்ன எழுதலாம்? What is 116? Resolution passed at an adjourned meeting. Then resolution is valid only for the date on which it is passed. இதுக்கு resolution இருந்தால் இருக்கிற எல்லா ரெசல்யூஷன் எழுதிருவியா? ஓகே, irrelevant point. This is like what I told. எழுதலாம், பட் ஒரு கிரிக்கெட் பிச்சில் ஒரு நாய் வந்தால் எப்படி இருக்கும்? Irrelevant for that ground. I'm not against dogs. In that match, dog is irrelevant. So this provision is not relevant. Okay. Next time அவன் டவுட் மைக் கொடுத்துருவான் அவனுக்கு. Okay. Let online students also hear his mic. Sorry. Ignore, guys. Sometimes on the flow it will happen. Why that happens is, as a faculty, I keep thinking about next question, next என்ன பண்ணலாம். So mind is thinking about what is next, but word is coming from something else. So that mismatch happens. You can laugh, it's fine. Give the points of distinction between OR and SR. மே 19ல கேட்டான், திருப்பிலாம் கேட்கறதுக்கு வாய்ப்பு ரொம்ப கம்மி. ஜஸ்ட் ரீட் த தியரி கைஸ். வாட் இஸ் OR and what is SR? எஸ், we are in 30th question.
Examine the validity of the following statement in respect of AGM as per the provisions of Companies Act 2013. The first AGM of the company shall be held within a period of 6 months from the date of closing of the first financial year.
Quickly, let's close. Is it correct guys? No, it should be held within 9 months. Next.
The registrar may for any special reason extend the time within the first AGM shall be held.
Answer, no, first AGM you can't extend.
Subsequently, second onwards, AGM should be held within 6 months from closing of the financial year.
Yes, within 6 months. Next.
There shall be maximum interval of 15 months between two AGMs.
Correct, maximum should be 15 months. அதுக்கு மேலே போனால் two AGMs are not valid. Nice. இந்த மாதிரி கொஷன்லாம் வந்தால் ஜாலியாக இருக்கும். July 21, 4 marks. Okay. Some motivation. How do you write these kind of questions? அது correct, incorrect and சொல்லி write what is the correct provision. That is difficult. No, not difficult. First அவனை கொடுத்துருக்கான் 6 months. It is incorrect. So it should be held within. Hence statement of shall be held within 6 months is incorrect. Should I write the correct provision? Yes, it should be held within 9 months. For something that is correct, வேற என்ன எழுதணும்? கொடுத்தது கரெக்டாக எழுது. According 96, subsequent AGM onwards, it shall be held within 6 months from close of financial year. அதான் கொஷனில் இருக்கே. Rewrite the question and tell it's correct. அதுக்கு மேலே என்ன பண்ண முடியும்? Okay. Understood guys? So for incorrect statement, please write what is correct. For correct statement, write again saying that is correct. Question 39. Quickly read the first question, I will give the answer. Then second question, answer. Yes.
Mr. L, a shareholder in Harley Limited, a listed company, desires to inspect minutes books of general meetings and to have a copy of some resolutions. In the light of the provisions of Companies Act 2013, answer the following. Whether he can inspect the minutes books and to have copies of the minutes at free of cost?
Answer, he can inspect the minutes books, yes. No need to pay any money. 2 hours like business hours he can inspect. Can he have copies of minutes at free of cost? No, copies na 10 rupees. Here they are trying to say copy na hard copy. Okay. Whether he can authorize his friend to inspect minute books on behalf of him by signing power of attorney. Can member inspect somebody else? Did we discuss something like this? Can you appoint? This is for not books of accounts. So first answer is yes. Second, I have a slight doubt. My answer is no, because Act is silent about this. Only member can inspect, or member can get copy and give friends, but you can't appoint agent. Let me check the answer. Okay. See, as provision does not specify anyone. That means Act is பத்தி பேசல. Now don't ask me, sir, inga class la சொல்லி தரல sir. Act la இல்லையே. I will teach you the Act. That's why I am teaching you logic. So logic is saying what? Whether he can authorize his friend. இது பத்தி Companies Act la பேசவே இல்லை. That means you apply common sense. Member inspection, anywhere they have not given means answer is no. Okay. So first case, Laurel and requirement, he can inspect the minutes and to have soft copies of last 3 years. Soft copy free I can have for last 3 years. If it is hard copy, he has to get within 7 days and he has to pay maximum of. Here copy in கொடுத்திருக்காங்க sir. Hard or soft and சொல்ல, write both. Here, as provision does not specify anything on authorizing anyone else to inspect on minutes book, Laurel cannot inspect, cannot authorize his friend because 119 la adu பத்தி எதுமே பேசல. So common sense answer. Okay, which is more reasonable. We came to 40, I think last 10 questions. Go ahead.
Explain the provisions of e-voting in an AGM in the following cases. A and his wife B has joint demat account in Alpha Investment Limited. In such a case, who will cast the vote in e-voting system?
Both questions are done guys, that's why I am stopping him. First, who will vote? Whosoever name is first. AGM is going to be held on 7 September. What will be e-voting period? 3 days before. 7, 6, 5. 5th September start panni. Sorry, it should start on 4th September. 4, 5, 6th September should end at 5 p.m. This also we saw from above. Question 40 is done. Next. Examine the validity. Yes.
The board of directors of the company refused to convene the extraordinary general meetings of the members on the ground that the requisitioners have not given explanatory statement for the resolution proposed to be passed at the meeting. The board of directors refused to convene the EGM on the ground that requisitioners have not been signed by the joint holder of the shares. Adjournment of EGM called upon the requisition of members on the ground that the quorum was not present in the meeting.
First, section 100 says requisitioners, should they give explanatory statement Is it necessary for them to give explanatory statement, guys? Answer is no. They should just call for meeting. எதுக்கு அவங்க சொல்ல வேணாம். Only board should attach the explanatory statement if available. We would have seen this also. Meetings chapter, which page number, guys? Okay. So if I go to section 100, it will be given, yeah, valid requisition. Requisition shall specify the matter for EGM to be called. Requisition is valid even if the reason for the same is not specified. So explanatory statement kudukalanalo, it is all right. Therefore no. Board of Directors refused to convene EGM on the ground that it is not signed by the joint shareholders both. Any one sign panna podum. So that also we have it. If you see, if it is joint shareholders, any one should sign. It is sufficient. Somewhere we would have given it, guys. The board of directors refused to convene EGM on the ground that the requisitionists have not been signed by the joint holder of the shares. If there are two joint shareholders, A and B, A sign பண்ணிட்டான், B sign பண்ணல. So because B did not sign, they are saying they won't keep EGM. Is it valid, guys? No. If one person signs, it is enough. Are they valid, guys? No. Let's check answer for both of this. First, board of directors cannot refuse to keep EGM just because explanatory statement is not given. Case 1. Case 2. Here the board are correct in refusing to convening EGM on the refusal have not been signed by the joint holder of shares. Okay, what is the question? Clear? Have not been signed by the joint holder of the shares. Let me read the case fully. The notice shall be signed by all the requisitionists or requisitionists duly authorized in writing, or by all requisitionists on behalf or sending an electronic request and scan copy. Hence it is imperative for joint holders also to sign the notice for calling meeting, or by requisitionists duly authorized in writing by joint holder. Therefore, board are correct in refusing to convene the EGM on the ground that requisitions have not been signed by the joint holder. So the assumption that, the point they are taking here is both should sign off. If A and B are there, question is clear. To convene EGM on the ground that requisitionists have not been signed by the joint holder of shares. Okay, it depends on assumption here, guys. Actually in A and B, if any one signs, na, it's enough. Maybe they are taking the meaning that here both have not signed, but is that a valid assumption from our side? Provision booklia. It shall be signed by all the requisition or requisition duly authorized by all other requisitionists. Duly authorized by all other requisitionists. Then going by this, the interpretation is, if there are two joint shareholders, A and B, then both should sign, or A should sign and B at least should authorize the other person to sign. That is the interpretation we will take purely based on this question. I am still not convinced that both should sign. According to common sense, I will tell ortha sign panna podu, but because of the question which came in December 21 MTP, aligning our answer with ICA, sometimes we will take these deviations. So here the word is very clear, by the joint holder. Overall sign panla, that means one person has signed. I can't take the assumption both have not signed, because it's given it has not been signed by the joint holder of shares. So I will assume that one person has signed. That's why answer is saying it's imperative for joint holders requisition also to sign the notice to call the meeting, or authorized by writing by joint holder. Carefully use பண்ணிருக்கான் பாருங்க இங்க joint holders, joint holder, singular plural. So here what they are trying to say is both of them have to sign. As per concept I will not agree, but as per this question we will go with the answer. Are you getting it? Of course it's conflict, but if it comes in exam, go with the answer that we have in the book only, guys. Are you understanding any? Yes. Exactly, that is the conclusion. So conclusion is, if there are two people, A and B, preferably both sign. If one person A has signed, then other person B should at least authorize the signature. Are you guys following? All of you clear with me, guys? Okay. Case 3. Case 3 படிக்கவே இல்லை. Adjournment of EGM called upon by requisition of members on the ground that quorum was not present in the meeting. Can EGM be adjourned? No. Members are calling for EGM. Members are not present. Can I adjourn, guys? Answer is no. So case 3, if quorum is not present for meeting called by requisitionist, it shall stand cancelled and shall not be adjourned. This we already saw. Yes, question 42.
New Pharma Limited issued a notice for holding its AGM on 7th September 2020. The notice was posted to the members on 16th August 2020. Some members of the company argued that company has not complied with the provisions of the Companies Act 2013. With regard to the period of notice and such, the meeting was invalid. Referring to the provisions of the Companies Act 2013, decide whether the meetings has been validly called. If there is shortfall in the notice, state explain how many days does the notice fall short by statute requirements, whether the length of serving of notice curtailed by articles of association.
Simple. அவன் என்ன கேட்குறான், மீட்டிங் இஸ் ஆன் 7th of September, notice is sent on 16th of August. Do I have in between 21 days? I should not count which 2 days, 16th August and 7th September I will not count. So how I will have in September 6 days I have. In August if I don't count 16, 31 minus 16 took, how much I'm getting? 15. So 15 plus 6, 21 days are there. Are you following, guys? Again, for safety I will cross check. Apart from 16th, 1 to 16, August still has 15 days, September 6 exactly 21 days. Is this sufficient? No. For notice by post, you need to have 21 clear days plus 48 hours extra. 23 days இருக்கணும், மிஸ் பண்ணிட்டாங்க. They have not given. I am assuming it's posted na, post னு assume பண்றேன், guys. If answer changes no, don't ask me. Okay. So whether notice has been validly called, first case answer is falls short by 2 days, only 19 clear days. Okay, excluding 48 hours. Okay. So our answer is correct. Only 19 clear days notice is served after excluding. What has he done? On the 48 hours. This is the point. Further, it provides in case of post, there should be at least 48 hours. Oh, அவன் என்ன சொல்றானா, okay, we should not write like 23 days in எழுதக்கூடாது. Example, you should not write 23. You should start counting 21 days only after expiry of 48 hours. That means I posted on 16th August, 17th August, 18th August exclude பண்ணி, you have to count only from 19th August. Are you getting it? How they are presenting? So count starts from 19th August. That's why you don't have 21 days minus 2, you have only 19 days. Are you getting it? So don't write 23 in exam, because law uses 21 days plus 48 notice post. So on the 48 include, remove panna, I have only 19 days. 21 irukanu. Are you following, guys? So is there a shortfall? Yes, by 2 days. Does the notice of shortfall statutory requirements? Yes, by 2 days. Whether the length of serving the notice can be curtailed by articles of association? No. Shorter notice is possible only if 95% of members give consent in writing or electronic mode. I am sure in class I would have told many times, don't do 21 plus 48, 23 use பண்ணாதீங்க சொல்லிருப்பேன் classல. Correct? That same thing is done. I am sure most students will make the mistake over here by saying 23 days needed, 21 இருக்கு, gone. You should start counting 21 days after expiry of 48 hours. This is where we lose marks in presentation, step marks. Next, any doubts in this? Third case பத்தி பேசவே இல்லையே. Delay, okay, leave. 95% you need. Okay. Question 43. Now we are seeing past exam questions. Last 7-8 questions. Go ahead.
ABC Limited is an unlisted company having its registered office at Kolkata. The AGM was held at Goa on 1st July 2021 at 3 p.m. and concluded at 8 p.m. Consent of all the members to conduct AGM at Goa were received by 24th June 2021 by email. Examine the validity of the meetings as per the provision of Companies Act 2013. State the consequences if the resolution has passed in such meeting without sufficient disclosure regarding interest of a director.
We will go to Gen Z notes, section 96, where to conduct AGM. AGM should be at registered office, same city, town or village. However, anywhere else in India, if it is a unanimous resolution, government company anywhere else in India. So here is an unlisted company, registered office in Kolkata, they kept in Goa. எவனாவது வேணான்னு சொல்லுவானா? registered office கொல்கட்டாவை தூக்கி கோவான்னு வச்சா ஓகேன்னு தான் சொல்லணும். For this, examine the validity of meeting. Okay, consent of all members concluded on 8 pm. Consent of all members was received by 24th June. They got by email. There is no time limit. அவங்க எங்கேயுமே டைம் லிமிட் கொடுக்கல. யூ ஷுட் கெட் கன்சென்ட் பிஃபோர் ஸோ மெனி டேஸ். கன்சென்ட் வந்தால் போதும். கன்சென்ட் கொடுக்காம இருப்பானா, கோவாவில் வைக்கணும்னா ரெடியாக கொடுத்துட்டான். ஓகே, எக்ஸாமின் வேலிடிட்டி ஆஃப் மீட்டிங். மீட்டிங் இஸ் வேலிட்லி கால்ட் பிகாஸ் all the members gave consent in unanimous in advance. How many days in advance? முன்னாடி வந்தா போதும். If the consent comes before AGM, it's sufficient. அதுக்கு they have not given any time limit. Okay, are you following, guys? Second question is what? State the consequence if a resolution has passed in this meeting without disclosing sufficient interest. Okay, it concluded at 8 pm. Is it fine? Started at 3 pm, concluded at 8 pm. What is the working hours, sir? When I should start only is important. Start between 9 to 6. Here the meeting started at 3 pm. கோவாவில் இருக்கான், அவன் 11 pm வரைக்கும் மீட்டிங் வைக்கலாம். ஸோ 8 pm கரெக்டாக மீட்டிங் முடிச்சுட்டு டின்னரை சாப்பிட்டு வெளியே போயிடுவோம். கரெக்ட், தட்ஸ் when the life starts in Goa, night life. Okay, next, state the consequence if a resolution has passed in such meeting without sufficient disclosure regarding interest of a director. எனக்கு கொஷினே புரியல. State the consequence if a resolution has passed in such meeting without sufficient disclosure regarding interest of a director. Let me go see the answer. I honestly don't understand the question. Okay, section 102 says where any special, okay, this concept, okay, state resolution has been passed without sufficient disclosure regarding interest of director. Section 102 explanatory statement. Yeah, no, we have not seen this so far. Explanatory statement says in a resolution that you are passing in an AGM or EGM, if any special business, look at this explanatory statement required to annex all of this. If any special business to our company, extent of shareholding in that company, all that will be given if they have 2% or more. We are discussing point 2, nature of concern and interest of directors, manager, KMP and relatives of them. So if any business is happening and in that business if director has any interest, அதை கொடுக்கணும். Meaning, let's say for example, company is doing bonus rights issue. In that rights issue, director is taking some shares, or company is entering into a merger with some other company. Which company? Director or wife or a company. They are doing merger of company also, in which director is having interest. So if director has interest, you have to disclose. So 102 says if resolution is passed without disclosing the interest of director, resolution is not valid. Explanatory statement has to be given. So section 102 says where any special business has been transacted at company's general meeting, then it must specify nature of concern of every director. Effect of non-disclosure, the meeting shall not be valid. Are you following, guys? எப்படி மைன்யூட்டாக கேட்குறான் பாருங்க. 102 ஒரு sub point which says if director has any interest in resolution, we have to disclose that. அது இல்லைன்னு சொல்லி எப்படி மைன்யூட்டாக கேட்குறான். that too exam question, May 2022. Are you following, guys? These are all questions you have to mark as important because just once it came. Okay, very minute. Unless you read every word in the book that was given, you will not be able to answer these. Correct? Sir, என்ன சார் இப்படிலாம் எக்ஸாம்லாம் வருமா? This is the 43rd question. Out of the 45 questions, 43 questions we have seen so far. Like this, how many are there? 1, 2 or 3. Again, we are doing workout and covering all of that. Okay. So case 1, case 2. Are you all fine, guys? Enjoying meetings chapter? Okay. Fine. Sir, சீக்கிரமா முடிங்க sir. 9:30 pm ஆயிடுச்சு sir. Okay. Just to show that recording students our dedication. 9:30 pm we are sitting and recording workout batch, guys. Whatever time you are watching, let me know. Sir, I am watching this at night 2 am. Send me a screenshot, then only I will believe. TST Limited. Sorry. Padipa. Yes.
TSC Limited has equity share capital of 10,000 shares of 10 each. The company has received a requisition from Mr. A and Mr. B, each holding 1,500 equity shares to call an EGM to remove managing director of the company who has been found to be involved in some malpractices. The company failed to call the said meeting. The requisitionist decided to call the meeting by themselves to pass the resolution to remove the managing director. Explain the validity of such resolution passed in the said meeting, referring to the provision of the Companies Act 2013.
Okay, first the company has how many shares? 10,000. In this fellow A and B each has 1,500. That means totally they have. That means percentage 30% vechirukam. You need only 10% to call an EGM. He has sufficient percentage to even stop a special resolution. Avula power vechirukam. Okay. They wanted to call EGM to remove director panna director கூப்பிட சொல்ற meeting. என்ன பண்ணா director has been involved some malpractice. Company failed to call the meeting. Of course director தூக்க சொன்னா வைப்பாங்களா meeting. They didn't keep. Requisitionist அந்த 30% வெச்சவங்கள desires to call the meeting by themselves. We see in EGM provision, EGM should be held within 90 days. First 45 days board should call. If not, next 45 days the requisitionist can conduct the meeting by themselves. We see that in EGM. They kept the meeting by themselves to remove the MD. Is the resolution valid? Yes. Power is given. So no need to go to tribunal. 100 will come only if here also members you vekka vedla sir meeting unable to keep, then you will go reach out to tribunal. Tribunal will call in section 98. Okay, validity of resolution passed then EGM by requisition all the 21 days before 45 days. This is the main point, same point we have in the book. If the board does not call within 21 days, where meeting is not convened by requisitions, have right to receive list. If provided the company within 21 days they have not held, same point will come over here. If board does not within 21 days of receipt of valid requisition regard to any matter proceed to call, then within not later than 45 days meeting may be called and held by the requisitionist themselves. I am not focusing on timelines guys. Basically first 45 days kulla they have to call. Same point we have here, 21 days 45 days. First 21 days kulla if they have not called it within the, then and with the end of next 45 days same thing, and the first 21 days kulla they should proceed to call EGM and meeting should have been held within 45 days. Then EGM can be called by the members itself in the next 45 days. Are you following guys? Understanding? So requisition shall call and hold the EGM in the same manner and such meeting will comply with all provisions of the act. Here they have 30% only prove பண்றான். All the expense will be reimbursed. All the provisions of 100 எழுதி முடிச்சிட்டாங்க. Maybe it's a 6 mark question or 5 mark question, so they wrote all the provisions, all other points are done, 1/10 everything. Section 100 ல இருக்கிற full provisions are written and given analysis. Are you following guys? Next question 45 RTP November 23. Yes.
The paid up share capital of Golden Shoes Limited is 25 lakhs divided into 2,50,000 equity shares of 10 each. Some of the shareholders holding 2,500 equity shares are residents of London from whom a foreign register of shareholders is opened on November 1 to 2022. Advise Golden Shoes Limited within how much time after opening of foreign registers it is required to file within the register of companies a notice of situation in the London office.
Section 88 subsection 4 is foreign register. 88 subsection 4. 88 subsection 4 says that once you open a foreign register, it should be intimated to ROC within 30 days. That's it. In the concept terinja, it's over. You will intimate ROC within 30 days. Are you following guys? That's it. 88 na padikla sir. Adla 88 subsection 4 la 30 days. Adnala da RTP la vandirukku. Fine. Next. Question 46. We are towards the end guys. Mottama 51. Just 5 to 6 more questions. Come on, online students, if you are still watching, don't pause the video now. Finish it with us. Yes.
Prakash and some of his friends are members of Focus Limited, a company with a paid up share capital of 1 crore. They are all intent to propose a resolution at the forthcoming general meetings of the company, which is going to be held in CP, New Delhi. That is the place where registered office Focus Limited is situated. Kindly provide guidelines to Prakash and his friends on the requested minimum paid up share capital they should hold to initiate a members resolution. What are the other requirements that the Prakash and his friends need to keep in the mind for moving a members resolution?
Section 111. Circulation of members resolution. They should have how much percentage? 10%. We saw in our Gen Z notes also, section 111, 1/10 of paid up share capital they should have for circulation of members resolution. Let me go check that. 1/10 of paid up share capital should be there, eligible to make a vote. Are you following this? Other points of this section also you should write. What are the other points? The same time limit, 6 weeks before, 2 weeks before, same thing is coming here, 6 weeks before the meeting. In case of other resolution, deposit 2 weeks before the meeting. Are you following, guys? Gen Z notes is to revise the provisions. Book is for the wordings. That's it. Are you following, guys? Clear? Understanding? Anything difficult here? No, nothing great. If you feel, sir, please explain more. Let me know, guys. We will discuss. Next.
Discuss the provision of the Companies Act 2013 regarding the time limit for holding the AGM of the company. Also state the power of the registrar to grant extension of time for the first AGM. Explain with the help of an example.
சொல்லுப்பா சஞ்சீவ், நீ ஆன்சர் சொல்லு இந்த கொஸ்டினுக்கு. கமான் ஆன்சர் சொல்லு, பசங்க கேட்பாங்க ஆன்லைனில். ஓன் வேர்ஸ்ல சொல்லிக்கோ.
As per 96 of the company section 96 of the Companies Act வந்து every company incorporate ஆனதுக்கு அப்புறம் 9 monthsல வந்து first AGM conduct பண்ணனும் சார். No extension will be granted by the registrar. Already நிறைய பார்த்தாச்சு, repetition.
Correct. So only one small correction, this 9 months from end of financial year. So first year 9 months, time limit for holding first AGM, state the power of ours, explain with give example. நீயே ஒரு எக்ஸாம்பிளை கிரியேட் பண்ணு. என்ன மாதிரி எக்ஸாம்பிள்? மேரேஜ் இன்வைட் அந்த மாதிரி கிடையாது. You just write some company XYZ started on this day. This is the end of the year. So 9 months. So they are giving some example. Incorporate 1st April 21. இதுல வந்து don't play over here. Incorporate on 1st Jan. நான் calendar year follow பண்றேன். வேணாம். Don't take risk. You know how to give examples. Fairly simple. Okay. Next.
Explain the following as per the provisions of Companies Act 2013. Abridged form of annual return, signing of annual return.
This also we saw in the class, but unfortunately this one concept alone in concept batch recording நம்ம class எடுத்தோம், that didn't get recorded that day. 1 hour didn't get recorded. but அன்னைக்கு தான் neighbor death ன்னு சொல்லி class got cancelled. நல்ல வேளை அந்த 1 hourலயே recording stop ஆயிடுச்சு. டெத்துக்கு நல்ல வேலைன்னு சொல்ல recording stop பண்ணதுக்கு சொல்கிறேன் guys. but actually that day it was not death, it was a fake death, but we all went home that day only. Okay, for concept students you will understand this when you are seeing the videos. For workout batch students, provision abridged form of annual return and signing of annual return. Who will sign annual return? We will see in section 92. It has to be signed by director and CS. Company does not have CS, no, then CS in practice. OPC and small company, when there is CS, if there is no CS, then by the director. Abridged form also I would have given in the book. கீழே கொடுத்திருப்பேன். Abridged form of annual return is applicable for small company and OPC. It has to be filed in form MJT 7A. That's it. Okay. MTP same thing. MGT 7A for 1% company and small company. Who has to sign? Same provisions what we discussed. I'll again revise. Signed by director of the company and company secretary. In case there is no CS. CS in practice. In the section 92 தான் CS க்கு காசு. இதான் இன்கம், மெயின் சோர்ஸ் ஆஃப் இன்கம். எவ்ரி இயர் கம்பெனியில் இருக்கிற இன்ஹவுஸ் சிஎஸ் வில் சைன், இஃப் நாட் சிஎஸ் இன் ப்ராக்டிஸ். 1% கம்பெனிக்கும் ஸ்மால் கம்பெனிக்கும் ப்ரைவேட் கம்பெனிக்கும் இஃப் இட்ஸ் ஸ்டார்ட் அப் ஷல் பி சைன்ட் பை த கம்பெனி செக்ரட்டரி. நோ சிஎஸ்னா டைரக்டர் ஆஃப் த கம்பெனி வில் சைன் இட். சம் எக்ஸம்ஷன். ஆர் யூ ஃபாலோயிங் கைஸ்? இதுதான் அவனோட பிரெட் அண்ட் பட்டர் ஃபார் சிஎஸ். நெக்ஸ்ட் 49. லெட் மீ ரீட் ஸ்மால் கொஷின். Enumerate the provisions in respect of following matters not to be included in the minutes as per opinion of chairman. Yes, reasonable, defamatory, immaterial, detrimental provisions I will not include. Maximum time limit following entering into minutes 30 days of conclusion of meeting. Correct? Within 30 days. Example time limit தெரியலனா 30 போட்டுக்கோ, லக் இருந்தா வரும். Okay, fine. Max 30 days you will file in minutes. 50th question finally. Let Sanjeev do the honors. Yes.
Sunshine Limited, an unlisted company registered in the state of UP with 40 shareholders, want to organize the AGM of the company for the financial year 22-23 as under. The meeting shall be held on 28th September 2023, which happens to be Raksha Bandhan, a day declared as a holiday in UP government. The venue for the meeting shall be in Lonavala, a hill resort in Maharashtra. Out of 40 shareholders, 38 have given their consent in writing for conducting the meetings in Lonavala. Advice. நான் சொல்றேன் advice. Okay. Now first
Can I keep on Raksha Bandhan? Yes. National holiday மட்டும் வைக்க முடியாது. 3 days we already discussed. Raksha Bandhanla என்ன வேணா பண்ணிக்கோ. AGM தானே. All of you come together and attend. Okay. So answer is, can we keep on Raksha Bandhan? Yes. Second, venue for meeting shall be Lonavala. அப்போ கோவா, இப்போ லோனாவலா. சார் லோனாவலா என்னன்னு தெரியாது சார். இது ஒரு பூனேல ஹில் ஸ்டேஷன். லைக் how we are Ooty, Kodaikanal in south, near Pune hill station is Lonavala. Okay, fine. Unlisted company with unlisted company, they want to keep somewhere else. What you should get? What solution? Unanimous resolution. 40 shareholders only 38 gave their consent. Not possible. அவன் என்ன பண்ணிருக்கணும்? லோனாவலா பதிலா கோவான்னு வச்சிருந்தானா 40 out of 40 will give unanimous resolution. Lonavala, 2 people said no, you change. Okay, இதெல்லாம் எக்ஸாம்ல எழுதாதீங்க guys. Unanimous resolution 40 out of 40. Sir, Goa, really that hype is there, sir? Will you actually enjoy when you go there? At least for the hype that is there, you have to go someday. I've been 4 times. As a bachelor, after marriage also I've gone, guys. So, someday in your life, you will get the opportunity. Don't worry. When you get the opportunity, you have to go. Okay, which was more fun, not in recording class, guys. Okay, fine. So definitely, when I went for the first time, that hype was there. Finally, went on to Goa. Okay. Now all that fun, all of that hype was there. So that was definitely there. One day, you also will go. When you go, send photo to me. Don't worry, guys. Na story lam poda maata. Okay. Which was more fun? Na unakke theriyum answer. Bachelor fun ah irukumo, after marriage fun ah irukumo, unakke theriyum. Therinje kekran par. Okay. Oh, 50 the last. I thought 51 was there. 50, that's it. Super, we are done, guys. Clap, mic like the clap now. Okay, fine. So let me just summarize this over here. You can keep on this day because it is not a national holiday. Second, unanimous resolution da venu. Hill Maharashtra, because consent for this has been given by all the members. With this, we conclude meetings chapter. Now you will clap, guys. Yeah. Take guys, recording. We have closed at almost 9:40. Fine. இதை வச்சுட்டு சார் வந்து மீட்டிங் சாப்டரில் 2 ஹவர்ஸில் எங்களை கோவா போக சொன்னாருன்னு வீட்டில் கேட்காதீங்க. நீயே படிச்சுட்டு பாஸ் பண்ணி உன் காசில் போ. ஐ வெண்ட் ஆஃப்டர் கிளியரிங் சிஏ அப்படின்னு சொல்ல மாட்டேன். மை சிஏ ஃபைனல் எக்ஸாம் வாஸ் இன் May 2016. December 2015 தான் ஃபஸ்ட் டைம் போனேன். எக்ஸாமை ஸ்கிப் பண்ணிட்டேன் ஏன்னா படிக்கலன்னு சொல்லி. ஓகே, May 2016 ஃபஸ்ட் அட்டெம்ப்ட். திஸ் வாஸ் மை எலிஜிபிள் ஃபஸ்ட் அட்டெம்ப்ட். தட் அட்டெம்ப்ட் வாட் ஐ தாட், நான் என்ன நினச்சேன்னா December 2015 கோவா போயிட்டு நியூ இயர்லாம் கோவாவில் முடிச்சுட்டு ஐ வில் கம் பேக் டு சென்னை ஃப்ரம் 1st Jan 2016 பயங்கரமாக படிச்சுட்டு மே எழுதலாம் 4 months அந்த மோட்டிவேஷனில் தான் போனேன். சரி, ஒரு வில் ஜஸ்ட் கோ ரிலாக்ஸ், கம் பேக் அண்ட் டூ ஸ்டடிங். பட் why I skipped was different reason. I got an injury and all, so I skipped the exam. ஸ்மால் இன்ஜுரி தான், எழுதியிருக்கலாம் எக்ஸாம். பட் அதை சாக்கா வச்சுட்டு எக்ஸாமை ஸ்கிப் பண்ணிட்டேன் பயத்தில். தென் ஐ வெண்ட் அண்ட் ரோட் November 16 ஃபஸ்ட்டு. ஸோ ஐ வெண்ட் பிஃபோர் clearing it because my parents allowed, guys. Don't tell sir went, I will also go, guys. Don't put the blame on me. That's about it. We are done with this. Yeah, thank you. Any doubts, guys? Meeting chapter fine. Yeah, bye bye.